Yes, my lord, I am mentioning matter. It is appearing as item number 1790 in my lord's list. My lord, I am praying for extension of interim order. Your lordship's order will expire on 29th of August.
All right.
But,
If
my lord,
29th of August?
but my lord, I am leaving. I am going.
Yes.
I'm
But then somebody will be there.
my lord, my
Junior will be there.
yes, my lord, yes, but because I am going.
All right, you give. Let's see. And notice should be served upon the other side.
With notice, my lord, I am mentioning.
All right, all right.
You see, number is
Yes.
My lord, item number, my lord, 442. That is item number from my lord to monthly list, my lord. And my lord, my submission is that, my lord, matter to be released because it is group 6 matter, my lord.
442 list কোথায়? Yes, 442 released. কেউ আছে? Give your name.
Obliged, my lord.
May I seek your lordship's kind leave to move this matter urgently, my lord. These petitioners are primary school teachers, my lord. My lord, they have been assigned as booth level officers by the Chief Electoral Officer of West Bengal, my lord, violating the rules of Election Commission of India and also the judgment passed by the Honorable Supreme Court in St. Mary versus.
Where will the election be held?
My election will be held on 26.
Where? Which?
Throughout the state, my lord. Throughout the state, the Vidhan Sabha election, my lord, they have been assigned as booth level officer to
All right.
to do the groundwork, my lord, violating the people-teacher ratio and everything, my lord.
But then where is the urgency?
The urgency, my lord, we have been show-caused since, my lord, we refused to accept the letter because there was no specific time frame mentioned, my lord. The Supreme Court says the teacher should be appointed only on holidays, my lord. But in the appointment letter, there is no such and the list of work we should perform, my lord, they are so elaborate, my lord, we cannot perform only on holidays, my lord. That is the reason we have refused to accept, and they are now they are, my lord, show-causing us, and departmental proceeding should be initiated. That's a communication.
What is the item number?
No, my lord, I am seeking leave to move this matter urgently.
Leave to move. All right, leave. Monday.
Lordship,
It will appear in the list next Monday. Serve notice.
I'm deeply obliged. Deeply obliged.
For inclusion? No. No inclusions and no upgradation mentioning today. Yes, come next week. Contempt application. Yes.
Lordship, may I be permitted to mention two issues regarding inclusion in the list, your lordship?
Two issues.
Two matters, your lordship. I apologize, your
For
lordship.
inclusion, no inclusion and no upgradation mentioning will be permitted today. Please do not give. Yes.
Extreme circumstances, I am mentioning this matter of item number 167.
Of which list?
Of appellate side list.
Daily or? Yes.
Today's list. Municipal authority is trying to illegally encroach upon my land. And
Go before the municipality bench. Why are you here?
legally, it is residuary matter, my lord.
How can it be residuary? Municipality?
The other authorities are also involved. Actually,
Maybe.
I am a decree holder I took land from irrigation department. Then I am a decree holder, and I am with the construction. I am residing there. Everything is title is clear. They are absolutely illegally trying to.
Yes, so it's a very good ground to go before the municipal bench. Item number?
167.
167. Soumitra Parui.
Yes, Lord.
Very well released. Diamond Harbour Municipality. Absolutely municipality. 167 municipality matter released.
I am praying leave, my lord,
be permitted
to
to
move on.
mention.
1 minute, yes.
Praying leave to move on matter, my lord, delays to, my lord, tender, my lord. What has happened in this case, my lord? My lord, we are supplying, my lord, security personnel and cleaning staff in different, my lord, government hospital and the district of, my lord, Hooghly, my lord. My lord, we are in extension period, my lord. My lord, between this time, my lord, in our extension period, my lord, one tender has been floated, my lord. We have also participated in the tender process, my lord. In technical bid, we passed. Thereafter, my lord, the financial bid, my lord, on 24th, my lord, financial bid, we have been placed in the L2 and L4, my lord.
Yes.
Although we have, my lord, the criteria, all criteria we have been fulfilled, my lord.
Maybe somebody else is better than you. You
No, my
cannot
lord,
be the best all the
there are
time.
documents, my lord, to show before your lordship. Kindly takes up any day before your lordship. By 31st, my lord, another work order will be issued, my lord.
31st, Thursday.
Grateful, your lordship.
Sir,
Some notice.
My lord, I shall sub notice.
28.
It is my current account in the IndusInd Bank.
328 of combined list.
On my list.
Yes.
It's my current account in.
Why are you mentioning for upgradation?
Yes, my lord.
Come next Monday, please.
Your lordship may permitted to
1
tell-
minute. Are you aware as to how the mentionings are being made? What is the priority? What is to be done? Are you aware?
Yes, ma'am.
Possibly no. Or yes. Or what? Are you aware? It is the seniority that is being maintained, right? When there is a lot of crowd, it is very difficult to maintain that. But since there isn't crowd today, so I'll try to maintain the seniority. So have patience. Yes, Mr. De?
My lord, I was seeking your lordship's Indian list. Today is 28th. Next Monday, my lord, monthly list will be published. I was
Yes.
mentioning a contempt new. Could it be included in the monthly list?
No,
Then, my
I'm not taking it. I'll take it up on next Tuesday. Yes.
subject to the leave of the court.
Hmm.
But I come back on
In the
Monday
contempt
Tuesday to
proceed-
mention.
Monday.
Monday to mention.
Yes.
In the contempt proceeding, my lord has issued the rule. Thereafter, the contemner appeared and cost has been imposed and direction has been made upon the video to appear before this court. In the meantime, video issued a notice upon the parties. They will take up the hearing. My submission before this honorable court, while the application has been disposed of by this honorable court, and thereafter the contempt proceeding is going on, in that event they ask for the hearing. This is the subject matter urgency of the matter.
Absolutely no urgency.
Mil-
Yes.
and the hearing
No,
is
sir. I am not accepting your prayer.
taking place on today.
It will take place
While it has been decided.
for purpose of consideration of the contempt. The hearing is required. Please don't mention. I am not accepting your prayer. Yes. I am not listening. Yes.
Lordship, my interim order is due to expire on the 31st. However, your lordship, the petitioners want to withdraw this writ. Lordship keeps it any day before 31st, lordship.
Give the number and serve notice upon the other side.
Already served, your lordship.
Lordship, under compelling circumstances, I am mentioning this application, Lordship. I have filed this writ petition challenging the order passed under subsection 1 of section 10 of the Highways Act, Lordship. This writ application is pending.
Hmm.
And yesterday, Lordship, the order under subsection 3 of the Highways Act, Lordship, has been passed and they have started preparation to encroach us from the land, Lordship. We are not.
10-3 stage is over now. 10-4 will come. 10-4 apply. What is to be done?
Lordship, but
Nothing doing. Yes.
My lord's chief mentioned insurance matter. The insurance company had quantified. They had only taken time for instructions, my lord, for obtaining instructions. The matter is due to appear tomorrow. But
All
my
right.
lord, it's appearing in the monthly list. I'm mentioning upon notice, my lord.
It is due to appear tomorrow and appearing in the monthly list. What does this mean?
My lord, it's already appearing in the monthly list as item number 1295. But my lord,
All right.
please to direct the matter to be
Give the number.
grateful, my lord.
Hmm.
And a compelling circumstance, I am mentioning one matter, my lord, I don't know, 124 of today's list, my lord. What happened in this matter, my lord? The notice was issued for vacating the land.
Hmm.
Jurisdictional question, I have filed the writ application.
Under which provision vacating?
Under, my lord, the Highways Authorities Act, my lord, they want to, my lord, vacate from the private land, my lord. It's a private land. On jurisdictional question, my lord, I have challenged this before this honorable court, my lord. The notice has been issued, my lord, within 7 days, my lord, this should be vacated, my lord. Kindly hear the matter, my lord.
Private land, highway authority coming and getting it evicted.
It's a private.
And who
Land, my lord.
who has decided it is private land?
It's a private land. Over the
The
private.
record of rights is also there in your name.
And also, my lord, DM also affirmed that, my lord, that it's a public property, my lord, but
Public property.
they said so. Over the private land, my lord, why I'm sitting there, my lord, I'm leaving.
Which is your item?
I don't know, 124, my lord.
124. Thursday it will appear. Give notice to the other side. Urgent motion. Yes. Payment of dues.
Friday, my lord.
Yes, Friday. Give how many? One.
One.
Serve notice upon the other side.
Lord, Food Corporation of India has withheld more than 8 crore. Lord, I have made a representation. Lord, that is not being considered.
Give the number.
Lord,
Friday it will appear.
638 in the monthly list.
638. Payment of dues.
Lord, I have served notice. I'll again serve notice. So grateful.
Yes. Yes.
Lord, I just indicate, Lord, they are withholding this as penalty. Lord, I must indicate that. But my lord, I say this is paid.
All right, let's see.
Great.
Yes.
Mentioning upon notice extremely urgent, my lord. There's a lookout circular without any notice, my lord, no intimation given. My lord, the gentleman is an elderly gentleman, wants to see his granddaughter. They'll be shifting, my lord. It's item
Shifting
50.
means he is going to go away from here.
My lord, he will be here, my lord. The granddaughter, my lord, they are shifting from
Yes.
America to, my lord, Canada, and he won't get a visa immediately. But he will not be able to see his granddaughter.
No, I do not understand. If the person can go to Canada, he can go to US
No,
also.
my lord, US, my lord, the visa is not, my lord, available before 2 years. If he applies now, my lord, he'll not get before 2 years. The difficulty is, my lord, today, this lookout circular is absolutely on the face of it, my lord, it's illegal. I have judgments, my lord, which covers the case. It's item 505 in
No,
the
but then
monthly list.
going outside is not a very good ground.
No, my lord, it's only, my lord,
Now the video conferencing facility and
the only
everything is
reason,
there.
my lord,
No, sorry.
he's suffering from, my lord, various ailments. I'm only praying for this, my lord. Let the matter be heard once, my lord. I'll try and indicate
I'll hear, but then please wait. Yes.
My lord, item number
Deeply
108
obliged,
under extreme urgency. I'm
Item
108.
of
Today's case, ma'am.
yes.
Under extreme urgency, I'm mentioning the matter. The petitioner took a property on lease for 10 years. The lease is going to expire on this 1st August. During the lease period, he planted some trees over there, and as per the lease agreement, there was a clause that during my tenure, I can cut those trees. I have asked for permission from the authority. The authority, with the connivance with the lessee, is asking me to get the permission from asking me to get a no objection. On first, it will expire. Obviously, he will not give me no objection. I am suffering huge loss, my lord. The order passed by the
But then how can you cut trees?
but standing timber. So standing timber with the permission I can cut.
Yeah, who has given you the permission to cut it?
But from the forest department, I need to take the permission.
Yes.
They applied, my lord.
Yes.
And forest department said, okay, I will give permission, but take no objection from the landowner. But my agreement is covered, my lord.
If that is the law, if you want to
I shall satisfy your lordship.
no,
I
if
can-
you want to rely upon the private agreement, then you go before the civil
not
court.
private agreement, my lord, but the authority is saying something, my lord.
You have to go before the civil court, otherwise.
Authority, forest department is interpreting the agreement in other manner, and with connivance with the landowner is not granting the permission.
Yes. You come on Monday, upgradation.
On 1st August, it will expire, my lord. After that,
you want permission, you'll immediately cut the trees.
but standing timber, my lord, that was planted
So what?
for that purpose only.
All right, 31st it will appear. Give notice.
Upon notice, I am
Yes. Yes.
Lordship, Mr. Austin Jana is appointed by WBSLSA. So this is a victim compensation matter. Lordship, this victim on dated 6th May 2025, the DLSA has given 1.5 lakh rupees to the victim. So the repetition has become infructuous.
Which item?
Lordship, 875. So I'm
875 to be mentioned tomorrow. Come with the document to show that the writ petition has become infructuous. Let the client give a communication to you, whatever.
Lordship, Mr. Austin Jana may not be appear tomorrow.
Then when do you want?
After Wednesday, Thursday.
When? Thursday? Friday?
Yes.
When?
Friday, Thursday.
Thursday? Thursday, the other one. Yes, madam?
Yes,
Great
Your
figures.
Lordship, mention please that the date of auction or fixed on 31st July.
Yes.
So and we have gone to the DRT and no interim relief we haven't rented.
Yes.
So we are urgently wanted.
If DRT is not giving you order, go to DRAT. All right, and obtain order from there.
The auction date is fixed in 31st July.
Yes. So what can be done? You go approach DRAT immediately. Yes, sir.
Lordship, mention for the restoration application.
No mentioning for inclusion and upgradations.
Lordship, extremely urgent matter, your lordship. 10-3 order has been passed for demolition. Demolition
To
due on
10-4.
30th of
10-4. Avail 10-4. Yes, sir.
May I seek your leadership's kind leave to mention this matter? It's under extremely compelling circumstances. My property has been taken over by the authorized officer of the respondent bank. The issue is that the
Under the SAFESI
Act, however,
have you approached DRT?
we have not, your lordship.
Go.
I stand corrected, your lordship. We have approached the DRT. I stand corrected over here.
DRT, then DRAT,
Your
then
lordship, not DRT.
civil
Your
division.
lordship, because no, not DRAT or DRT. Your lordship, we've approached the DRT, your lordship. An order has been passed, your lordship. However, the strategy in that case was not not right, Your Lordship. The best course of action would have been to approach this writ court. I can showcase from the impugned order or the Section 14 order that there's an abject violation of my fundamental right. Your Lordship, my personal valuables of the women in question in my family, that has been taken over.
Yes.
It's item number 94 of today's cause list, Your Lordship.
But then,
Your Lordship, Mr. Shuddha Banerjee is leading me in this matter.
but is leading you.
Your Lordship, I'll tell
The
you why.
facts of the matter does not appeal to
Your
the
Lordship, I realize why. Because, Your Lordship, given the facts of the matter as has fallen from your ladies,
Come
Your Lordship, it's
prepared.
other. No, Your Lordship, I'm
Get
prepared.
prepared.
I'm prepared in the matter.
Yes,
Your
then
Lordship. Your Lordship,
I am not very convinced with the submission for upgradation.
Your Lordship, the personal valuables are at stake.
Tomorrow.
Otherwise,
Lordship, one indulgence, Your Lordship, this matter has already been filed. It's running in the monthly list, Lordship. 792 of the monthly list, Lordship.
Yes. what
Demolition
happened?
order has been passed, and 10th order has already passed, due on 30th of July, Your Lordship. This matter would get infructuous otherwise, Your Lordship. Kindly take up this matter at your earliest convenience, Your Lordship.
30th of July. Give the item number.
Yes.
And serve notice upon your other side. Urgent motion. Yes.
May I permit to mention one matter, Your Lordship? The matter
For what?
for my Lordship, urgent motion, Your Lordship.
Where is the matter?
Matter is in monthly list, Your Lordship.
Come next Monday. Call the list, please.
I am for the program and I am for short parts of the minor. The exception is being affirmed in this affirmation section, my lord.
Let me see once.
I apologize for the accommodation for the short pass over, my lord.
1 minute. Authorized construction, unauthorized construction remains. File exception to the affidavit and accept photographs to show existence.
But,
You have photographs?
I have photographs, my lord. I will show your lordship that there is still the unauthorized construction, my lord. I try to satisfy your lordship.
All right.
A short passover, my lord.
No, Passover will not do because you need to serve copy.
I have the copy, my lord.
Then he need to take instruction also. Please come.
As your lordship.
Were you submitting something?
No, I was submitting that we had filed our affidavit of
No, that is already
yes,
here.
yes, yes.
This is
Achha. Leave granted to the petitioner to file affidavit in reply in the department in course of the day. Stop. Copy of the same has been handed over to the learned advocate representing the alleged contemner. Stop. The learned advocate for the contemner shall come ready with necessary instruction. Released. 5th.
Grateful.
But only thing, there is no direction upon the police. The police authority has made a contemner in this matter.
May I file the correct?
If your lordship see once, my lord.
Corrected.
Corrected copy of the application, my lord. I have changed the cost item as your lordship directed on the last occasion, my lord.
Because the
In
name,
the contempt you have made the necessary changes.
No, my lord. I have.
একটু দেখে নিন তো তুহিন বাবু কি আছে।
no, my lord, I'm telling you, the name of the contemners, my lord, are totally wrong.
No, this is
নতুন petition. No. Yes, call to.
My lord, I appear on behalf of the petitioner. I appear for the respondent number 1 and 4. Lord, may I file my affidavit in opposition to the writ petition?
Copy served? Was there
It was served. They have, yes, my lord, they have given the
application?
My lord, in the writ petition.
In the writ petition, what is the application for?
But the immediate concern in the GA1, my lord, the release of cargo, which they have not delivered to us. And they have stopped delivering the cargo since April 2023, my lord. That is the immediate concern. That's why the GA1 has. My lord, may I tell you, lordship, the brief facts behind the entire case, my lord. My lord, the thing is this: there is a warehousing contract, my lord, and thereafter another contract that is a container contract basis a contract. My lord, we have been allotted a big space in the warehouse, my lord, where we kept our cargo, my lord. My lord, the thing is this: the moment we have raised a problem, we have raised our dispute with regard to the unfair process and the abuse of power, my lord, they become very agile to make a measurement and come to a conclusion, forming a committee by which my lord,
You were directed to remain present at the time of inspection. Why did you refrain from remaining present?
my lord, we have communicated them, my lord, on that day we have some problem. Kindly adjourn the things or refix another date. My lord, they didn't. They were very much agile to make the measurement in absence, in our absence, and issued a
And what are the goods?
bill. My lord,
What are the goods in the cargo?
my lord, the goods tarpaulin, my lord, the industrial tarpaulin.
All right. So it's not that it will perish or
kept-
something
but
of that
it is
sort.
kept pending. It is kept lying over there since 2016, and gradually the delivery was taken place, my lord. Suddenly, things has been stopped on and from April 2023, and there is a thread. Unless you pay the excess bill, whatever bill has been raised, we are going to stop your delivery, and that delivery was stopped. Well, then we tried to negotiate, deliberate, nothing. And we came to know that a committee has been formed to solve our problem. It is a problem of abuse of power and the gross denial of process, unfair process, my lord. They're demanding unlawful gratitude and everything. We didn't agree to that. Now the thing is this: the committee has been formed pursuant to our complaint, and the committee come into conclusion without hearing us. Then the moment we came to know that the committee has been formed and they passed an order and they passed a recommendation to the billing authority, then we filed an RTI application. And my lord, what reply?
What is the writ code to do over here?
My lord, it is not a breach of contract. Not only, it's a public element of law is involved.
What is the
abuse of power, arbitrary retrospective billing?
No,
Arbitrary retrospective billing, and not only that, in the violation of natural justice. The committee has been formed pursuant to our complaint, and such committee has come into conclusions that yes.
Where is the report of the committee?
My lord, there no report has been given, my lord. If you lordship,
then how do you get to know that the committee has come to
kindly,
conclusion?
on the basis of the RTI report, my lord, kindly consider the page 187, the second volume of the read. How they have replied my. Yes. 187. Well, if you like to kindly consider, this is the reply they have given at page 187. Well, the question number 1 is details of all members of the committee. The details of the committee cannot be made public to protect the interest of the committee members. And next question, Malad, the date of formation of the committee along with its objective. Committee was formed on 4th January 2023. Malad, the complaint made on December 2022. Objective was regarding investigation of the complaints raised by the Tirumala spinners. But pursuant to our complaint, the committee has been formed and they come into conclusion. And third question is the final report of the investigation for which the company was formed. The final report of the investigation is for internal consumption and cannot be made public.
And all the issues that you have raised, is it there before the committee?
Yes.
All the issues.
The next question, Mala, kindly see next question. The copy of the official decision, suggestions, order of the committee basis which invoices bearing invoice numbers, and these are the illegal alleged bill.
All right.
And the official decision, suggestion, order is internal consumer.
All right, let me hear once. Is the committee only looking after the issues raised by the petition?
In the affidavit in opposition, we have clarified, the committee was constituted for the purpose of looking into the internal business of the company. And this has nothing.
Internal business of the company, nothing to do with the resolution
Nothing to do with the respondent. That is what my lord will see paragraph 7 of my affidavit in opposition.
All right, tell me one more thing. Is there a contract between the two of you?
Yes, what has happened, Milord?
Do not say anything. Yes. Is there a contract? Contract is still subsisting.
Milord, it is Milord paying, but he is not paying since Milord the date of filing of the writ petition. Not even a single.
All right. And in the contract, what is the dispute resolution mechanism?
Milord, there is no arbitration clause. Milord, they will have to file a civil suit in that.
All right. Yes.
My lord,
I am not going to entertain your petition. Your writ
Kindly
petition
consider-
also will not
Malad,
be
kindly
entertained.
Consider the once, my lord, the situation. Malad, the moment, if your lordship kindly consider the complaint once, Malad, at page 32 of my writ petition, volume 1. Malad, kindly consider.
Yes.
It is not a simplicity or a breach of contract. The abuse of power and the violation of natural of justice. Malad, the committee found pursuant to my complaint, Malad, and such committee.
This explanation of the respondent is very clear. The
My lord-
committee was not formed to resolve the dispute.
No, that's my specific submissions.
It
before
is
you.
the authority who knows the reason for formation of the committee. You will force the committee to go into a
Malad, kindly
conclusion or
consider
what?
the person who affirmed the affidavit, against whom we have alleged everything, against whom the illegal gratitude complaint was made.
Very
Malad, the
well.
paragraph 7 of the
And you
affidavit.
still want to go to that person?
Lordship.
The person wants to take illegal gratitude from you and you want to go to that person.
No.
Then?
My humble submissions before your lordships today, my lord. Malad, kindly direct the chairman. A measurement be taken under his supervision. And whatever measurement is coming in our presence, of course, and we shall pay the money and release the goods.
Let me see the writ petition once. প্রথম volume-টা দেখি। Did you raise a objection? An objection is pending before the authority, highlighting all your issues.
My lord, the objection raised at page 32, volume 1. This is the objection, my lord.
Where is the, what are the grounds?
The grounds, first grounds, is the service irregularity.
Where is it? Where is it?
My lord, it is from the day Mr. Seth joined, my lord, first paragraph, second paragraph.
Listen, when you prepare an objection, you do not give all these things from where day he joined, this has happened, this has happened. These are the problems you are facing. I need an answer to it.
My lord.
This is exactly what is to be done.
My lord, the objections and the problem in the form of corruptions.
Where is it?
My lord, here, then after, my lord, this, first, my lord, the officer was PK Sahu. Then the two officers has scam. One is Prashant Basu, another is P Srivastava. They started trying to do something which is.
See, you mentioned thereafter I complained to such and such for the corruption. What exactly is the corruption? Only
the next page, my lord, if you lordship.
Yes.
Mr. Abrojit and Mr. Srivastava are very much interested to keep chemicals which are harmful of the health because they are payment from the concerned party for keeping these chemicals in the yards, as the fixed pays are allotted for us, 5,000 something.
Do you think this objection is suffice to take into consideration whatever issues that you have?
My lord, pursuant to this complaint, my lord, they have formed the committee. That is.
Try to answer the question. Are you okay with the objection?
This is the objection.
Are you okay with it?
Yes, my lord.
Please consider and dispose it off.
May I just indicate one thing, my lord? What my learned friend is today saying, what has happened, my lord? 5,000.
No, I do not want to know what has happened. You give a reply to it and finish it off.
My lord, what he is complaining, my lord, I am a warehouse. I shall keep all kind of materials, my lord. He is complaining I cannot keep, my lord, the chemical.
Very well. Let him know that it is not possible. Finish it off. Please come.
Only, my lord, this part of, my lord.
This is the only objection that he has.
At page 33.
Page 32 and 33. 32 and 33.
And the subsequent measurement, my lord, subsequent measurement.
I do not know. If measurement is written over here, it is all right.
Not in here, my lord. In the subsequent mail, my lord, they have on 30.
This is the reason the court wanted to know, is this the proper objection?
This is the initiative, my lord. The objections has been started from here and the measurement has taken place.
If you want to give a comprehensive objection, the court can give you leave.
Comprehensive objection to them, my lord.
Obviously, to who else?
Lordship, I shall do that because there is several email has been written, my lord.
You prepare one comprehensive with all your objections, file it to them, they'll consider.
And my lord, only one thing, my lord, there is a due of 43 lakhs as on.
Take steps. The court is not interfering.
that my lord will kindly my lord grant.
The petitioner has a contract with the respondent number 1. Stop. The petitioner intends to highlight certain issues which, according to the petitioner, are illegal, and the petitioner wants a resolution of the disputes that have cropped up between the petitioner and the respondent number 1. Stop. Learned advocate for the petitioner submits that there are series of objections which are pending consideration before the authority. Paragraph. Without entering into the merits of the objections raised by the petitioner, at this stage, the petitioner is granted liberty to file a comprehensive objection highlighting all the issues. Stop. The authorized officer of the respondent number 1.
My lord, the chairman, my lord, below the
The chairman and managing director. All right.
My lord, may I just indicate, my lord, the chairman has been named in person, my lord, and he is no more there in the organization.
Anyway, I am not mentioning any name.
He's not there.
The chairman and managing director of the respondent number 1, competent authority বলেছিলাম ওই জায়গায় chairman and managing director shall consider the objection to be filed by the petitioner in accordance with law/guidelines/regulations and afford an opportunity of hearing to the petitioner. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 4 weeks from the date of receipt of the objection. Receipt and submission of the objection before the respondent number 1. It petition disposed.
My lord, will kindly be pleased to, my lord, write one line, my lord, that I shall not be precluded from recovery money of dues. He is not paying, my lord, since.
একটা জিনিস, as you are filing your opposition?
Yes, my lord, I have filed.
The affidavit in opposition and the reply filed in court today are taken on record. Stop. It is made clear that the court has not entered into the merits of the allegations, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the objection to be filed by the petitioner. Disposed. Writ and the GA.
This application is taken out in a pending writ petition because of a clear attempt to overreach the orders passed by your lordship. If your lordship will kindly have a look first at my lord page annexure P1. So page কত এটা? Page 30. This is a communication made by the MSME authorities. My lord will kindly allow me to place this. This is written by the General Manager, District Industry Center of Paschim Bardhaman to the Directorate of MSME, New Secretariat. Apropos the above noted subject and reference, I would like to inform you that an inspection has been conducted at Jagdamba Industries Limited, located at such and such. The general observation of inspection has been noted below. Unit has been identified by local people. There was no signage on the unit premises. Locals reported that the unit has been closed for some years. All machinery have been dismantled. No employee or worker was available in the unit premises. Now, this was the report with which we approached your lordship with a writ petition, because the concern was as to whether the unit is MSME. Because if it is MSME, then even related parties can participate in submitting a resolution plan. If it is not MSME, they cannot. So it becomes very important because it's a matter of disqualification. Now, your lordship heard this matter and thereafter passed an order, which is at the next page, 4th April 2025, 31.
Yes.
Page 31. Well, at paragraph 2, may I show you, Lordship? First, learned advocate representing the state respondents has placed before this court an inspection report in respect of the respondent who signed by the general manager, District Industry Center, Paschim Bardhaman on 3rd April 25, disclosing that on inspection it was revealed that the unit has been closed for some years. All machinery have been dismantled, no employee or worker is available at the unit premises. Report of the general manager, District Industry Center, Paschim Bardhaman is retained with the records. Then paragraph 3. From the documents annexed to the writ petition, it appears that the respondent number 2 was granted MSME registration in July 2018. Registration was under the Uddog Aadhar. After publication of the notification of Ministry of Micro, Small and Medium Enterprises on 26 June 20, the respondent number 2 company was registered under Uddam registration on 25th August 23. In the meantime, the respondent number 2 was admitted into CRP under Insolvency Bankruptcy Code on 22nd August 2023. Then, well, if your Lordship kindly skips over paragraph 8, the instant writ petition only revolves around the MSME status of the respondent number 2. The inspection report of the General Manager, District Industry Center, dated 3rd April 25, appears to have been forwarded to the Assistant Director in Charge, MSME such and such. Now, Mali, this is the important part. Clause 9.4 of the notification of the Ministry of Micro, Small and Medium Enterprises, dated 26 June 2020, mentions that in case of any discrepancy or complaint, the General Manager of the District Industry Center of the concerned district shall undertake an inquiry for verification of the details of Uddam registration submitted by the enterprise and thereafter forward the matter with necessary remarks to the Director or Commissioner of Industries, Secretary concerned of the State Department, who, after issuing a notice to the enterprise and after giving an opportunity to present its case and based on findings, may amend the details or recommend to the Ministry of Micro, Small and Medium Enterprises for cancellation of the Uddam registration certificate. Aforesaid provision mentions about complaint before the General Manager. In the instant case, the complaint lodged by the petitioner has been acted upon and a spot inspection has already been conducted. General Manager, District Industry Center is directed to follow up the matter strictly in accordance with law and dispose of the complaint at the earliest. This was your Lordship's direction. So your Lordship directed an inquiry because there was already a report. Now, after that, there were no steps taken, at least not to our knowledge. We were not given any intimation of any step having been taken, although your Lordship directed that all the parties will be informed as to what is the decision. Since no step was taken, the matter was thereafter proceeding to the NCLT. And before the NCLT, suddenly a representation was made by the resolution professional of Jagadamba Industries, that is the industry in question, that there is already a report and we have been given a clean chit, MSME status is confirmed. Well, in these circumstances, we came running before Lordship with the second writ petition because the earlier writ petition had been disposed of. And your Lordship passed an order at page 35. Well, this is order of 13th June.
Yes.
Paragraph 3, the petitioners pray for cancellation of MSME certificate issued in favor of respondent 2. Whether the certificate is liable for cancellation or not has to be decided on affidavits and then directed filing of affidavits. And then your Lordship said, paragraph 7, any steps taken during the pendency of the instant writ petition relying on the MSME certificate shall abide by the result of the petition. And paragraph 6 also, this was the direction. Respondent numbers 1 and 4 are directed to file a report disclosing all facts and figures. Respondent numbers 5 and 6 will also file a report disclosing all facts. Now, no affidavit filed in terms of your Lordship's direction, no report filed. Now, instead, we again, hear that they are taking steps to proceed with the matter and representation being made before the NCLT that report is finalized. We come back before your Lordship. Your Lordship passed an order on the 16th of July, page 37. Now, this is very important because on the 16th of July, your Lordship is told that there is no report yet and no report has been circulated. Learned advocate representing the respondent number 1 submits. Report is ready but is yet to be circulated as it had not been affirmed. Now, your Lordship therefore says you circulate the report. Now, page 40. Thereafter, if your Lordship will kindly have a look at page 40, then they file an affidavit before the NCLT. Affidavit discloses at page 43 an order. It's an internal communication. I won't call it an order. This is 18 June 2025. Now, on 16 July 2025, when your Lordship's approach, the representation is there's no report. In any event, in terms of your Lordship's direction, no report has been filed, no affidavit has been filed. Now, please see what it says. 18 June.
This has reference to writ petition number such and such before the Honorable Court. Well, your Lordship's order 4th April 2025 is referred to. Then, my Lord, please say, as all the points have been taken into account and necessary measures have been taken accordingly, in the light of provisions of notification number such and such dated 26 June 2020, under clause number 94 as directed in the Honorable Order of the Honorable Court, such and such was advised to undertake inquiry for verification of details of Uddam registration. And well, it then says, accordingly, GM DIC Poshchim Bardhaman submitted inquiry report by his office memo number such and such, based on, well, it now kindly mark the words, physical inspection, as well as other substantial documents received from power supply authorities. During considering the clause 94 of the notification, dated 26 June 2020, with its meaning and merits, it has been found that there is no discrepancy between the information appeared in the Uddam registration portal and inquiry report as mentioned. Now, where is the inquiry report? Well, there is no inquiry report. Now, thereafter, your Lordship will find that next page is the conclusion based upon the findings, scope of amendment, and any other activity in regard to Uddam registration of Jagadamba Industries having registration number such and such is limited and not feasible. Now, I don't understand what is the meaning of this sentence. Well, I have not been able to really make out any meaning from this sentence. Whether it says, yes, it is to be cancelled.
Yes or no, I do not understand what it means.
Now, very important. Well, if your Lordship finds, copy forwarded for information at the bottom of page 44.
Yes.
To Director MSSP, Joint Director MSME, General Manager DIC, Law Cell. How did the RP get a copy? How did he file the report, before affidavit before the NCLT? And then, my lord, this is after we file this application with your Lordship, they file a second affidavit, my lord, before the NCLT. Where, my lord, unfortunately, I could not make it a part of this application, but my lord, I should hand up a copy because it's a. My lord, now, my lord, your Lordship will find at page 44, it says enclosure inspection report. Now, this is what is filed by way of inspection report. Now, again, this is not circulated. At least this document does not say it's been circulated to resolution professional. Resolution professional, however, my lord, comes across this and my lord files it. Now, my lord, please see what it says. My lord, at page 4.
This is a letter of 18.
My lord, this is the 18th letter, and my lord, then the inspection certificate is at page 6. Now, the inspection certificate again, interestingly, is of 11th June 2025.
Yes.
Not circulated to the parties. When your Lordship takes up the matter on 13th June, not stated that, my lord, this is the position.
16th July, not.
16th July, when your Lordship takes up the matter, not stated that, my lord, this has happened. Now, my lord, what is stated here? My lord, may I just place this once? Apropos the above noted subject and reference, I would like to inform you that an inspection has been conducted at Jagadamba Industries Steel Manufacturing Unit, located in such and such, and Jagadamba Industries Limited Cement Manufacturing Unit at Bidhan Commercial Complex. Also verified documents submitted by Tech Nirman Ispat Private Limited and Jagadamba Industries Limited. General observations. Now, my lord, number 1, Mr. Pradeep Kumar, KDR Director Jagadamba, was present at both the unit during inspection.
He is not present. Suspended.
Now, my lord, very interestingly, my lord, the resolution professional is not there, who is now, my lord, in charge of the company. The, my lord, suspended board of directors is there. Anyway, that may not be so significant. Observance of Jagadamba Industries Limited Steel Manufacturing Unit is as follows. No signage found at any place on the unit site. Factory shed and machinery were found in rusted condition.
To the inspection report of 3rd April.
Plant and machinery not found in running condition. No power connection did not exist. Should no power connection exist. No employees, workers found. And then, my lord, with regard to the cement manufacturing.
No power connection, it did not exist. What does it mean? Yes, no, what?
It's of course not really the Queen's English, but my lord, let us understand that, my lord, it says no power connection exists.
No power connection exists. All right.
Then observance of Jagadamba Industries Limited Cement Manufacturing Unit. Signage not found. Factory shed and machinery found in rusted condition. Plant machinery not found in running condition. Power connection did not exist. Employees, workers not found. Then, next page. As per Uddam portal, it appeared that the investment in plant machinery and turnover of Jagadamba Industries is as follows. Now, we are not concerned with 21, 22, 23, 24 is relevant. because that is the my lord period when it went into CRP. Now, my lord, kindly see written down value of plant and machine is stated to be 23 crores 21 lakhs 90,071. Turnover is stated to be 1 crore 48 lakhs 79,293.
This is taken from the declaration.
Now, my lord, this is a self-declaration that is made. Your lordship directed inquiry, report with data. Now, my lord, on the basis of this self-declaration, what do they conclude? Even if the factory is not running, employees are not there, plant machinery are not working condition, sheds are in rusted condition, what do they say? Please see, it is here noted as per office memorandum such and such and clarification number such and such. It says online form of Uddam registration captures depreciated cost as on 31st March each year of the relevant previous year. The data of investment and turnover either gets autofilled or fetched from the income tax department and GSTN. As letter received from WBSEDCL by memo number such and such dated 15th May against our letter, the power connection of Jagadamba Industries Limited steel plant located at such and such was disconnected permanently on 9th August 2023. Now, the unit became CIRP on 22nd August 2023. So even before CIRP. As letter written from Indian Power Corporation Limited by such and such against our letter, it says power connection of Jagadamba Industries Limited cement unit was disconnected on 27th November 2023
RP has admitted himself.
permanently. Now, there are discrepancies so far as what RP has stated later. I am not troubling your lordship with that now. All that I am saying is, your lordship's order directed inquiry. And thereafter, your lordship's order of 13th July, very specifically said that you must ultimately file a report. And this is the requisite. It said 16th July. I'm sorry,
13 July, 13 June, read with
16 July.
35,
Yes. Your lordship had directed reports to be filed.
35. Page 35 at first.
Yes, my lord. Respondent numbers 1 to 4 directed to file a report disclosing all facts and figures. 5, 6 will also file a report disclosing all facts. Now, my lord, the question is, my lord, here, my lord, so far as MSME is concerned, the status is confirmed to facilitate the carrying on of business. Now, my lord, so far as this is concerned, the only question is, my lord, whether you are carrying on business. And my lord, whether today, if the idea is if you're carrying on business, there will be a turnover. You're carrying on business, there will be plant and machinery. Now, my lord, here, the report said, initially, my lord, when your lordship took up the matter, the report said factory line closed for many years. Plant and machinery rusted. Factory sheds rusted. Not in a running condition, no employee.
No plant and machinery.
Now, my lord, with what are they running? Now, my lord, when your lordship directs that an inquiry should be conducted, my lord, there is no inquiry. They go say that, yes, nothing is there. But they say because there's a self-declaration, we are proceeding to say it's all right. Now, my lord, that is exactly what your lordship directed an inquiry on. That whether, my lord, the self-declaration that they're making on the basis of which, my lord, they're seeking to continue or reassert the status of MSME, my lord, whether that is a valid declaration. Now, my lord, contrary to, my lord, the report, their own report, my lord, if there is no plant and machinery in working condition, no power connection, no employees, no sheds, then, my lord, how can they commence and carry on business?
Auto fetch on the basis of balance.
And, my lord, so far as the auto generation of information is concerned, that happens on the basis of balance sheet.
No, page 122.
Now, my lord, so far as balance sheet is concerned, please have a look at
122.
my lord, the balance sheet of, my lord, the company.
122. Page 122. LC. Property, plant, and have not been physically verified.
My lord, now, my lord, so far as the balance sheet is concerned, please see 122. My lord, this is, my lord, the annexure to the independent auditor's report. My lord, your lordship will
Who has
find.
prepared this?
Well, this is a company. Company has prepared this.
Company has prepared this.
Independent.
Now, my lord, please see it, clause D.
Hmm.
The company has not revalued any of its property, plant, and equipment and tangible assets during the year.
Hmm. Hmm.
And, my lord, also B, the property, plant, and equipment has not been physically verified by the management during the year, hence could not be commented upon. Now, my lord, the question is, my lord, then what is, my lord, being done? Well, my lord, submission to your lordship, which is very simple. Well, your lordship had given a very specific direction to conduct an inquiry.
Hmm.
And thereafter, my lord, to submit details. My lord, the inquiry means, my lord, inquiry into whether, my lord, the self-declaration that is made is, my lord, actually correct or incorrect. If the self-declaration is made on the basis of balance sheet, my lord, these two, my lord, independent, my lord, auditors reports in the balance sheet or the annual returns of the company shows that, my lord, this is a false declaration with regard to plant machinery.
No, rather the land is itself sold now.
Now, my lord, it is for this reason that, my lord, we have now, my lord, requested, my lord, to your lordship to, my lord, appoint an independent agency, my lord, to carry out this inquiry. Because otherwise, my lord, what is happening is, my lord, your lordship's order is attempted to be overreached. Because, my lord, without circulating copies to us, without circulating copies to all concerned in terms of your lordship direction, independent communications are being made, my lord, to the resolution professional. Independent communications are being made, my lord, to the other person who's now, my lord, the successful resolution applicant, although a related party and hence barred. And, my lord, the entire process is sought to be flouted. And, my lord, the representation made very, my lord, in a very vocal fashion before the NCLT is that, my lord, NCLT has nothing to do. NCLT can't go into the question of whether, my lord, it is a valid MSME registration or not. It has to, my lord, proceed on the basis of MSME registration as granted and approve the plan. Now, my lord, that is why, my lord, we had to approach your lordship because, my lord, unless, my lord, this NCLT process is stayed till your lordship decides this question, well, the entire process is being bypassed. Your lordship's order is, my lord, being jettisoned and cast aside.
All promoters will misuse this provision.
Well, these are my submissions.
I am the resolution professional. Lord, whatever your lordship, Lord, decides.
I hear the directorate first.
Lord, may I?
Yes. How are communications going to the?
Your lordship, this application was received by my office on Thursday. I have sent out I have sent out to the officer to give me instructions how this has happened.
Absolutely.
Your lordship, we did that.
I have recorded your submission that it has not been circulated, the report and everything. And now the report by way of an affidavit is being filed before another forum.
That your lordship,
What is the genuinity of the conduct of your clients?
Lord,
Is taking a stern view of this.
Because before that, I also need to understand from where it has happened.
Exactly.
Lord, it's a letter which was given to me.
Yes, so he'll be answerable as to how it can be given to you.
To the petitioner.
Yes, yes.
Lord, may I explain?
1 minute. Who are you? 4, 5, 6. Yes, what will be your submission? There was a direction upon you also.
Yes, the report has been prepared, Lord, the line of my junior, Lord, they're running, Lord,
Whoever it is not before the court.
Yes, but Lord, I have got something to say, Lord.
What is it?
I don't have the instruction.
What is the, who is he? Who is the petitioner and what is his locus standi for asking the cancellation of Lord the MSME?
Okay. To cancel.
But there is a procedure, Lord, for cancellation of that registration, Lord. One by either Lord the Jagdamba,
726.
against whom my learned friend has come up before your lordship, Lord. Either Lord, he will so moto Lord surrender that Lord that we don't want to proceed or we don't want to take up Lord that continue with that registration, or the state government after due verification and all that Lord will submit a report and they have got the power. Lord.
That is exactly the reason why the state was directed to conduct an inquiry and come up with report.
Now, no, state government has already said that everything has been done in a proper way. There is no discrepancy, nothing of that sort, Lord. So, Lord, the registration is valid.
What does this mean? That there is no plant. The plant is there, the machinery is there. There is no electricity. The turnover, how come the turnover is coming?
Only, Lord, my instruction is, Lord, that everything has been done in, everything is in order, Lord.
What do you mean by everything is in order? A physical inspection was conducted. An inquiry was done. It was seen that the unit is not functional.
That this matter is pending before the NCLT. And
that is different. The court is not concerned.
Advanced stage, Lord.
The court is not concerned.
So, Lord, we are only concerned with the Lord cancellation or Lord
whether the unit can be treated as MSME as on date. This is what the issue is.
No, my lord. My lord, may I please,
Right.
my lord,
So what is your submission? Even if the company is not functional, the unit is not functional, does it continue to remain as MSME? That is the question.
Yes, Lord, I have to take instruction, specific instruction with regard to Lord, whether the Lord, unit is functioning or not.
No, the report says
It is not functional.
There is no electricity. How can a unit function without electricity and for quite some time?
It is not functional. It's a closed unit. Both units are closed. Milord,
Who are you?
Milord, I am the resolution professional.
All right.
Milord, please let me explain the matter.
But then the resolution professional is not a party over here.
No, the company, Milord, I have to represent the company. Milord, under the insolvency code, Milord, I represent the company today, Milord. Now, the first thing, Milord, what is happening is, Milord, the submission that this is a closed unit by the petitioner is absolutely correct. There is no difficulty there. The petitioner is a failed bidder. He wanted to buy. He is unsuccessful. So, my lord, after everything is over, he is, my lord, starting this witch hunt. Now, my lord, may I put it in the correct perspective? MSME registration under the Act is on the basis of investment made. My lord, if your lordship looks at section 7 and, my lord, the rules and the notification, I have them for your lordship's perusal. It's on the basis of investment made. It is, my lord, nobody's case that this was not a functional unit. Now, there are two, my lord, industries, my lord, under this company. One is, my lord, cement manufacturing. The other is, my lord, steel manufacturing. Both were, my lord, functioning until 15 days prior to the insolvency CIRP commencement date. 15 days before admission, both were functioning. Electricity in one of the two units was disconnected, my lord, 15 days before the CIRP date. And after, my lord, the CIRP commencement happened when I took over, it became unfeasible to run the unit with its cash flows. So, my lord, the second unit also, my lord, was closed. My lord, workers were discharged, etc. So, admitted position is A, there is, my lord, investment, there is existing plant and machinery, and B, that both, my lord, are stopped with electricity disconnection. Now, my lord, the relevance insofar as the present matter is concerned, what Mr. Shah opened by saying that as at the insolvency commencement date, the CIRP commencement date, question is whether there is an MSME certificate or not, and the validity of that certificate. Not as of today. Today, my lord, if it is to be seen as of today, this would be, my lord, 100% liable to, my lord, go out. But if at the CIRP commencement date, there was, my lord, an MSME certificate, in that case, the eligibility under section 29A of the IBC is relaxed. That is the issue, my lord, before your lordship. So, my lord, an industry with its factories, with one of its two factories shutting down 15 days before, would not be ineligible at all. Its investments were absolutely there. There is existing plant and machinery. So, my lord, this is a complete non-issue, which is, my lord, being raised before your lordship. Now, may I tell your lordship, my lord, why this is being raised today? Because a resolution plan has come. The Committee of Creditors has approved it. The resolution plan application has been heard. Now, the objections to the plan will be heard. My learned friends' clients have filed several objections. In one of the objections, my lord, apart from the plan approval objection, this issue has also been raised. Now, my lord, the matter is fixed on the 30th or the 31st. 30th. To prevent that application from being heard, my lord, all of this is happening. May I now show your law? And my lord, I'll also show when, my lord, he was aware of, my lord, the process, and how, my lord, 1 year after he failed, my lord, to take any steps, and after he was rejected, he's come up and he started doing this. But all that is, my lord, secondary. First is to, my lord, satisfy your lordship's conscience that the MSME registration was proper and your lordship's orders, my lord, have been followed. May I, my lord, show your lordship section 7 of the MSME Act. Lord, please see section 7.
Yes.
And then, Lord, I'll explain each of the reports. Lord, please see section 7. Lord, classification of enterprises, subsection 1, notwithstanding anything contained in such and such. A. In case of enterprises engaged in manufacture or production of goods pertaining to industry specified in the first schedule to the Industries Development and Regulation Act as a micro enterprise, where the investment in plant and machinery does not exceed such and such. Small enterprise, same, investment in plant and machinery. 3. Medium enterprise, investment in plant and machinery. Then, in case of enterprises engaged in providing or rendering of services, that's not so relevant here, but same, my lord, investment. And then notifications, etc. So, my lord, the eligibility is on the basis of investment made in the infrastructure. So, once, my lord, investment has been made, you are eligible. Then, my lord, subsequent turnover criteria is there. My lord, also...
One minute. Yes. See, it is not for the writ court to declare any unit as MSME or not.
Correct.
This is not the function of the court.
Yes.
The authorities are already there.
Yes.
And there is a direction which has been read out.
Yes, pursuant to the direction, I was informed by the state of, they don't, not the learned advocate appearing doesn't have instructions, but I do. My client was informed that there would be an MSME inspection after your lordship's order. My lord, I went there to assist because I am the one who has the keys and custody of the factory. I, my lord, now substitute the board of directors. I went there with a Google camera. I photographed, my lord, inspection on 29th April. Then, my lord, I was given a letter with, my lord, the inspection report. I have filed that before, my lord, the NCLT. Now, I'll just show your lordship, my lord, one photo.
If document is given to the company, why will not be given to the petitioner? Because it is being done in terms of the orders passed by the court.
Because I am
it should have been given to the writ petitioner also. Right? This is what the...
Speaking, I am a statutory functionary and I have the keys to the factory, which is why I was called for their inspection. But, my lord, all that is relevant, my lord, if I may humbly submit, is was there ever a functional factory with plant and machinery?
It was.
Then, my lord,
after it has become non-functional.
Yes.
It is then the question of the resolution professional and everybody
correct,
coming
my
in.
lord. Absolutely, my lord. Now,
Right.
may I give your lordship 3 dates? My lord, please permit me, my lord. Very important 3 dates. First is, my lord, the CIRP commencement date, that is 22nd of August 2023. The steel plant was functional till 9th of August 2023. My lord, 15 days. When, my lord, electricity was disconnected and it, my lord, was closed down. Then, my lord, after I took over, the cement plant was closed upon disconnection on 22nd of November 2023. From then, everything is shut.
Yes.
But the fact of the matter is that on 22nd of August 2023, there was a factory for which, my lord, an MSME certificate was given. It was a functional factory. And, my lord, that is all that is relevant for the purpose of, my lord, the insolvency code. Now, the petitioner, my lord, if I may use the expression, is starting this witch hunt because, my lord, it is ineligible and its plan has been rejected by the Committee of Creditors.
No, that is for the NCLT to decide what is
Now,
to be
that's,
done.
my lord,
court
on
is
the
not
30th.
entering.
Now, my lord, may I show your lordship? If your lordship permits me to hand up these photographs.
Nothing. Did you get the report?
Nothing.
You've got this.
My lord, he's filed it.
Just now it
He's
has been
filed
handed
it.
over.
He's handed.
I have not.
No, that's from a different source. But this is coming from the authority.
My lord, I haven't got this also. I've also got this now.
Yes.
What, my lord, he has annexed has also been given to me. And he's, my lord, suppressed the main document in that.
What I have got.
Because he wants to, my lord, ensure that the 30th hearing is derailed. That is his objective. My lord, please permit me 5 minutes.
This is what is here. And what is this?
Your Lordship, that is the inquiry report, Your Lordship. It has to be confidential, so I have just my.
Please see it, my lord, whether it was
Have it
functional.
with you?
Your Lordship, that the one in the envelope I don't have, but I have this report.
All right. This the authority will decide as to whether the certificate is valid, or if it is not valid, from when it is not valid. The writ court will not decide.
Your Lordship,
That's been decided really.
No, well, your Lordship
That's
had
really been decided. If your lordship sees the letter, I'll show your lordship. my
your
lord.
Lordship had my lord,
No,
directed
my lord,
filing
you
of
are the
affidavits.
failed bidder. I'll show
But
their
I just-
motives. And I'll show both their applications filed before
lord, a
NCLT.
failed bidder
He
is
is, my lord,
entitled to
taking
raise this
advantage of, my lord, the writ court in an incorrect manner.
My lord,
My lord,
this
let
is-
me
this
show
is,
your
my lord,
lordship.
this is, my lord,
No,
all
no,
fire
please, Mr. Shah, I didn't disturb you.
Who are you
I'm
representing?
one of the successful resolution applicant. Lord, my plan, Lord, is for number 3.
All right.
My plan was approved, Lord, on 19 September 2024 by the Committee of Creditors by 80% vote. Lord, his plan wasn't. Thereafter, Lord, on 5th November onwards, Lord, this objection has started.
Exactly. And he's filed an application.
I am
Lord, this
saying
objection
you're
has
not
started.
eligible.
Lord, the repetition was
I am
filed.
entitled to raise this objection in law.
No, I will show, my
We are
lord.
both bidding for the same thing.
No, I'll show your
He
lordship.
also knows, my lord, what is there.
My lord, I am
he-
only.
No, I will
Let us
now
start.
show your lordship. My lord, please have a look at IA 624, which my learned friend has filed before the NCLT. And he's made a bid on the basis of this very plant and machinery. So how can he now today say anything?
My lord, so far as this is concerned.
No, but let me finish. My lord, please have a look at IA 624.
No, I'm not looking at anything.
My lord, all that matters is whether at the CIRP commencement date, there was, my lord, a valid certificate. It was a running industry. What is my learned friend saying? How does it matter whether there should be a certificate today or not? No, I'm not giving anything. And please, Mr. Banerjee, no, you then don't address me. Now, my lord.
Let the authority take a decision. It is the respondent number 4. Respondent number 4 will take a decision.
DFO will take the decision. Your Lordship.
My lord, but the DFO has already decided. If your lordship sees that decision.
Your lordship had directed an
No, my lord,
inquiry.
may I?
Thereafter,
The
certain
inquiry. No, my lord, on the basis of the inquiry, decision has been taken.
Where is the inquiry?
Lord, please, let me show your lordship, my lord. Now, my lord, please.
We have not been given anything.
No, my lord, please have a look at the last application file. I'll show your lordship, my lord, that he suppressed the inquiry. Both of us got the same letter. He's taken out, my lord, the inquiry report.
Well, we have come to know for whatever we have come to know from the supplement.
Absolutely wrong.
Who is the respondent number 6? The joint
Milord,
director and
Milord,
the
please.
HOO. Who is the HOO?
I'm for 1.
Milord, please look at page 43 of the application.
This is supplementary affidavit given by ACPI, which we have an
HOO?
চিঠিটা আলাদা করে দাও।
Who is this HOO?
Milord, my learned friends got page 43. Kindly see page 43. This is after all of your lordship's orders. All the points.
What does page 44 last paragraph say?
Page 44 says, based on the findings, scope of amendment or any other activity in regard to Udyam registration of such and such is limited and not feasible.
What does
as
limited
of
and
today,
not feasible mean?
As of not feasible mean it's not to be amended today. Let's please have a look at what Udyam says.
No, that is your way of interpreting it. The
And
court
Milord,
is not
look at
very
the
sure.
inspection report. And Milord, may I humbly submit, today may I humbly submit this, as of the today, whether there will be a certificate, as of today, whether there will or will not be a certificate is irrelevant for the purpose of this industry, which is in the process of being, my lord, there's a CI revived. And that relevant date is CIRP commencement date in 2023. As on that date, August, as on that date, admitted position is there was plant and machinery. Based on that, he has himself participated in the bid process. So, my lord, he wants to derail the adjudication by starting this.
All right. The court is not deciding whether whether the company is MSME or not. This is not the power or the authority of the court. It has to be done by the competent authority.
my lord, what your lordship had directed, my lord, because of this, is my lord, they should make an inquiry and take a decision on cancellation of the MSME registration. That was your lordship's order. Now, my lord, so far as the question of cancellation of the registration is concerned, that is therefore what is material. Now, my lord, cancellation of the registration, my lord, can happen irrespective of whether, my lord, there was investment in plant and machinery or not, because, my lord, it is not a functioning unit any longer.
So today it can't be cancelled because of section 14 of IBC. There's a moratorium. It cannot be cancelled.
There was a direction to dispose of the complaint. Where
That's
is the
right.
direction for cancellation?
Yes, my lord, dear lordship, will kindly see.
Which
Well,
portion?
that's my lord, the order of 4th April 2025 at page 31.
Yes, page 31. The directed to follow up the matter and dispose of the complaint of the petitioner.
Correct. Milord, that's been done. Inspection done.
No,
Milord, please permit me, Milord, to show your lordship the.
Please see.
हाँ,
My lord, please see, my lord, here. My lord, this is, my lord, what your lordship had, my lord, held. Your lordship had directed disposal of the complaint. And
Yes.
here the complaint was, my lord, with regard
Thereafter,
to
you
cancellation of the status. That is why-
thereafter you come up with the writ petition seeking cancellation.
Yes, now, my lord, that
which
is why.
pending.
That is why, my lord, if your lordship sees page 726 of the writ petition,
Volume 5.
my lord, volume 5 of the writ petition, my lord, here, my lord, the MSME authorities had therefore said that please show cause as to why it will not be cancelled.
All right.
My lord, this is what it says.
Milord, it can't be done today.
Premises on which Mullah comes, Mullah is not correct.
Here,
Mullah has
what
to be
this is what
considered
it
at that
says.
date. We both know, Mullah, we are bidding
Just
for a
one
closed
page.
unit.
Just one page,
No, we are bidding
726.
for a closed unit.
My lord, this is just one page, but it says
Participated, Mullah, he was
misrepresentation.
a prospective resolution application from 4th
My lord, page 726,
January.
misrepresentation of facts in
4th
Uttram
January
registration
2024.
certificate. My lord, this
And
is
it's
what
not
it says.
relevant as of today.
Well, at paragraph 2, however, on
Yes.
physical verification of unit, it has been seen that unit is closed for several years. All machinery have been dismantled. There are no employees in the unit.
Correct.
So all along,
Yes,
it is
that's
the same
right.
fact.
Then
That's why both of us have
participated.
bid.
clearly demonstrates misrepresentation. Hence, you're advised to apply on the following link for cancellation of Uddam
They have
registration.
to apply for cancellation themselves. There is no proof. That's why.
Milord,
So they do not want cancellation. They want revival of the unit.
Correct.
My lord, revival of the unit, my lord, of course can be done, but my lord, not with my lord, the existing status by a related party saying that it is an MSME unit.
Status can't be changed.
Let the authorities take a decision on the basis of the inquiry report and whatever is there. Previously, also they have taken a decision as
Milord,
to what is to be
Milord,
done.
what they're
But,
trying
Milord,
to do
what
is to
they're saying-
pressurize the authorities
No, my lord,
so
kindly,
that the
may I make-
NCLT process is lost.
my lord, may I make
And
only one
Milord,
submission?
Milord, no, please, Milord, the Mr. Banerjee's client, Ratnanko Banerjee's client's bid, Milord, has been found acceptable by the lenders and they have approved it. Milord, application has been filed. It's about, Milord, to be, application is considered, only 1 or 2 objections are left to be considered. That's on the 30th. To forestall this, they want, Milord, your lordship to reopen this certificate issue, which is a non-starter because certificate is as at
Yes,
that
I
date.
followed.
Well, only one submission. I'm just speaking to your lordship's order, nothing else.
Yes.
Now, my lord, so far as this is concerned, your lordship directed an inquiry.
Hmm.
Now, my lord, page 726, your lordship has seen that they have said that misdeclaration, my lord, declaration has been made and hence, my lord, it's liable to be cancelled. So, my lord, it is not on the basis of whatever is shown in the, my lord, portal that one can proceed. So, my lord, the inquiry meant, my lord, to find out as to whether there is a misdeclaration or not. That was your lordship's direction.
But then the misdeclaration or whatever will go back to the day on which the proceedings.
Yes, that's right.
Right.
And there was
Day
a
on which, my
functional
lord, the
unit on that
declaration was
date.
made. And, my lord, the declaration was made, my lord, 22nd May, my lord, is when it went into CRP. 25th May is when, my lord, the new MSME certificate is issued. 25th August.
Mullah, it is
22nd
surprising he
August,
wakes up, Mullah, in November 2024. After Mullah having participated, having lost, Mullah having lost, Mullah, in the Mullah bidding process, now Mullah he comes up with this.
Well, I am only on the one
Lordship
question.
remembers Mr.
Lordship
Shah's
directed
last
an inquiry.
submission, stay the process. That was his last submission.
My lord, your lordship had directed an inquiry. Inquiry, my lord, is not, my lord, simply accepting what is there on the portal because my the authorities themselves have found that there's a misdeclaration. I'm only on that. Number 8 is on the
Milord,
basis of, my lord, an
this is
actual
the
inquiry
letter
on the
which
basis
we
of
have
the
all
proceedings.
got. Milord, please have a look at the letter which we have all got from
And, my lord,
MSME,
here your lordship
which
has
has
seen
the inquiry report.
that the
Milord,
balance
please
sheet,
see the inquiry report.
the balance
which they
sheet
have
says
suppressed.
that, my lord, there has no physical verification of plant and machinery. My lord, that is the auditor's, my lord, representation. My lord, we
Milord,
can,
please have a look at this
can't be
document,
allowed.
Milord. There is an inquiry report, plant machinery found. After that, it's a closed matter, and the
Well, I don't
authorities have
know, my
said.
lord, what is the inquiry report? Because
No, no,
whatever I have
authorities
told
have
your
said
lordship,
not
I've
feasible.
seen, my lord, what is there.
Milord, Milord, I have the inquiry report. I have photographs taken on a Google camera with the date of the machineries. And my learned friend, all that he wants is to
My
stall
learned
the
friend is
process
saying
and
that
revival
whatever has been
after
found
being
under
a failed
report is
bidder.
false.
After being a failed bidder, making a bid on in
Sir, is
respect of
that-
this plant and
But
machinery.
is that going to be
He
the
is now
constant
going to say
refrain?
this.
We are on a different question, my lord. My learned friend is on a point of prejudice.
Milord,
because-
please see the inquiry report.
Status, my lord, he wants, my lord, this company now, my lord, to go into insolvency, my lord, liquidation.
Liquidation.
But he can come around.
No,
He
no,
can come back.
Will fail.
Milord, please
No,
see
no,
this
that's not
inquiry
not
report.
Why go through the whole process, my lord, if he was not interested?
That's not correct.
All that he wants is a direction on the MSME. He'll use that to Milord scuttle the hearing.
So that let me see what it is. See,
And everybody's English is not as good.
it is not the English part.
No, not feasible, not feasible. So that's it. That's the finding. And why? Because existing turnover is admitted.
Oh, not feasible, whether the cancellation is not feasible or the certificate validity is not feasible, the court is not able
Milord,
to.
as of today, Milord, now may I just say two things?
18.6 is annexed, isn't it?
Yes, yes.
18.6.20.
That's at page 43.
Milord, just
That is annexed already.
At page 43.
Milord, just two things. As on today, under section 14 of the Insolvency Code, there is a statutory moratorium and there can't be any cancellation in any case. Because that's for the bidders to,
Section
Milord,
14.
have. Section 14.
14 of, my lord, the IBC.
And nothing can be cancelled today. No government registration
Right,
can
my
be
lord, the RP
cancelled.
has an obligation, my lord, to continue the present state.
Milord, if it's cancelled, I have to challenge it. That's my
As-
obligation.
Well, our contention is as on the date of
Only the crux is not prayer for the cancellation.
because my lord,
Can't
our
be done.
contention is well, our contention is
They have already
তার একসঙ্গে সবই কথা বললাম
inspected, verified everything. Then that report has been prepared.
Yes.
Well, our contention is as on the date when the company was into CRP, it could not have been MSME.
Cancellation of.
So why did you bid on the basis then?
Participated on that.
No, why did you bid on the basis?
Because my lord, there was misdescription by the RP in the information memorandum. They
Now,
did not
Milord,
say
it's
this.
becoming
Then he has
clear.
to go there.
Your client has all the papers right now. File one-page report saying whether the cancellation is required, relying on this, or the certificate will remain valid. When will you come up with this?
1 week.
1 week? Very
Only
good.
within 1 week.
All right, please come.
Not to kindly indicate that.
I will.
Yes.
Milord, may I make one last prayer?
Acha. Mm, the
দাঁড়াও সবাই মিলে কথা বলবো না
inquiry report of the General Manager, District Industries Center, Paschim Bardhaman, in a sealed cover, is placed before the court. Stop. The
Oh.
director Directorate of Micro, Small and Medium Enterprises is directed to file a report, not more than a page, clearly indicating as to whether the MSME certificate in favor of The respondent number 2 can be treated to be valid. Stop. The treated to be valid on the day the CIRP proceeding was initiated. That is given the date
22nd August 23.
22nd August 2023. Stop. The matter is made returnable on 4th August, next Monday. Come back.
And would your lordship, also say this, that the NCLT proceedings, they will not be concluded in 7 days. Otherwise, they'll go and get it adjourned on the 30th.
It will be concluded. I don't think 1 day's adjournment.
No,
will
but
create any difficulty.
would your lordship, permit
After
that?
the 4th,
What thing? I have not stopped anybody. I have not.
I will go. We will continue with the hearing.
Whatever is there is there.
Absolutely. Huh?
Mr. Dinda, you also inquire as to how documents are going outside. Your name has not been recorded for the state?
Yes, ma'am.
For the state? All right.
All the sleep was handed over.
Very well. ওনার নামটা রেকর্ড করে দেবেন for the state. And is anybody's name required to be struck off?
Yes, because this matter was actually allotted in my name along with the junior. My junior was not present, so I did not give his name.
Only
There should
You given
Honda and last two names.
they
will not be there. Given the your name, নিচের দুটো নাম কেটে দেবেন.
Item number 2 is for extension of interim order.
What was the interim order?
Not to proceed before the tribunal. There was an arbitration clause. This is between state of Kerala versus
presenting any.
Just 10 minutes, ma'am.
This is my application.
Yes.
No,
What is your prayer?
It's at page 27.
Yes.
No, they thought to issue a show cause notice for termination of the contract, and they have imposed a order for living compensation. Now, not the sole point not which I flag for your lordship's kind consideration as an issue is, please come to page 39. Not this provides for a mode of termination of contract by the government. They want to do it before the 2026 election. It's construction of a university building. In May 2025, the revised drawings are handed over to me. In June 2025, they themselves extend this period till 31st of December 2026 for the purpose of execution of the contract. Within 7 days, they issue me a show cause notice.
Where is the extension?
Not that, Lordship will have that at page 61. Please have a reference to page 61. The last paragraph on that page. In view of these circumstances, a suo motu time extension up to 31st December 2026 was granted via this office memo dated 28th of May 2025. This is dated 20th of June 2025. So, December 2026 is the last date by which I have to execute the contract. On 20th of June 2025, I am issued with a show cause notice as to why they should not issue an order of compensation in terms of a particular clause. Now, please come to page 39. Now, that's my case. Pages 38 and 39. Page 38 of the writ application.
38. 38 is the conditions of contract.
Yes, conditions of contract.
Yes.
But please come to the last clause on that page, clause 2.
Yes.
The time allowed for carrying out the work as entered in the tender shall be strictly observed by the contractor and shall be reckoned from the date on which the order to commence work is given to the contractor. The work shall, throughout the stipulated period of the contract, be proceeded with all due diligence, time being deemed to be the essence of the contract on the part of the contractor, and the contractor shall pay as compensation an amount equal to 1% or such smaller amount as the superintending engineer, whose decision in writing shall be final, may decide on the amount of the tendered amount of the whole work as shown in the tender. So that's the power to levy compensation. Now please come to clause 3 at 39. In any case in which under any clause or clauses of this contract, the contractor shall have rendered himself liable to pay compensation amounting to the whole of his security deposit. So that's the first condition. Whether paid in one sum or deducted by installments, the divisional officer on behalf of the governor shall have the power to adopt any of the following courses as may be deemed best suited to the interests of the government. Not they have taken recourse to clause A to rescind the contract, of which rescission notice in writing to the contractor under the hand of the divisional officer shall be conclusive evidence, and in which case the security deposit of the contractor shall stand forfeited and absolutely at the disposal of the government. So that this power to rescind the contract can be imposed in the event the amount liable to be paid towards compensation amounts to whole of the security deposit. Now the security deposit was 1.96 crores. Now they have extended this in June 2025. The compensation is at the rate of 5,000 per day. So for 1 month at the most, it's 1,50,000. Therefore, the decision, not as we have brought on record, on 18th I filed the writ petition. At 9 o'clock in the night, I received the termination order. To non-suit me, please come to the supplementary affidavit.
page 14 of that supplementary affidavit. Copy the supplementary copy. In inviting to the above subject and references, the undersigned would like to inform you that in spite of repeated requests from the end of the concerned executive engineer, you failed to do proportionate progress of work in proportionate time, which the concerned executive engineer stated in his several correspondences, and also the undersigned explained in detail in this office memo number so and so of 30th of June 2025. As per recommendation of the concerned executive engineer, the undersigned was compelled to impose clause 2 of this numbering is that works contract, which is very much applicable as per PWR so and so 100 of 2020-21 of superintending engineer and project director, project implementation unit, public works directorate and contract agreements. Regarding payment of this project work, please read so and so. Further, your statement about your proposal of honorable exit in principle, no such proposal from your end has been received by this office, nor the engineer in charge, and also no such instruction from any authority of the department has been received. So at this juncture, the undersigned can't be able to comment anything regarding your statement of honorable exit. So this action in termination of the contract after this show cause notice of 30th of June 2025, levying compensation is wholly premature and devoid of the contract.
What is this honorable exit?
We said that if you can't furnish the drawings and cannot allot me the space for the purpose of execution of the construction work,
let me go out.
Honorably exit.
So that compensation and all these
or
things doesn't.
I don't get debarred in future tender process.
Hmm.
They initially exit, then they reconcile therefrom. Then they don't want to carry out with this. Very well, if you don't want to an honorable exit, stick to your terms of contract. That's my prayer in the writ petition. But the reading of clause 39 can only lead to this. I'm sorry, clause 3 at 39 can only be invoked once the compensation amount equals to or exceeds the amount of security deposit. Then the subsequent steps can be taken. And they themselves have extended it up to 31st of December 2026.
No, but then they say that proportionate work has not been done.
Yes, please.
That is important.
No, please come to page 220 of the supplementary affidavit.
Yes.
You are this is dated 26th of May 2025. You are requested to collect one copy of drawing, pile and column layout plans for academic and students activity center immediately and commence the remaining piling work at the site. Certain portion of the work has been executed. 26th of May 2025 is the revised drawing. Now 28th of May, suo motu decision to extend the contract that I read page 61 up to 31st of December. So till end May 2025, to the satisfaction of the government, they have suo motu decided to extend the term of contract up to December 2026. 20th of June is the show cause notice and 30th of June is the compensation order. Please come to page 72. There's the 30th June order of the writ petition. But just like a bidder cannot go beyond the terms of contract or tender, the other, it's also same for the buyer.
What is the defense mechanism, dispute redressal mechanism?
The dispute redressal mechanism, but it's of the same department. But first of all, there is no arbitration clause expressly. I don't have a remedy to pray for injunction anywhere. Number two, this is comprised of persons from the same department. But your lordships have not time and again.
So why don't you go to the civil court? Why? What will the
civil court against the government for the purpose of obtaining an injunction against termination? Probably I will be really non-suited. Please see the provisions in 39. But they took recourse to clause A to rescind the contract, and in which case the security deposit of the contractor shall stand forfeited and absolutely at the disposal of the government. Then after clause C, in the event of any of the above courses being adopted by the divisional officer, the contractor shall have no claim to compensation for any loss sustained by him by reason of his having purchased or procured any materials or entered into any engagements or made any advances so and so. And in case the contract shall be rescinded under the provision aforesaid, The contractor shall not be entitled to recover or be paid any sum for any work therefore actually performed under this contract unless and until the subdivisional officer will have certified in writing the performance of such work and the value payable in respect thereof, and he shall only be entitled to be paid the value so certified. But the provisions of the contract say that every month there has to be a running bill and they will pay accordingly on being certified. But that's
You
something
have
that
performed some portion of
Yes,
the
yes.
work. Did you receive any payment?
not out of the actual amount of work rendered, they paid me 40% or something like that. 3 contracts are in execution, 2 in North Bengal, 1 here, and they say you have sufficient fund to carry on with your own money. That's the stand taken by the government.
And that is the reason you are also not proceeding for which
I said
all
that
these
you
things.
please permit me.
Exactly. This is why the project got delayed.
No, the second point is not allocation of space and the drawing. That revised drawing came only in May 2025. Because there were water bodies for which there had to be permission taken or not permission given by the government for replacing those water bodies. But that is a disputed question of fact. But not admitted fact is on 26th of May 2025, the government gave me that revised drawing, and in June 2025,
What is
they
your
extended
instruction?
At this stage, not it is the fact, my lord, that project is the very important project.
Yes.
But unfortunately, the agency already from the beginning to work the slowly. In spite of that, the project tender amount is more or less 78 crore 81 lakhs 1,000 such and such, and that work will be completed within 27 July 24. It is the terms and conditions of the tender. So
24.
27 date of completion of the work 27 July 2024. Thereafter, my lord, exchange of tomato allowed by the executive engineer
till 26 December.
26. Thereafter, my lord, payment already made rupees 8 crore 62 lakh 72,000. Work already completed more or less 15% of the total work. So thereafter, the executive engineer Somoto extends this time, but their intentions is very bad to complete the work. At this stage, the executive engineer issued the so-called notice. There is no any steps for continue the work. This is the
You
fact.
file a report.
The report will be filed
Yes.
after tomorrow.
And all figures and all dates should be mentioned as to what, and you will also disclose when you handed over the drawings whether the petitioner was in a position to carry out the work or not. Please come. Supplementary affidavit filed in court is taken on record. The matter relates to a works contract entered into in between the petitioner and the PWD. Regarding construction of Rani Rashmoni Green University. Stop paragraph. The authority has terminated the contract of the petitioner and has also sought to impose penalty. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that the impugned orders are beyond the scope of the contract. Stop. Specific submission is that the delay caused in the construction work was not because of the petitioner. Stop. The authority did not provide the drawing at the proper time. Stop. The no objection certificates from the competent authorities were also not received at the proper time. Stop. Paragraph. The prayer has been made to set aside the impugned order of termination. Step next. According to the respondents, the petitioner is not interested to complete the work within the stipulated time period. Step next. The state respondents is directed to file a report giving the report disclosing all facts and figures. Step. The report shall clearly indicate as to when the site was made available to the contractor, the date of handing over the drawings, the progress of work by the contractor, and the payment received. Step next. Such report shall be circulated by 7. You have everything, all facts are there within 1 week. Within 5th August. Release the matter for further consideration on 12th August. In the meantime, what are you all proposing? Since it has been terminated, I do not think the petitioner cannot work anymore. So whether penalty can be imposed or not, that will be the only thing that can be done. Otherwise,
your lordship will
show cause. After the show cause, the termination has also been issued.
Now, your lordships will consider, not of course not during the pendency of the writ petition. Not what is the interplay of rule 2 and clause 2 and clause 3. Clause 2 clothes the government with power to levy compensation, and clause 3 permits the government to terminate only in the event of such compensation amount exceeding or equaling to the security deposit.
Now your condition is such that you want to quit.
I wanted to. They said you can't. If I can't, then I have to execute.
This is what I was thinking, whether the petitioner can be put on terms and you can proceed with the work. Because if you terminate the contract as you have done, you have to find out a new contractor. You have to float a fresh tender. That is going to cost money and that is going to take a lot of time. So if you can put the petitioner to terms and continue with the work, choice is yours. I cannot say anything. It is also up to you to see whether you will be able to work with the terms and conditions that they will put. They may put. I do not know. But since it has already been terminated, without deciding the termination, you cannot be permitted to work either. This is the difficulty.
But of course not, the executive has to take the decision in terms of their executive action.
Right. The court will certainly not take a decision.
Not the I am only challenging the decision making process of the executive apropos the terms of contract which binds both the parties.
What would your client intend to do? I can adjourn and I have already adjourned. But in the meantime, you can take a decision.
It's on record that they want this university to be at least constructed before the next assembly elections. So that's on record.
If that be so, and if your contract is terminated, getting a new contractor and proceeding in the work will cause subsequent delay.
Also contains certain clauses which, in the eventuality of such a thing happening, they can carry on with the existing contractor even. Now, those terms are there at page 39. Your lordships must have seen that. But I just indicate to your lordship. 39A was the termination clause.
Yes.
B is to employ labor paid by the PWD and to supply materials to carry out the work or any part of the work, debiting the contractor with the cost of labor. So that means carrying on with the existing contractor. And that's why the power.
As the authority intends to complete the project in a time bound manner, immediate termination of the contract of the petitioner may lead to further delay in completion of the project, as the authority would be required to find out a fresh contractor to conclude the remainder work. Actually, to conclude the unfinished work. Stop. Next. The in that case, the authority can revisit the issue of termination, and if the petitioner is interested to proceed with the work, the authority can direct the petitioner to conclude the work in a time-bound manner. Nothing more. I will not say anything more.
Grateful.
Supplementary is taken on record. Affidavit of service is also taken on record.
One last submission, but if it could appear with some precedence on the returnability.
Yes, it will appear as urgent motion only.
Grateful.
Can you come up with your reply prior to that date so that it can
Trust out.
Yeah.
My learned friend hands over an advance copy to me so that I can prepare it within a day's time. Okay.
Will I make it returnable on the 7th of August?
My lord. 7th of Copy দিয়েছো? Copy দিয়েছো না?
Item number 4. Lord, I beg to appear on the petitioner, my lord. And this is my my lord report.
But on the last occasion, my lord was pleased to direct them to file a report, and liberty was given to the petitioner to file an exception. But I have received the report on the Friday after.
So exception is not ready?
Not
Why?
I have received on Friday afternoon. They are supposed to file within 2 weeks, but they are filed on the Friday, last Friday only.
Report in the form of affidavit on behalf of the respondent number 3 filed in court today is taken on record. Stop. Learned advocate for the petitioner seeks extension of time for filing the reply. Stop. Let the reply be prepared and circulated by this Friday.
By this Friday.
1st of August. 1st of August.
I'm grateful.
Released on 11th August.
Dada. I'm grateful. Grateful.
Item number 5 and 6, I am for the person.
You are in person?
In person.
5, I am appearing for the state led by Mr. Galipat.
All right. Yes.
Affidavits.
But affidavits are ready.
All right.
In the two matters, affidavits are ready. Affidavit in opposition.
Give.
Serve them an affidavit in opposition.
Have you served?
I am giving.
Oh.
I am giving. Sorry.
Yes.
What
What is to be done today?
দেখুন তো তরুণ কান্তি দাস ও ওটাতে না না আপনি ওটাতে নেই এইটাতে আছে পুলক
Pradeep, কোনটা থেকে opposition দিলে একটু দেখে দেবেন. Opposition filed in court today is taken on record.
and served
Yes.
on the state and
দুটোই দিয়ে দিচ্ছি.
Give a copy to the petitioner in the other matter.
6.
Yes. Everybody will be served. Acha.
I'm for the state in item number 6.
Yes, copy will be served.
6 আপনি নিন
Acha.
but no one is for item number
reply.
6 item number
He's there.
আপনি পেয়েছেন কপি
দিয়ে দিচ্ছি.
Acha. It will
So
be open
affidavits are
for
complete,
the
madam.
it will be open for the petitioners to file affidavit and reply within a fortnight. Stop. Liberty to mention the matter for hearing before any other bench having determination. Next. Get it done.
Meeting is due.
Five and
It is
six.
due for the last 6 years.
do one thing. Pendency of the writ petition will not stand in the way of the competent authority.
No, only one thing is there, my lord.
Registrar of cooperative
We
societies.
are challenging the maintainability first. That is in the first order, my lord. And second, let them say. Let them say, I will say.
1 minute. The registrar of cooperative societies.
Not cooperative societies, only society.
Oh, it's a registrar of societies.
And only one thing, my lord.
To
They
take a
have
decision.
already filed title suit before the landed court below.
All
Those
right.
suits are also pending.
All right. To take a decision on the prayer of the petitioners for conducting the annual general meeting and for holding the election. Yes. Intimate state, you are there? All right. Take steps. Next. 7.
Where there is a direction, your lordship asked me as a
Were you required to file an affidavit?
Your lordship direction was there.
Yes, give.
I'm sorry. First, see your lordship's order. Your lordship was indicated what is the matter about and
Yes. Refund of 50% of the payment made.
there is no finding.
Conclusive finding that there is any deficiency in service. All right.
Of that, court or
Director.
authority, my lord,
Which page is it?
one can see the order in view
Is the complainant
from
present?
page 48, my lord.
Is the complainant present?
Yes, my lord, I am present.
What is your submission?
My lord, there is negligence, my lord, on the
There
part
is
of the
negligence. But
Kindly,
has the authority come to
yes,
the
my lord,
conclusion?
kindly
The
comes to the
commission?
order first. Page,
48 is the order.
order starts from page 48, my lord. Kindly comes to page 51. I'm just showing the points so it has been noted. Kindly comes to my lord, page 51. Second paragraph. The patient attended KPCMCH on 23rd of March. The sixth line, admission sheet serial number 13, intimation to consulted points are blank, suggesting that senior doctor was not consulted on the day of admission. This is one of the deficiency on their part. Now, my lord, kindly comes to the observation of the commission. That is, my lord, will find at page 54. The first bullet. The surgery of ERCP-induced duodenal perforation is a very difficult and has to be done in an advanced gastrosurgery setup with very experienced surgeon. KPCMCH does not have an advanced gastrosurgery unit, and decision to refer this patient to KPCMCH was not a rational decision. They did not have
This is by the other hospital possibly?
Yes, and they agreed to admit the patient in the first place.
KPC?
Yes, they agreed to. They did not have a proper gastro setup. Despite that, they agreed to admit the patient. They admitted the patient, kept her for around 2 weeks, raised a bill of 7 lakhs, left the patient. The patient died immediately on the day after she was released. And now the reason why the commission directed 50% of the treatment cost, my lord, kindly comes to page number 55 once. The last paragraph. In course of hearing, we also felt KPC should also reconsider the issue as to whether they would refund substantial part of the treatment cost in view of the observations of our esteemed members and have in course of hearing. Mr. Karmakar representing KPC was candid enough to agree to have reconciliation on such issue. They agreed to that in the first place. They failed to come to any solution. That is the reason the commission orders, sir. When it comes to the next paragraph, while judgment has been under preparation, the commission has received a mail dated November 2nd, 2023 from KPC informing that despite best efforts, they could not resolve the issue. In such event, we deduct 50% of the total cost. This is basically the reason the negligence on the part of the KPC is, the petitioner is, they admitted the patient despite the fact that they did not have the proper gastro setup. That is also one of the points they noted. Moreover, they send on the second last paragraph, the last line, they send the case to KPC where there is no proper gastro setup. They have sent the patient to KPC, that is good enough. They accepted the patient despite not having proper gastro setup. That is what the negligence lies, my lord. And during hearing, they agreed to reconcile on that issue, but they did not come to a conclusion.
Consent that yes, I will reconcile.
Means I will try to resolve the issue.
Yes, they fail, and that is the reason they directed. And
Consensus could not be arrived at.
that
Consensus with regard to the quantum
yes,
be refunded.
that is the
In course of hearing,
What the patient has died, there is nothing more to reconcile.
a substantial
else
part
can
of the
you
treatment
reconcile?
cost that is clearly there.
left.
The patient has already died.
Right. If my lord,
What type of reconciliation could be done in such a case?
My lord, it's clearly written. My lord, kindly comes to the paragraph once, page 55, last paragraph. Would refund substantial part of the treatment cost.
why? I'm asking the question to myself.
Because
The authority has also not come to a definite conclusion that there is negligence on their part.
that is
If you do not have a setup and you admit a patient,
I have to. If a patient comes, my lord, if I don't admit, again there is a negligence.
no.
you admit and you release, that is okay. You trace the
You
patient for
say
around 2
it
weeks.
is not possible. I do not have the setup. You
Yes.
Admit and treat basic treatment. I could not understand.
basic treatment for 7 days so that the
No,
person dies.
15 days, my lord, 15 days.
15 that is not the finding.
No, fact says.
You add,
Kindly come to that. The less,
No,
less-
compensation is different.
yes.
that is the compensation.
Compensation is
If it
different.
compensation, that includes the charge as
You
we
admit
receive.
the patient, you treat her for a few days and you leave her, that is understandable. You for 2 weeks you can't just admit it saying that I'm just treating the patient when
If
you
this
don't
is
have the
the
proper
salvage
gastro
that
setup.
is being given out to the patients, then so many more cases will come up. Either you improve your setup so that all type of patients can be admitted and given proper treatment. Otherwise,
And no hospital can say I am fully equipped.
If the patient would have alive, my lord, I would have understood. She died the very next day.
15 days you keep a patient, and this is what the doctors say.
I repeat, my lord, kindly see any finding against me.
Yes,
These are
there
the
is
findings.
finding.
There are a lot of
Enough
findings. my lord.
finding
That is
to.
up to my.
Yes, because
There is no finding against me.
please come. If you were in
I
opposition,
cannot think, my lord, this is not the case that we have overcharged.
The question is
No, that
negligence,
is-
my lord. The question is negligence.
that is different. That is different. Overcharging is different. It's a different issue. কি বললাম? Filed by the না এটা কি হ্যাঁ না এটা অপোজিশন না রিপ্লাই এফিডেভিট বলে ছেড়ে দিয়েছে পিটিশনার দিয়েছে তো রিপ্লাই হবে এফিডেভিট বাই দি না whose document is this? দেবজ্যোতি ভট্টাচার্য?
My lord directed me to file an affidavit.
Yes, it's a
charges.
hospital. আচ্ছা তাহলে the affidavit filed by the hospital.
My lord, ask for the charges which were.
All right. Is taken on record. Stop. The petitioner is aggrieved by the direction passed by the West Bengal Clinical Establishment Regulatory Commission to refund 50% of the treatment cost to the next of kin of the deceased patient. Stop. According to the petitioner, there is no finding of negligence and the commission ought not to have directed refund. Stop. On a perusal of the impugned judgment, it appears that the commission has recorded that the patient attended the hospital on 23rd March 23 at 8:16 p.m. And the initial clinical impression was of severe acute pancreatitis and duodenal perforation with AKI was made. Stop. The patient was admitted and a number of investigations were made. The attendance sheet, serial number 13.
Admission sheet, my lord.
Admission slip, attendance, admission sheet, serial number 13. The consultation points were kept blank, suggesting that the senior doctor was not consulted on the day of admission.
This is, my lord, the opinion of one of the experts, one of the members.
My lord is dictating the order. Why are you?
The observation recorded in the impugned judgment mentions that the surgery for ERCP induced duodenal perforation is a very difficult one and has to be done in an advanced gastrosurgery setup with very experienced surgeon. Stop. The hospital does not have an advanced gastrosurgery unit. The doctors have opined that the outcome of the treatment may have been different had the patient been referred to a better center. The case was also decided to be referred to the West Bengal Medical Council to assess whether correct line of treatment was followed on the patient. Stop. The members on the panel of the commission were of the opinion that there had been a bile duct injury at the time of doing the procedure at the earlier hospital where the patient was taken. Stop. The earlier hospital could not identify the problem and made the situation more complex. Stop. Even after laparotomy at the hospital, the problem could not be taken care of. The medical members were of the opinion that it was a case of post-surgical complication that could not be effectively taken care of. The exact reason for the death of the patient was, however, not identified, and it was observed that an investigation by a body of expert was required to be done. The doctors of the team expressed strong displeasure in how the patient was treated. Paragraph, at the time of hearing, the commission gave one opportunity to the hospital to reconsider the issue as to whether a part of the treatment cost, whether substantial part of the treatment cost could be refunded, to which the representative of the hospital agreed. Stop. A conciliation was sought to be made, but the same failed. Stop. Under such circumstances, the commission directed the hospital to refund 50% of the total cost, amounting to rupees 3,43,706 to the next of kin of the deceased patient. Stop. The commission also held that refund of the amount would not debar the patient family to seek appropriate compensation for medical negligence, if any, established before the appropriate authority. Liberty was also granted to the complainant to approach the commission afresh in case they succeed before the West Bengal Medical Council. Clear indication by the member of the commission is that the hospital did not have proper gastro setup. Stop. Paragraph. Learned senior counsel representing the petitioner asserts that had the patient not been admitted and treatment not provided, and treatment emergency treatment not provided, the same would have led to negligence. Stop. Paragraph. In the instant case, it appears that the hospital admitted the patient and treated and provided treatment for 2 weeks. Stop. According to the doctors, the patient ought not to have been provided treatment from a hospital with a better gastro setup. Stop. The doctors are the competent person to assess whether the hospital has a proper gastro setup or not. Stop. The hospitals have opined, the doctors have opined.
There is no finding of the doctors in the report.
Yes, there is.
How they have arrived at that conclusion? That is not there.
The
doctors have opined
that the hospital does not have a proper gastro setup. Stop. Though it has been contended that the doctors, that the judgment does not reflect as to how the doctors opined that the hospital does not have a gastro setup. Stop. The paragraph. Admittedly, the patient was treated for nearly a fortnight, and the specialized doctors opine that the fate of the procedure could have been different had treatment been provided in a hospital with better setup, and it is a case of post-surgical complication, which could have been taken care of effectively had the proper gastro setup been there. Stuff paragraph. The court is not inclined to interfere with the impugned judgment. The writ petition fails and is hereby dismissed.
Grateful, my lord.
Next. Yes. What is it?
My client, my lord, wait till 26 December 2026. Is a lock that has been locked, my lord. His client will wait.
Will wait.
Will not refund the now. He is withdrawing his stand. She shall not withdraw the amount.
Whether the entire amount will be permitted to be withdrawn or not with interest immediately on 29 December 26.
Too late. That is your loss. You ask your client whether she will wait or not.
Yes. No, but then whether the entire amount will be given to you or not was to be replied by the bank. Give a phone call to Mr. Dey. He came in the morning. Give a phone call. I'm passing it over.
Yes. Last day also the info over phone.
Yes, yes. Call him, he'll come.
Yes.
On the last occasion, your lordship directed us to file a report in this matter, my lord. We have prepared the report. May we file the report, my lord?
File the reply, maybe a copy given.
Well, we are giving a copy, my lord.
Well, I appear for respondent number 6, MSTC Limited. Our only submission is we have conducted the auction as per the directions of the authorities. We are just an e-auctioning platform over here.
Your lordship, the time to file my rejoinder may be extended, your lordship.
That may be extended, but what is the immediate relief that you're seeking?
Your
Cancellation of the bid.
Your lordship, they have, your lordship, I am seeking that my money, which is lying with the respondents, be returned with interest. Why, your lordship? Because, your lordship, after the auction, your lordship, they were supposed to give delivery within 60 days. They held my money for 8 months, and then by one liner, they cancelled the sale in my favor. They were holding my money. They're still holding my money. I'm asking for refund with interest. So, your lordship, that was being opposed by my...
You are not aggrieved with the cancellation?
Your lordship, I'm aggrieved with the cancellation. But if they say that they have already sold it and third party has lifted the goods... Now,
auction has already been held. This is what the authority says.
Lordship, delivery order has been issued.
In spite of informing them that we have preferred a...
What will happen to the money that you collected from the petitioner?
Money is with the respondents 1 to 5, Lordship. I'm just the e-auctioning platform. I do not hold anything.
Your lordship, your lordship.
Oh, 1 to 5.
Represented by me.
1 to 5 is different.
5 is a
authorities.
Is the warehouse. The auction, the...
Number 6 is working under me. It is a platform on which the auction is conducted.
Right. Now, who has the money? 1 to 4.
Yes, we have the money.
You have the money. What will be your answer to the refund? Have you mentioned anything in your report?
So far the refund is concerned, if your lordship kindly comes to paragraph 13.
Yes.
We have disputed the interest part, and so far the refund is concerned, we have stated very clearly. However, the custodian is ready to refund the deposit amount paid by the H1 bidder, that is Messrs. Sri Ganesh Traders, upon submission of requisite document to the department.
What is the requisite document?
They have to, the credentials and all those things, if they want to contact the office.
At the time of accepting the money, you did not require credential. Now, when you want to refund, you want all types of documents. What is this?
No. If your lordship kindly comes to page 43 of the writ petition.
43, yes.
43 of the writ petition.
Yes. Yes.
Here, this is the letter written by the petitioner to the manager container freight station for refund, and our communication to this is at page.
Interest at 1% per week.
Interest, they are not entitled to interest because they have failed the conditions for the.
Where is that?
They have pollution control check. They have failed. There was no pollution control. There was a pollution control check. They were required to submit. They failed to do so.
There is no
Now,
clause in the contract, Your Lordship, regarding pollution control. Your Lordship, after 8 months of sale,
if Your Lordship kindly comes to page 27, these are the conditions which have to be complied with.
Your Lordship, on the last occasion.
1 minute. Do not interject at each and every stage.
I'm sorry.
Yes.
Any NOC, page 27,
Yes,
Lordship
yes.
kindly comes to the middle portion.
Yes.
The para starts with
26.
any NOC.
Huh?
Any NOC required by custom authority during assessment of customs duty for plant quarantine department, PPQ, BIS, FSSI, DGFT license or any other NOC required by customs. Only the successful bidder itself will make arrangement for the same from the concerned authority and submit to CWC before deposit of custom duty by CWC and further issue of final delivery order by CWC.
This
Portion-
the
this
petitioner
they have
for-
failed. These they have not complied with.
Not complied.
Yes. Now,
Please.
portion money deposit will be
Please
included.
come. May I make one submission, Your Lordship, in response to this? Your Lordship, here, Your Lordship, PCB, pollution control certificate is not sought in this paragraph.
Acha.
Now, Your Lordship, in the subsequent auction which they have floated, they have
Any other NOC is
stated
very clear.
Appears
PCB, Your
from the
Lordship. May I
submission
just
made
hand-
on behalf of the parties that the petitioner's bid stood cancelled because of non-fulfillment of certain conditions. Stop. The petitioner seeks refund of the bid amount along with interest. Stop. The Customs Authority has filed an affidavit before this court disclosing that the custodian of the money is ready to refund the deposit amount paid by the petitioner upon submission of requisite document to the department. Stop. Where is your dispute regard to the interest?
Yes. Lordship kindly comes to
The authority has denied the issue of payment of interest as the petitioner was himself unable to submit documents on time. Paragraph. As the authority is agreeable to refund the principal amount, comma, it will be open for the petitioner to collect the same. Stop. Paragraph. Acha, collect the same on compliance of the necessary formalities. Stop. As regards interest,
para 30.
comma, the same has been disputed by the authority. Stop. Such disputed question of payment cannot be adjudicated by the writ court. Stop. Accordingly, it will be open for the petitioner to approach the competent forum for resolution of dispute in accordance with law if so advised. The writ petition stands disposed of.
Grateful, Your Lordship.
Next.
Grateful. Grateful to your Lordship.
Item number 10. Your Lordship directed me to file an exception to the objection filed by the private respondent. This is regarding Clinical Establishment Act. I seek only 15 days time.
15 days?
7 days at least.
What does this bargaining mean with regard to the time?
Only 7 days. It is the fault of my client, because he could not able to come from Katwa.
Reply.
Only.
What is the issue? Let me see.
The compensation has been awarded. Of
Sum
5
of
lakhs.
rupees 5 lakh.
Yes.
Post-surgical complications. The
Was more than 2.5 years after the surgery was conducted. Complaint lodged was after 2.5 years after the surgery. No complaint was lodged by the petitioner before the doctor. According to who performed the story was made up by the petitioner.
after the surgery, a foreign part was found inside the
a gauge.
That was retained by the.
That was written by the doctor.
Yes.
No.
That was actually found.
Actually found for such reason. That is the observation, page 42 of the.
I don't have the brief today with me. My clerk's father is in hospital.
It's a serious issue.
Yes, I will. Definitely I will demonstrate. This is only.
Private respondent is a farmer, my lord.
3 bighas of my lord agricultural land, my lord. He sold out this land, my lord. I have stated my lord affidavit, my lord.
For
and my lord,
treatment?
for treatment,
Yes,
my
my lord.
15 lakhs, my lord, more or less, my lord.
Acha, আসুন তো।
Only for the purpose of gallbladder stone.
Affidavit filed on behalf of the respondent number 3 in court today is taken on record. Stop. The petitioner seeks extension of time for filing the reply. Stop. Released on 18th August. The reply may be prepared and circulated by 14th August.
Today we are on 18th August. I'm grateful.
After a long holiday.
Well, I'm for the minority commission. Well, there is a direction for file a short affidavit. The point, well, the difficulty is, well, only yesterday I received the instruction.
16th of May order passed.
It was extended subsequently.
extended
after
twice.
My prayer. Well, only yesterday I received the instruction. Kindly grant me only 1 day time. Day after tomorrow I shall file the affidavit.
Then the petitioner is required to file an exception.
Yes, that liberty was given by your lord.
Yes, obviously.
Too short point. I don't know whether any exception is required or not, my lord.
For you, opposition is
My-
required, and for him,
Obvious.
exception is not required.
When it's
Why
not
will it be
opposition,
so?
lordship asked me to file the not affidavit only, my lord. You will not allow me to. Well, tomorrow I shall affirm it. Certainly I will affirm it tomorrow.
The Minority Commission once again seeks extension of time for filing the opposition. Filing the
Opposition
affidavit.
or your direct-
No,
affidavit.
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 Stop. The last chance to file the affidavit was extended by order dated 8th July 2025. Stop. The now cost will be imposed.
Well, only 1 day. I am praying for only 1 day accommodation.
Why will that be? What 1 day? Time was there for 18th of July. Today we are 28th of July.
I know. Well,
Then
only yesterday I received the instruction.
that means
tomorrow,
your officer
well,
was.
Tomorrow I shall affirm it. Well, kindly consider tomorrow I shall.
Learned advocate for the commission submits that instruction was forwarded only on 27th July 2025. Stop. On the prayer of the learned advocate for the commission, time to file the affidavit is extended till 1st August. Stop. In the affidavit, a paragraph should be clearly made stating the reason for the delay in forwarding the instruction to the learned advocate for preparation of the affidavit. Stop. The time to file the affidavit expired on 18th July 2025. Stop. The person responsible in causing delay in forwarding the instruction. The person responsible, the name and designation of the person responsible. No. The name and designation of the person responsible for the delay in forwarding the instruction shall be clearly disclosed in the affidavit.
My lord, kindly, my lord.
Why will you take so much of responsibility? Let the officer take the responsibility. Let him take no kindness.
My lord, kindly do not.
There was a limit to show some kindness.
It's my humble request before your lordship. Kindly, my lord. That line may be deleted.
Affidavit in reply
Subject to your lordship's
may be prepared by how soon?
In exception.
Exception.
4 days is enough for me.
All right. By 19th, released on 26th of August.
So far, my part is concerned, respondent
You have already filed.
lordship, but I just only I'm praying before lordship, keeping open up the point of maintainability of the application.
That was possibly kept open on the first day.
There is
no
direction for affidavit.
Kindly delete that line. It's my humble request. Kindly, my lord. Kindly, my lord.
Well, your request is refused, sir. 12.
There was a direction on the part of the private respondent to use an affidavit, but I have not received any copy.
Is private respondent appearing?
Yes.
Yes, my lord. My lord, we are ready with the affidavit of opposition, my lord, may be filed before your lordship.
Why two?
There are two, but common
12
judgment
and 13.
passed by commission, my lord, the regulatory commission, one against mission and one against health world.
So two. Well, the affidavit prepared by the private respondent. Affidavit by the private respondent. Filed in court today is taken on record. Stop. Let copy be circulated.
Very well. My lord, it is served as I am told.
My lord, they have sent me by post and I have not
The
received
council is here and you sent it through post. Time and money, both gone. It will be open for the petitioner to file a reply to the same. Reply. Affidavit in reply হবে কারণ affidavit in opposition হয়েছে ঠিক আছে আচ্ছা
স্টেট লিখলাম দেখো তো
and then hearing
My lord, they have mainly raised 3 points.
whatever it is, it has to be heard.
But my lord,
I would be praying my lord 2 weeks time my lord because there are 2 read petitions to
Yes, আচ্ছা reply দেবে কিন্তু by 22nd August.
my lord,
Liberty to mention the matter for hearing before any other bench having determination.
my lord, only one innocuous prayer. My lord, we are before your lordship to adjudicate whether or not to pay compensation to a newborn who has lost her mother. Now, my lord, they have preferred this writ petition just to avoid paying the compensation. If that be so, they could have paid something
absolutely
and come
questioning
before your
the
lordship.
decision making process of the commission.
Why don't you pay it to the
No, my lord.
registrar? Let it be
They are
kept.
2 private hospitals, giant
Let it be
private
kept with the
hospitals, and
registrar.
compensation amount
I
is
shall
5 and
deposit
10.
it before the learned registrar of this court. Lordship would grant me a stay of operation of the order.
No.
Because my lord, the commission will
All
be
right.
executing.
If you pay with the registrar, then stay.
But I am agreeable to it.
The petitioner is directed to deposit the amount directed to be deposited by the commission before the learned registrar general of this court by how soon?
2 weeks.
Acha, by 14th August. ঠিক আছে? The registrar general shall invest the amount deposited in short-term fixed deposits bearing interest. Stop. The fate of the money deposited shall depend on the result of the writ petition. Stop. In the event the sum is deposited as mentioned herein above, comma, the direction passed in the commission shall remain stayed. Stop. To ascertain as to whether payment has been made or not, comma, release the matter on 19th August 2025 under the heading to be mentioned.
25th August, Lordship fixed. So there is a direction of 2 payment has been mentioned. One is compensation 10 lakhs, another one is 5 lakhs,
5 lakhs
by health ward. So
whatever
it will be 15 lakhs. My lord, I shall deposit it into against 2 separate petitions.
Yes.
I'm grateful, my lord.
At least
My lord, only এটা তো পরেরটা তো 13. Yes, yes. These 2 identical matters, my lord.
12 and 13.
12 and 13 are same matters.
Only different hospitals.
Different hospitals.
This is 14.
My lord, affidavit is served.
Yes, it is served. Yes.
Both the cases.
Yes, your
I'm
Your
grateful,
Lordship,
my
I will peruse your Lordship's order dated 7th July, and particularly paragraph 3 and 5.
My lord was pleased to file a report. My lord, kindly pass it over. My lord, report is with me. My lord,
It's coming.
No.
All right, passing it over.
Pass it over.
Yes, call the next one. 15?
Yes, Lord, I appear on.
Yes.
Lord, last occasion. Lord, last occasion, there was a direction passed by your lordship to take the instruction of the state authorities upon the state authorities that they will pay the excess tax amount, Lord, that GST issue.
Obtain written instruction from the state authority.
Has any request been forwarded?
Yes,
That is.
My lord,
yes.
it was informed.
Hmm.
She kindly give some more time so that I can come back on the next day, my lord, with the report in written instruction.
And because of the delay, is the petitioner required to pay extra charges or something?
There is a penalty. Already it has been imposed.
Whatever.
Day by day, my lord, day to day, it is.
Whatever already, my lord, that is my lord, the cause of action. He has filed the writ petition. After that, my lord was kind enough to pass this order. Now, my lord, that order was passed. We have to comply with lordship's order. Only give some more time, lordship. There may be
No,
some
because of
communication.
the delay.
There may be some communication gap. Lordship kindly consider. She kindly, because if he is entitled to, then
What is the stand of the authority?
My lord, I have already, my lord, actually, my lord, we have already wrote to the, in the, on 30/10/2024.
না, ওই চিঠিটা কি ওদেরকে
That
দেওয়া
is
হয়েছিল?
the
That has been handed over to my learned friend.
that is the impugned communication or something. Aja, please come, learned advocate representing the state respondents. Seeks extension of time for taking instruction.
আরে না, এই চিঠিটা তো ওনারা কোর্টে দিয়েছেন আমাকে।
হ্যাঁ, দিয়েছি।
সেটা জানিয়ে দেওয়া হয়েছে।
No, this was handed over to the DM on 30th October 2024 when we have faced the problem. We have wrote.
So there must be some reply from the DM.
Yes,
No,
yes.
nothing. Till date.
That is why when this letter they disclosed before your lordship on the last occasion,
Yes.
this was not the, my lord, the annexure to the writ petition. This, just a minute. This letter was, my lord, for the first time disclosed before your lordship on behalf of the respondent number 2.
No, it was not disclosed.
Who floated the tender?
Last occasion, it was not disclosed.
Yes, my lord,
I have
forwarded a request for payment and the same is pending. It was this, but then what is the request? But the request is here now. Let me see a copy of the request. This is the request letter.
Yes, 30th October 20.
Right, so let me see. Dekhi, copy ta dekhi. See, 30th of October, the request was made.
Yes, that I have submitted just now, my lord.
If that be so, what is the reply of the magistrate?
Lord,
Something has to come.
Lordship, kindly give me some more discovery. I shall come back with the.
Ajay, please come. Learned advocate kere din. Learned advocate representing the respondent numbers 2 and 3 has produced before this court copy of the request letter dated 30th October 2024 addressed to the district magistrate Malda.
আমাকে একটা কপি দেবেন ম্যাডাম, আমাকে একটা কপি দেবেন।
With request for payment of additional taxable values of the executed works due to enhancement of GST rate from 12% to 18% with effect from 18th July 2022. Stop. Next. Paragraph. Learned advocate representing the state respondents is directed to produce the reply to the aforesaid communication dated 30th October 2024 from the end of the district magistrate Malda. Stop. When do I keep it? Next Monday? Tuesday?
Lordship, kindly give me 10 days time.
10 days?
Lordship, kindly. Because, my lord, to get rid of all any further problem, my lord.
List on 12th August.
12th August, my lord.
Your Lordship, in this matter, I appearing on the behalf of the petitioner, Your Lordship. On the last occasion, Your Lordship passed in two direction. One, SDO to file a report, and second, the notice upon the officer in charge, Chinchura Police Station.
Lordship, last occasion, Lordship directed me to file the.
Why steps were not taken despite receiving representation? What does it say?
Lordship, report says that the application is not filed in the proper jurisdiction, Lordship.
Where was it filed?
The present petition is filed in the Chinchura jurisdiction, Lordship.
Where should it be?
Hooghly, it will be filed in the Chandanagar SDO.
Chandanagar
Lordship.
SDO.
She is a resident of Chandanagar, not Hooghly Sadar.
Who is the resident of Chandanagar?
Lordship, see page 40, Lordship. Previous, the order was passed under the Chandanagar SDO.
Page 40.
40.
Very well. This could have been intimated to the lady.
And that is also not in a proper form, Your Lordship.
What is the format?
That is Form A, under the according to Rule 4 of the West Bengal Maintenance and Welfare Parents and Senior Citizen Rules. Your Lordship. That is also indicated in my report, Your Lordship.
Page 43. Page
40.
40.
40. That is the previous order passed under the jurisdiction of the SDO Chandanagar.
Where does the lady stay?
Your Lordship, he resided in Chandanagar, and the order was passed by HDO Hooghly, not HDO Chandanagar. Kindly come, Annexure P5, page 40, Your Lordship.
Can you see?
SDO Chandanagar District Hooghly.
District Hooghly, Your Lordship.
The subdivision is Chandanagar.
Subdivision in Chandanagar at the office of the district magistrate HDO in the Chinchura. Kindly, my representation, Your Lordship, kindly come. My representation. HDO Magistrate Learned Component Authority under the Maintenance Welfare Parent Act, Office of the District Magistrate, Post and Police, Chinchura, District Hooghly, PO 72101. At the office of the district magistrate of the Hooghly, I have served to the concerned SDO.
But that is too
Very well. Now, did your
different
officer?
SDO, Lordship.
1 minute. Now, has the proper person received this?
Lordship, they received it. What
Proper
appears,
person?
What is appears from the report, Lordship.
Now he has received?
Received, Lordship.
Who
And
has
the matter
given?
is also your Lordship.
In my report.
1 minute. 1 minute. This has come from the SDO Shodor Hooghly.
Lordship, my lord.
Right. But such order is. Please come. Peruse the report filed by the subdivisional officer Shodor Hooghly. Undated report, which mentions that the matter is to be decided by the subdivisional officer Chandanagar, within bracket Maintenance Tribunal Hooghly, as the petitioner resides in the Chandanagar subdivision. Stop paragraph. According to the authority, the petitioner has submitted the representation before the SDO Chinchura.
Hooghly, Sadar Hooghly. That is the designation, Lordship. SDO Sadar Hooghly.
আচ্ছা Chinchura না সদর হুগলি. The SDO has also mentioned that the application claiming maintenance has not been filed in the proper form. Stop paragraph. The petitioner is directed to file a proper application according to Rule 4 of the West Bengal Maintenance and Welfare of Parents and Senior Citizen Rules, 2008, before the appropriate authority.
Your Lordship, may I interrupt one thing?
Stop. In the event the same is filed, the same shall be considered by the competent officer in accordance with law at the earliest. Writ petition disposed. Give a copy to your learned so that
Your
you can take
Lordship,
steps.
the matter is still pending. I filed a substitution application.
Your matter is filed before an authority which does not have determination. So it is non-est. It has to be taken. Call the passover matter.
Spy matter.
I'm for the respondent, madam. For private respondent.
Why were you not there? Your client was addressing the court.
Yes, apologies, Your Lordship. My on record could not be present. My client had to come.
There is a request for extension of interim order which has been opposed by the private
Yes,
respondent.
I'm also opposing, Your Lordship.
Yes, why?
Your Lordship, the pleadings are all completed. Affidavits are completed.
Right.
It's ready for hearing, Your Lordship.
Right.
However, the state respondents has not yet filed the report. On last two occasions also, Your Lordship has granted liberty to on them to file a report. They haven't.
Report report. State has filed a report.
State has filed.
Yes, madam. And at least we have been served with
All right.
the exception to the report and the reply.
We have not been served a
You have
copy.
not been served with a copy. What is the issue?
It's a very small point of law.
Very short issue, milad, that whether MSME tribunal has jurisdiction in respect of a contract, particularly when it was not registered under MSME at the relevant point of time. We have the document annexed from which we can demonstrate. Kindly take some.
What does the what is the stand of the state?
They says, they says that yes, so far this jurisdiction is concerned, they have not specifically stated anything.
If this is the issue and they have not stated, who has? Why are you saying that the private respondent
page 26 once
of the writ petition?
Of the writ petition.
Please give an intimation to the learned advocate for the state.
Yes.
Page
26.
Yes.
This agreement was executed on 22nd March 2019. And on the very next page, second paragraph, contract was for supply, third line.
Yes.
Now, if you kindly takes up page 58. Private respondent was registered as MSME milad.
Yes.
Page 58 milad.
2015.
This was for manufacturing at the top milad. First, second MS so micro and this financial year then for manufacturing. And the kind of see then at the bottom of the date of registration 22nd March 2022. That is after the agreement was executed. The formula at the relevant point of time.
No, agreement was in 19.
19.
And 15, the MSME registration is there.
No. This is in 20. Can you see page 58 at the bottom.
Yeah, in the middle, it is mentioned the 26th of June 2015.
That is for manufacturing. No. Just a second, minute. 58.
When were you registered as MSME?
My learned is right. The registration is at
page 53 of their own statement.
Oh, date of registration is 20. All right, 22nd of March.
Yes.
All right. Yes.
That is an admitted fact, Your Lordship.
All right. Yes, then.
Yes, page 53 they have admitted that. Now, therefore, at the relevant point of view, it was not registered as MSME.
All right.
And therefore, MSME tribunal has no jurisdiction. That's my case.
My case is somewhat different, Your Lordship.
If you want to invoke the jurisdiction of MSME tribunal, you must have registration
That is not
at the relevant point of time.
That is not the law.
At the time of the contract, initiation of the contract.
And this is the judgment of 2023 of Supreme Court, which also is decides this issue, my lord?
Yes. Which portion?
52.6 is the decision, conclusion. 52.6 is the conclusion. A party who was not the supplier, as per definition contained in section 2N of the MSME Act on the date of entering into the contract, cannot seek the benefit of supplier. But I have shown to your lordship that it was not even registered as a supplier, rather as a manufacturer. Therefore, even today, they are not registered as a manufacturer supplier. And it is their own admission. That's my case.
All right. What is your submission?
Yes, my submission, Your Lordship, it's an admitted fact that the registration was done in the year 2022. How
As supplier
the
or manufacturer?
as supplier, as supplier.
It's mentioned manufacturer. Where is your supplier registration?
Their own date is 2022.
Their own date is also 2022, Your Lordship. My learned friend has also submitted that the date of
As manufacturer. Where is
I'll provide the Uddam registration for as a supplier, Your Lordship. But it's the same date, Your Lordship.
all right, same date then?
My submission is that even after registration, the supplies has continued, then MSME jurisdiction is there. I have brought judgments also on that.
Please show.
Yes. Also from documents, Your Lordship, I will show he supplies has done pursuant to registration. First, I'll indicate the page numbers. Your Lordship would see page number 78. It's the agreement. The agreement starts from page 78. Page 77, Your Lordship would see the invoice.
Yes.
Invoice?
23.
Yes, 23.
26, 2nd of June 2023.
Your Lordship would also see page 132.
1 minute, 77.
Page 132, this is a letter from DGP and State Police Chief Kerala.
Yes.
This is dated 7th March 2022. From there, the letter started, and as per the letter, the last para, page 133, hence it is directed to you to furnish the date by which the project would be completed by your company. Keeping in view of the timelines associated with the project, the date of completion should be furnished earliest. So the project was still continuing. Next page, Your Lordship, page 134. The committee meeting concluded on 4th May 2023. Thereafter, next page, equipments across police stations. The field trials, Your Lordship, the first para after C, the field trials should be conducted for at least 14 days. Commissioner of Police will ensure before the trial commences 3 to 4 days of extensive lands-on training is provided to.
Is it the same project which is mentioned in page 26, the agreement, it continues?
It continued.
All right.
Thereafter, Your Lordship would see the focus of the field trials to ensure there is network redundancy throughout the district. Thereafter, the Commissioner of Police will submit a detailed report after completion of field trials latest by 31st May 2023. So these are continuing. The project was still continuing. So, Your Lordship, I'll place two judgments.
Yes.
Thing.
This is of Delhi High Court, Your Lordship. Your Lordship would come at page number para 17, Your Lordship. The apex court in Mahakali Foods, after noticing paragraphs 42 and 43 of judgment passed by apex court in Silpi Industries, held that even any registration is obtained subsequently, the same would have effect prospectively and apply to the supply of goods and rendering services subsequent to the registration, and this issue could be decided by the Facilitation Council as an arbitral tribunal under the MSME Act. Paragraphs 51, 52 of 52.6 of the judgment passed by Apex Court in Gujarat State Civil Supplies Corporation Limited versus Mahakali Foods Private Limited reads as under. Following the aforestated ratio, it is held that a party who was not a supplier, as on Section 2N of the MSMED Act, on the date of entering into contract, could not seek any benefit as a supplier under MSMED Act. A party cannot become a micro and small enterprises to claim the benefit. The same cannot operate retrospectively. However, such issue being jurisdictional issue, if raised, could also be decided by the Facilitation Council acting as an arbitral tribunal under the MSMED Act 2006. So this issue, jurisdictional issue, has to be decided by the Facilitation Council itself. And secondly, it's already been stated that even after registration, if the supplies are being continued, then MSME will have jurisdiction. Lordship, the next para 18. The same view has been taken by coordinate bench of this court in Malani Construction Company versus Delhi International Arbitration. The ratio of these two judgments is clear to the effect that if the registration was obtained subsequently, the benefits under the said act would not apply. Even in a situation where portion of the goods services are supplied prior to registration and are supplied post registration, the act would apply. Depending on the facts, the goods and services which are supplied subsequent to the registration. Next para, Your Lordship.
Yes, I've followed it.
No, one line, Your Lordship.
I have read it. Tell me one thing. The contract which you entered in 2019 is an ongoing one. Has it concluded or is it still continuing?
That I have to take
Maybe. Now from 22 onwards also certain manufacturing or supply, whatever goods were given. A proceeding is pending before the tribunal. Did you raise this issue over there?
Arbitration was referred, but
to
it
me,
was
lad,
told. Then only it was told.
The judgment of 2023 says the date of execution of the agreement, not the period of contract.
You are trying to take advantage of this and not making payment or raising dispute with regard to payment. There may be disputes, no issues.
There are disputes. In fact, we have offered them to sit with us so that
that is between y'all. The court is not entering. Thing is, after the date of registration, the works or the goods or the supplies, whatever is
pursuant to that contract,
will fall under MSMED.
That is not the law.
This is what.
That is the interpretation of Delhi High Court.
No, relying on Supreme Court judgment.
No, that judgment I have referred.
Yes.
The judgment I have referred.
But did you raise this issue?
The same judgment. The same judgment that I have referred has been quoted there.
Yes.
But has been misinterpreted. And in fact, but the ratio of the judgment, which has not, Delhi High Court did not refer, paragraph 52.6, which I have shown to you.
It is. 51, 52.6 is also there. It is quoted.
52.6.
Yes.
52.6 speaks of that a party who was not a supplier, as per the definition contained in 2N, on the date of entering into contract, cannot seek any benefit of supplier. As of
thereafter, if any
registration is obtained subsequently, the same would have an effect prospectively.
Which means that from then onwards,
as of now, what we have with us, that they have applied on the basis of a registration that we have annexed. That document shows that it was registered as a manufacturer in 2022, not even a supplier. Therefore, as a supplier, he cannot take advantage of this act. This is first part. Second.
So that the learned counsel will provide.
Second, the prospective effect would be not in respect of the contract in question.
The contract will continue for 10 years and he will not get the benefit under MSMED.
That's the law.
No, that is not the law, sir. You are interpreting it
again,
in the wrong way.
Again, may I read? If any registration is obtained subsequently, the same would have an effect prospectively. What does it mean?
prospectively and would apply to the supply of
goods and
goods
rendering service subsequent to
subsequent. It is very clear that after registration, it will get the benefit.
Now,
Let us show that the registration as supplier is there.
as of now.
Obviously.
Let them produce an affidavit, document,
I'll
filing an
produce
affidavit
the document on the next day, Lordship.
as a supplier. Then,
Supplier, then only
and even with the ratio of Delhi High Court is
to the ratio, your Gujarat is very clear. The judgment that you are relying upon, the Gujarat is very clear.
on the that tribunal will decide the jurisdiction.
Yes.
That's the ratio.
Yes.
That's the ratio.
Did you raise this ratio, this issue over there? You didn't.
That's my point, that I do not want to submit to the jurisdiction which has no jurisdiction.
But the authority has a jurisdiction to decide its own jurisdiction.
Paragraph 68. Paragraph 68 of this judgment,
This
of
means
Gujarat. Yes.
Yes.
SLP was from that judgment only. Kindly see. Para 68, Yes. This is from Bombay High Court 68. All these writ petitions were placed before the Supreme Court, and thereafter this judgment was passed.
Yes. Where is the difficulty? It's all right. The Supreme Court lays it very clearly that subsequent to the registration, the tribunal can decide. Does your client have? Does your client have the certificate, MSME registration certificate?
I am.
Sure. After recess, please bring.
Prospective may not have the meaning of
No, it's very clear.
But I may
interpretation.
I may come up with at 2 p.m. fixed matter fixed matter.
Then keeps it tomorrow.
Then tomorrow. No order today. Till when is the interim order valid?
31st.
Then you have time. Come tomorrow.
Let them supply a copy by today, so that I can come back with a.
You are doing business with the private respondent and you have not kept a copy.
The copy that they have supplied, I have annexed.
You do not have another copy.
No.
Give a copy. Yes, call the other passover matter, please.
Passover matter. Item number 8.
Nobody is here. There is another passover matter.
Item number 14.
Yes.
In my I beg to upon the respondent.
Got a copy?
Yes, madam.
We'll give a copy to your learned senior friend.
Whereas petition is not there. Petition.
What does the inquiry report say?
He's saying that once the registration was completed without any order of the court, my lord,
it cannot be
it
cancelled.
cannot be done, and he has not got jurisdiction to entertain this.
And relying upon which law are you seeking cancellation?
My lord, your lordship, kindly come to my page 11 first.
Yes.
My lord, the person who alienated the land, he's one of the co-sharer.
All right.
The certificate issued by the one of the concerned executive officer of the one of the ministry.
He sold off the whole land in respect of.
Yes, my lord, your lordship, then come to my lord, page 15.
Why don't you go for cancellation setting aside of the sale deed?
Because that is civil jurisdiction.
Page 15, your lordship, kindly
Page
see.
15.
And then, my lord, your lordship, kindly turn to my lord, page 19.
Yes.
Page internal page 4. But how he described himself
as the sole owner.
Sole owner.
That will not determined by the authority.
Goes into the root of this thing,
no, but then the authority was not supposed to know. He relied upon whatever document is placed before the authority.
At the presentation, my lord, whatever documents is.
Whatever is there, he has done it.
My lord, we proceed this.
Exactly. Why don't you go for
one judge subject to lordship's sanction? But the government is taking care of these type of dealings. Your lordship kindly peruse.
See, it is not for
split into,
the
land, but the IG are also involved in this case. Immediately, he will take action, and my lord kept in abeyance, and all subsequent mutation and all these things should be stopped. But this was the the government notification. Your lordship kindly see.
by submitting fake or forged deed. Here the deed and is not false.
Other things are
And
there.
immediately on receipt shall
Quantum of the land
refer the matter to the registering authority. This is upon a forged and fake deed. This is different.
And my lord, your lordship kindly sees also the provision under the Registration Act, section 81 and 82.
This is what I wanted to see, whether there is any provision or not.
My lord, 82, my lord, your lordship kindly sees an
82.
82 and 81. Impersonation comes within the purview of this.
Intention
And it's a
delivers
penal offense.
falsely personates another.
Impersonation.
This is not impersonation.
But he claimed himself as the 100% owner of the property.
How will the authority get to know this? Now, if this matter is referred to the authority, then the authority will have adjudicatory power, which is not there in the act.
But your lordship kindly sees there is a penal consequence.
Yes.
The 81 and 82 both have the penal the consequences. Therefore, it is the authority has the power to initiate appropriate proceedings.
Penalty for incorrectly endorsing, which has not been done, copying, translating, or registering documents.
And the last,
this is different.
The last provision, my lord. Falsely personate another.
That will be created on criminal jurisdiction.
But falsely
suppose your name is there and your learned friend goes and signs or executes, then it is impersonation. But if you say that I am the sole owner of the entire property, the authority will certainly not know as to who are the other co-owners.
But as soon as it comes within the
No, sorry, please come.
The petitioner may refer it to the concerned.
You have to approach the civil court for setting aside of this deed of sale.
What about the penal consequence?
The petitioner.
Impersonation subject to
that will be possibly after you obtain order from the civil court. This impersonation.
I am appealing for the private respondent, my lord.
What is your submission?
My lord, my submission is other co-owners have subsequently registered me by right.
Subsequently, on the date of execution, where did you get the power? Did you have the power on the date of registration? You didn't. How could you do it?
My lord, other co-owners have registered me.
The petitioner alleges that the private respondent, claiming himself to be the sole owner of a property, executed.
Probably.
Private respondent 8.
And these are the purchaser. Remaining are the purchaser.
Claiming himself to be the sole owner of the subject property, has executed a deed of sale in favor of the other private respondents. Behind the knowledge and behind the consent of the petitioner, who is also a co-owner of the subject property. Stop. The petitioner prays for a direction upon the registering authority to cancel the registered deed. Paragraph. Learned advocate representing the state respondents has obtained instruction from the additional registrar of assurances, 1, Kolkata, dated 21st July 2025, which clearly mentions that the prayer of the petitioner for cancellation of the registered deed cannot be accepted, as there is no supporting law permitting cancellation of registration by the registering authority. Stop. Paragraph. The learned advocate representing the private respondent number 8 submits that the other co-owners subsequently authorized the private respondent number 8 to execute the deed. Stop. Paragraph. As per the Registration Act, 1908, the registering authority has not been empowered with any provision to cancel a registered deed. Stop. The registering authority was unaware of the fact as to whether the property in question was solely owned by the executant or not. Stop. The registering authority relied on the deed that was presented before it and proceeded to register the same. Stop. The Registration Act lays down penal provisions in case of impersonation, and submission of false statement. Stop paragraph. The petitioner alleges that the respondent number 8 deliberately made false statement before the authority solely for the execution of the sale deed. Stop. Paragraph D. Whether the property was jointly owned by more persons or whether the same was the property of a single individual has to be decided by the competent civil forum. Stop paragraph. Next, in view of the above, the writ petition is disposed of by observing that it will be open for the petitioner to approach the competent civil court, praying for setting aside of the sale deed in accordance with law, if so advised.
Till such time, he will not alienate that property. At least it will not.
If this court has no jurisdiction, what can be done? It will be open for the petitioner to pray for interim relief in the suit in accordance with law. Disposed.
Grateful, my lord.
But item number 70, my learned friend is appearing for the private respondent, but he wants a
Yes, your book. And this order also. 17, what?
But my learned friend is appearing for the private respondent. Lordship had directed me to serve a notice. He's appearing.
Yes.
My lord, he wants a copy of the writ petition. I'll give it to him today. Could this matter be taken up day after tomorrow? 31st আমার কোনো আপত্তি নেই।
আচ্ছা ঠিক আছে। Item 17, record an order. Who is for the commission? You are there? Acha. By consent of the parties, release the matter on 31st of July.
Great.
Your Lordship, I am 58.
No, I was applying for the response.
See, now the petitioner is not here. He's coming here every day. Every day he's coming. No, right now it cannot be taken up. It will be taken up serially then. Yes, call.
18, my lord. I am for the added respondent wife, my lord. Your lordship's direction was the,
I'm for the respondent bank, 1 to 6.
my lord.
What is the matter?
Matter pertains to, my lord, your lordship kindly take the order passed by your lordship on 10th of July.
Recalling, include the wife as a serve copy.
Now,
you want the bank?
Yes, I take the facts. If lordship kindly take page 31. Initially, I was posted as electrician in Andaman, working on central government. At that point of time, I took a loan in the year 2021. And I am repaying. EMI already done. Now, in the year 2024, I fall down from the office place. My spinal broke down.
Injury.
Yes. Now I prompted to get the voluntary retirement. I could not work. Accepted, done. Pension started. Only 32,188. Now from the pension account, although it is pension account in my favor, but it has been made jointly with my wife. And sanctioned the loan at the jointly. Took the flat. Staying. Wife is staying now. I am not. Now if lordship kindly take page 31. Salary pension account amount 32,188 and loan is deducting till last before month up to May, it amounts to 26,370. So now I am getting only 5,818. Now since there is a family dispute, one application by my wife before the DV court. DV court awarded expert award of interim maintenance for 4,000. So if 4,000 again goes, well, I have to comply. I have to maintain her by making that payment. Then I am now getting 1,818. So my life is under a stake. Issue is my life is larger than the liabilities now at this. So I made a payer before the bank. Get it liquidated, whatever amount I have paid, get it solved. In the meantime, if I am entitled to get any refund, give this. If not, not. But do not take my 32,000 salary.
Who will take care of your wife and where will she stay?
I shall make payment
What?
of maintenance.
And residence, she is there?
Yes, my lord, I can accommodate if your lordship desires. So.
Where? Accommodate her where?
Rental or my parental house, where I am staying there.
And you will put her in rent and thereafter stop paying rent.
No.
And the landlord will run after the lady.
Your lordship kindly clarify all these things.
I
took that from the instruction from my junior.
You have to come up.
But if I can just clarify.
You can stay with my parental house also. Where I am staying with my daughters. With my mother also.
You are not staying there.
I am staying with my mother at my parental house.
And you want your wife to come over here with whom you are having so much a problem. DV proceeding is proceeding.
Where she chooses, she can, from the bank account of my pension account, it can be deducted for rental. I am taking that risk. I know this. I have to maintain. So I leave it to lordship. What to be done? Your lordship kindly clarify the issues.
My lord, only one
by 1,800, I cannot maintain. My lord, I have made the supplementary affidavit to that extent also.
My lord, one by one, my lord, if I can just place it. My lord, very surreptitious strategy, my lord, to approach this court, my lord. What has happened, my lord, before the domestic violence case where it is pending, he has not entered appearance. My lord, over there for right of residence also, my lord, for the hearing, he has to enter appearance. 80,000 odd, my lord. He's saying that he will clear the dues, my lord. Till date, no dues have been cleared because he did not enter appearance. Process has been issued by the court. I have lodged 498 a case against him. Even over there, evidence is going on. He's not appearing. Now, my lord, these are the two facets. Now, my lord, in a very roundabout manner, my lord, he is trying to evict me from my matrimonial house, my lord, by taking this plea. But what he has not indicated to your lordship is that what amount did he get as per the voluntary retirement scheme, my lord, that he has obtained. He obtained, my lord, about 50 lakhs, my lord, from his VRS, my lord, which he has not disclosed. Now, my lord, in these backdrop,
What is the due? What is the due of the bank?
Lordship, the total sanctioned loan is 24 lakhs 44,000, and till date the amount repaid by the petitioner is 1,93,929. So the outstanding amount is 22 lakhs 50,000 and 71 rupees.
And with
there is also another
interest?
Surakha.
Interest?
Exactly. Accrued interest is 12,961. That is the up to date.
Right. So you
from the bank.
you
And
can
along
repay
with
the
that, there is a
amount?
ring Surakha also.
From selling that property, whatever
By
they
selling, you have enough money in your hand.
no, only 20. I have got the amount of 20 lakhs.
Yes.
It is there.
Right.
So if your lordship desires, I can.
You can repay the bank loan.
But 20 lakhs I cannot. Because
you cannot?
by virtue of that.
You have
plan,
received 50 lakh.
50 lakhs.
Let them
Let them put it on affidavit, my lord.
The outstanding is 22 lakhs 50,000 and
How much did he receive as per VRS?
along with accrued interest of 12,961. And there is also a ring Surakha, that is life coverage, which is 78,000.
What does
Now the
this mean?
The total amount figuring at
What
page
does
26.
this mean? Rin Surakha.
Ring Surakha, that is the life coverage.
So what exactly does it mean?
That is the another loan.
There
That is
also
the another loan. That is the another loan in the form of insurance.
so that the
Receipt of
petitioner
that-
is required to pay premium or something.
Exactly. 78,000 is totally outstanding amount.
Not that. Page 26 is there.
To didin na.
Total amount of loan, it is calculated by bank itself.
Now,
25 lakhs 33,000.
now the
You
petitioner
want
wants
to
to
dispose of the property only for throwing out your wife.
Correction, it is not. It is not.
No.
But may I come back with the instruction?
What
Whether
instruction?
I have the present, how much money I have,
Hmm.
whether I can
Lordship, I
repay
have
by
submitted it.
that amount itself,
Hmm.
or
If you can repay it, the property becomes yours and your wife is staying over there. So residence taken care of.
that I shall take care of. Otherwise, whether it can, if I do not make payment by 3 months, it will be an NPA. They had to go or have to go for recovery of that.
Yes.
It is another way.
Pension account.
It can be
Yes.
also done.
No, you have got the pension account related to the.
That is pension account they have created jointly. It could not have been done. I made a payout also.
No, at that point of time you accepted it at the
I
time of
accepted that
taking
is
the
there.
loan.
That is there.
What can be done?
And they cannot attach my pension account when at that point of issuance of loan, it was a salary account. There should be a
Whatever.
whatever.
No.
I am not disputing all this.
Yes.
Now it has been done. So
You have to file an affidavit as to how you are going to take care of your wife and how you intend to pay off the loan. Both. Thereafter, we will see.
My lord, let there be a direction.
One more clarification in the
Let
affidavit,
them.
how much he received as per the voluntary retirement scheme.
All
That is
right.
that- Let him, my lord, bring it
All
on
right.
affidavit. Because my instructions are he received 50 lakhs.
No.
And my lord, let this, my lord, not, my lord, affect because DB Act proceedings are still on, where he is not entering it.
Nothing
Notice-
to do with the DB.
I have just got the notice in the month of May.
May, now we are in July.
And
Every month maintenance becomes false due. So you are
no,
required to
I
pay.
have to, my lord, I have to.
Acha.
I have to maintain.
The private respondent has entered appearance and submits that the writ petition is a surreptitious way to throw out the private respondent, who is the legally married wife of the petitioner, and married wife of the petitioner, and the relationship between the parties is acrimonious stuff. It has been brought to the notice of the court that proceedings are pending under the provision of the prevention of violence. What is the full name?
Yes, I'm giving, I have annexed that.
DV Act, Prevention of Violence की Act है, of Women from Domestic Violence Act 2005 ना 7 की Act है देखने में. And
Prevention of women in domestic violence.
the year is 2005.
2005
ঠিক আছে, আর তারপর হচ্ছে
domestic
তারপর হচ্ছে and the petitioner has not entered appearance in the said proceeding. Stop. Maintenance amount directed to be paid by the petitioner to the private respondent is due. Stop. Paragraph. The petitioner is directed to file an affidavit disclosing the amount that he received on voluntary retirement from service. Stop. The manner and mode in which the petitioner intends to liquidate the bank dues. Stop. Comma. And the manner in which the petitioner intends to maintain his wife and pay off the maintenance charges. Stop. If the mortgage property is recovered by the bank under the provisions of the SURFACE Act, comma, the manner in which the petitioner will provide for the residence of the wife shall be disclosed in the affidavit. Stop. Learned advocate present in the bank has submits that the amount that is currently due and payable on account of the house loan is rupees 22,50,071. Stop. The petitioner also has an insurance policy for which
accrued interest is 12,961. Accrued interest till date.
Is it 22 lakh the principal amount? আচ্ছা তাহলে তার সাথে along with interest of rupees 12,961. And where is that insurance amount? Where is that?
That is the last statement, one page statement, 78,000.
Petitioner is also required to কি বললাম? Insurance policy for which he is required to pay rupees 78,100 per month.
No.
That is the that is the total amount.
Page 26 clarification.
That is the total amount, and the total amount, the loan amount to be repaid to the bank is 23,41,132.
Is it including 78? Where is that figure? 23?
It has to be calculated, your lord.
Oh. Then the interest will go on increasing, so the calculation. আচ্ছা ঠিক আছে তাহলে ইন্স্যুরেন্সের পার্টটা থাকবে required to pay insurance amount of rupees 78,100 per month থাকবে না 100 দুটো কপি রাখবেন. You can take back. You have given 2 copies. Give one copy to your learned friend so that he gets to know how much is due. ঠিক আছে? How soon can you come back?
3 weeks.
3 weeks? Very well, it's up to you.
Or 2 weeks.
The affidavit shall be prepared and circulated by 20th August 20.
Lordship, that's a humble request. I will be out of station till
20th. He will file the affidavit. Release the matter for further consideration on 27th of August will be all right. 27 তারিখ।
Subject to
Yes, yes.
তোমার phone number টা দাও। Subject to correction, if your lordship takes 1 minute of page 26, that amount will be varied.
Yeah.
Yeah, that is as per their statement. Total loan I took 24,44,000. Out of that, I have paid something and 22. And that Rinsurakka total amount 89,000. And they have deducted 870 per month. That page, my lord, kindly come to page.
Whatever calculation, if the
I will
figures
so.
figures are erroneous, then you can
I can
have a word with the
31 they are
bank.
deducting.
Whatever it is.
All right.
The figure that has been placed in court has been recorded.
Get.
Has the private respondent filed the wakalatnama?
We file it during the proceeding.
Then you should have mentioned it.
Because we cannot file it here, we file it in the department.
Obviously, it has to be filed in the department. Leave granted to file in the course of the day.
Or affidavit of service be kept.
Yes, service is taken on record.
Much obliged to lords. Grateful.
দেখুন তো আটটা। What is the stand of the bank? Can the entire money be collected?
Yes, my lord, that is my instruction. Lordship kindly goes through my instruction.
Which portion do I see?
But the only the initial premium was paid, the second paragraph. Under the policy and as per the terms and conditions of the policy, discontinued and fund moved to discontinuance fund. The lock-in period under the policy is 5 years, which ends on 26. Yes. As per the terms and conditions of the policy, at the end of lock-in period, discontinuance of fund is payable. The same is payable preliminary in the following manner. So, my lord, these are the two things that are given. Can take the annuity policy or can commute.
Your officers are so interested in selling insurance policies, they do not come up with a single sentence which the requirement was whether the petitioner can withdraw the entire money in one go. One sentence they can't write.
No, because they have to follow the guidelines. Lordship kindly
Let them follow the guidelines.
But without following the these regulations are 20. They have to follow the regulations. Otherwise, my lord,
let them follow the guidelines. Listen, Mr. Dey. The query of the court is whether the petitioner can collect the money in entire money in one go.
The ombudsman order, if that is, we are
I
complying.
do not want to hear anything. Just tell me yes or no.
We are complying with the ombudsman order. Let him come and submit the documents. Things will
you
be over.
Please say yes or no?
Whatever is there is here. And
this is not the query of the court. You are trying to complicate matters.
My officers will have to follow the regulations.
Tell your officers to join online. I'm not going to pass any order. Tell them to join online.
Lordship, kindly take the page 24. Lordship.
Immediately, the person should be there. I will not look at anything. Please give the next file. The query is very specific. Tell them when he joins.
Sir, cannot go beyond the regulation.
Sir, the query is whether the amount can be paid full on in December 26.
We are saying that.
You say yes or no?
We are saying that.
What you are saying?
The lock-in
you say
period under the policy
20%,
ends on 26. But at that time, most probably, but it will get over. So that is what the ombudsman order.
What is most probably?
Because, my lord, we do not, my lord, this is an insurance policy. We do not know what will happen then. Because today we are in 2025.
What is to happen? He has paid money and he'll take it back with the interest.
That is why I am beseeching your lordship, my lord, let them comply with the, in fact, we are complying with the
want an answer from your officer. If you are unable to explain, let the officer be online. I'll explain what is to be done and I know how to extract answers.
So that is all right. But
no, nothing doing. Your officer is not playing right with the court.
She cannot go beyond the regulation, my lord.
Yes, 19.
My will take up if he's online.
Yes, if he's online. At 4:15 or 20, let him to be let her.
I have a
present
at 3:30 p.m. my lord.
4:15.
That will continue. That will continue till 4:30.
4:30 you come.
Yes. There was a direction to serve my learned senior friend, my lord.
Yes.
That was only served last Friday. Well, the advocate could not serve. So only praying.
What is the query?
The query is, my lord, we are seeking informations with regard to my own property, my lord. My lord, I was very candid, my lord.
Where is it?
Under the RTI application.
His property, what is the construction is going on or not? That we have not.
No idea. Obviously.
Because even if I even if I have to take a
roving inquiry by the authority to
I cannot enter the property. I cannot.
it's your
make it-
property, you cannot,
cannot enter.
and the corporation will go.
Whatever records they have, I have to then use my force to enter the property.
Why force?
Well, I cannot. There are tenants in the property. I do not know what is the deviation that has been caused by them.
Sorry,
if anything
sir.
happens, my lord,
No.
the notice will be served upon us. Well, let me say the senior friend take instructions. My lord, let me
The
come back.
notice goes to the person responsible for making unauthorized construction.
Yes, my lord. That
Slash
is as per the
the
records.
owner.
The tenants are not recorded owners, my lord. We are the recorded owners.
Persons responsible becomes the
Tomorrow
tenant.
something happens, my lord, I'll be in
Obviously, it is your property. You should have taken care.
I was seeking, my lord, only that let the
Not
senior take instructions, my lord. Let him come back with instructions, my lord. Whatever that is, there is the KMC can provide.
KMC cannot provide me. In carpet area, you can check the IB and see how much is the carpet area, isn't it?
Well, that has been
From the
But it is the entire premises has been assessed, and he is saying that he is the only a portion of the building. He is only one flat. In respect of one flat, he want to inquiry about the matter. That is the about on first floor, roadside room, and it is
Even-
adjoining to Baranda premises.
Even
number
admin, the
286,
newly added, page 20,
Ganguly Street.
page 29, but even the newly added mezzanine floor.
they will not have it in their records.
If whatever they have, or whatever they have, if they do not have in records, that goes to show that is an illegal construction. I can proceed on the basis of this, my lord. Or else I stand nowhere. My property, there is somebody else making construction.
IB
How do I?
copy.
That is what I've asked them. Let him bring the instruction. Nothing to be out of the record. Nothing that the KMC cannot provide.
285C BB Ganguly Street, see what is there in your IB and bring a copy. Nothing more. Learned advocate representing the corporation seeks time to take instruction. Stop. Released on 12th August.
Grateful, my lord.
Next matter, Mr.
You are here. Your name will be recorded.
Next matter, Mr. Anirban made a request before your lordship on the last time that today he is a personal difficulty. If your lordship kindly give us some time, my lord, we have already informed. my lord.
Lordship indicated that at the time of hearing the.
Yes.
I am for the respondent.
দাদার 1 তারিখে হবে না।
Second. Request was made for second.
Yes, yes.
All right.
2nd August.
Yes.
তুমি তো 1 তারিখে ব্যস্ত থাকবে। 2 তারিখে থাক।
2nd August.
এই
Second August.
No, no, পাগল নাকি বললে হবে না।
This is a big matter. It can be hard on that.
লিখুন তো on the prayer. No, the prayer was specific. I remember Mr. Ray mentioned that 2nd of August, and I saw it was a Saturday, and I was reminded that it's a working Saturday. What?
Monday.
Which Monday? No, Monday is combined list. It will not be possible. Fifth. আচ্ছা ঠিক আছে। By consent of the parties, list this matter on 5th. ও শুনে নিয়েছে। Yes, call the next. Yes, it will be there. Yes.
State has filed report in the form of affidavit. We have also used a reply to this. Exception to that. It's okay.
The irrigation and waterways department was directed to prepare and circulate a report. Has it been done?
Yes, my lord, we are using it, my lord, with your lordship's leave an exception to that.
All right. What does they say?
My lord, they say now they require It's not a full term for a stockyard. Now I will show
Stockyard.
Stockyard. Now even Malad 2 months before, the same engineer said that
I do
don't
not
have it.
require.
This is the now this is Malad this is a selective one. And he almost said no step has been taken in respect of others 6-7 owners. Malad, they have built the house. I'm the tenant with my under my learned friend. He initiated the motion that I am not using that land, I am using another. I will show your losses to everything. But in presence of the
Private response.
no, the
State.
State not.
Only the interim order is going to expire on 31st. 30th.
State not.
Call Mr. Chakraborty.
He's not here, probably not in court. Not yet come.
Not yet come. It's 3 o'clock.
আসেনি এখনো বলেছে না over phone.
What about Shoptok Shannal?
Shoptok Shannal I do not find.
So what is to be done?
But keep it another day, extend the interim order to some.
No, then not today, come tomorrow.
Tomorrow.
It will be there in the list.
All tomorrow I don't have. But it's the second time I find, Malad. If they do not come tomorrow, then I have to proceed, Malad. With the report, I will submit before also the copy of the report I have. Like a copy.
Call the next matter.
Shoptok Shannal is there.
Where? Yes. Dekhi. Yes. Then it is all right. Dekhi dinta. Give the report.
Report is there, Your Lordship.
What is your stand?
Stand here, Lordship.
Yes. Dekhi the report. Exception, please. Exception. Yes. Plot numbers 363 and 364.
And I mean 364 and some of the courts are 360.
You are the owner of both. You are the owner of both the properties.
That time, my lord, I purchased my father purchased it.
Which one?
360 is 0.5 decimal and 360 because it is there.
All right. You have acquired the land.
Record of rights is there.
Which
Please,
page?
regarding 363, on page 34. Your Lordship.
Of the writ petition.
No, not page 34, R2, your page 10, Your Lordship, of the report.
Report.
Page 10 of the report.
Also page?
Page
10.
10.
363 Vastu. Irrigation and waterways. It is irrigation and water. So you are not the landlord in respect of 363.
363 and
364?
364, no, Lordship, only 363. They are pertaining to 363.
All right. 364, you do not have an issue.
364, we have not any issue, Your Lordship. Lordship,
That
363.
is not acquired and that is the land of the private respondent.
That is not our land,
So the
Your Lordship.
petitioner
363.
continue with 364. There is
363
no
because
issue.
petitioners, certain things are abutting into 363. Certain
Certain
petitioners.
things are abutting.
I'm apologizing, Your Lordship. I am not able to correctly say. The 363 is irrigation and waterways department land. Certain portions have been encroached. And regarding that encroachment, we have taken steps, Your Lordship.
The petitioner is there in 364.
If it's 364, I have no
issues with 364.
No issues with 364.
With only 363, you have an issue.
We have issues because that is irrigation and waterways department.
Yes.
Land. And Lordship, on the earlier occasion, has directed us what steps have been taken, whether we are the owner, or
Yes.
everything has been annexed here.
All right. And it is recorded. Does it mean that you acquired it?
Lordship,
How could it be recorded in your name?
it has been recorded because whatever instructions I have received way long back, it has been the property is lying with us. From the British era, that property belongs to us. And when it was acquired, that the officers are not able to trace it back.
Acquisition, nothing.
Because record of rights, it's there.
Because in case it is acquired, then the owner will be entitled to some compensation.
Yes, Lordship.
The owner
but
can pay
it was-
compensation to the
it was not
occupier
within the
also.
purview of your lordship's order was that whether we are the owner of the land.
I understand.
Yes, your lordship.
But then how did you acquire ownership? How did you acquire the ownership?
Because we have tried to ascertain that how it was acquired. The records lying with us
Doesn't say anything.
Doesn't say in the office. Lordship, that is the dilemma, your lordship.
All right. And exactly which portion or the quantum of land that encroach is 363?
Lordship. None. That, your lordship, in the report is not there.
0.26 decimal is 363.
Yes, your lordship.
And the entire stands in the name of the collector, the irrigation and waterways.
Department.
Yes.
Sequence wise, let me proceed. I just take few minutes. My lord, I am a tenant under my learned friend's client. My lord, kindly have a look at page 54. I'll take some of the documents.
We will restrict the submission with 363 only.
Yes.
364, we are not concerned. You are also not concerned. What do you have in
364? I'm concerned, but not the state.
State is not concerned.
Only 360.
364, you are using, and if there is a dispute, this is private dispute. Somewhere else it will be resolved. Over here, nothing.
I tell you, lordships, I have been running this on-shop liquor shop right from 2004 on this plot of land.
With 363 and 4.
In a constructed double-storied house, I'm in the ground floor.
363 and 4.
4. Both. I'm not, I'm both. I have been tenant. I'm a tenant. Your losses kindly have a look at the schedule of the tenancy agreement only, page 54.
No, if somebody has misrepresented and said that the
No, that's not. He has not misrepresented. I tell your losses. He has moved the motion. I tell your losses why. Something else is behind it. Kindly have a look, page 54.
Yes.
Only Toposhil Bhumi or Badir Bibaron. This has been this agreement by my learned friends, client Shokti Bag. Purbo Jela, Purbo Mednipur, Thana Kolagat, Moja Kolar, Eto, Dag number 363 and 364. ভূমির ওপরে নিজস্ব খরচে তৈরি করা দ্বিতল পার্কগুলির ভূতলের 36 foot by 15 foot. This covers both the dark 36 foot and 30 foot. Now, your lordship, he moved a motion before this court that I am not running this off-block liquor shop on 363 but 272. This court directed for consideration of his representation.
Yes.
Your lordship, this court directed 72 page. I'm not taking your losses. Can you take note of this fact? Directed consideration by the authorities.
Tell me one thing, how far is 272 or 4 from this place?
I believe.
The plot which the private respondent says where you are running the business.
Much long. They have said it. They have said it. I take your losses. Government official said I'm running in 363 and 364. And how much they have demarcated.
All right.
That's I will show.
All
now,
right.
after this order, page 72, your losses will find this his allegation. I am running in 272.
Yes.
This is the his allegation, and this court directed for consideration. Now, your losses will find page 77.
Yes.
This is the order. Your losses will find last portion. Considering the facts in entirety, I, the superintendent of excise such and such district, hereby bring the instant matter before the kind notice of collector of excise. He says, I am not the authority. Collector of excise is the authority. He is the licensing authority. Then you'll see next page. It was taken up by the collector of excise. Page 76. Last two paragraphs. It is necessary to ascertain the present location of the license shop as the license was granted in respect of plot number 363, but has been alleged to be running from plot number 272 as per the petition. Further, it is also imperative to ascertain the status of plot number 363 regarding its acquisition by government department as reported in courts of hearing. Considering the facts in their entirety, I, district magistrate such and such, ordered that the BLRO block to conduct an inquiry in presence of both the petitioner, Shokti Bag, and Chandana Maiti, the present petitioner, to ascertain the exact plot number of the land where from the license swap is running and whether the plot number 363 has been acquired by the government and direct him to give a detailed report. Now your losses take up before page 88 report.
Yes.
By the block land and land reform office. As per your order, I along with Moinwin such and such to ascertain the location of Kolaghat foreign liquor on shop in presence of the personnel of KES Shoktibag, the petitioner, husband Chandana Maiti, licensee of the said shop, and some local people. During field inquiry, it is found that the shop is situated in plot number 363 and 364 of Mauja Kola, jail number 287. The shop occupies an area of 394 square feet in plot number 363, recorded in Khotian number 266, in the name of Irrigation and Water Department, Waterways Department. The shop occupies an area of 187 square foot in plot number 364, recorded as per computer PI in the name of Bishupodo Bag, Gorai Bag, Muktolochon Bag, such and such, and present the name of the petitioner Shokti Bag does not feature in the plot number 364.
That means he is not.
364 also doesn't belong to him. But I have been tenanted. I'm enjoying a status quo order because his file evicted notice was given. I'm enjoying status quo order. So on this document, I have been given license by the government department also. They didn't raise any objection at any point of time. After this order, my report, what the order was passed by the page 86, your losses kindly consider. By the my lord, DM. 86, last paragraph. My lord, he directed me, gave an opportunity to sip the foreign liquor on shop. This that I question this order before your lawsuits. 97. Kindly have a look at this. I will not place your lawsuit the entirety, only the relevant portion.
Yes.
Malad, it starts from 97. Kindly come to straightway, Malad, 100, page 100.
Yes.
Finding portion, paragraph 16.
Right.
Neither the records placed before this 15. There is no recording in the order dated 3rd 24 with regard to the immediate urgency in disposing of the matter ex parte. The foreign liquor on shop is running from the said site since 2004, as per the license issued by the authority. It does not appear that there was any pressing emergency to dispose of the matter, ignoring the request for adjournment made by the petitioner. Neither the records placed before this court nor the impugned order disclose the date of acquisition of the subject land by Irrigation and Water Department. There is nothing to suggest that the requiring body raised any objection against the petitioner for running her business from the acquired plot of land. It has been asserted by the learned advocate representing the petitioner that there are several dwelling houses and shops situated over plot number 360, which has been acquired for the Irrigation and Waterways Department. As the shop in question is running for a considerable period of time, the DM and collector ought not to have rushed to direct the licensee to stop operation of the business. The authority ought to have further ascertained as to whether the department has any objection in the running of the said shop from the plot which was acquired for Irrigation and Waterways Department. Now, this is very important. Then, debarring the petitioner from running the shop within 45 days from the date of the order without granting a reasonable opportunity to place the records in support of a status in respect of the subject land would result in closure of her business. Then 20. The authority ought to have also deliberated over the issue as to whether there was any requirement of passing such an order for immediate closure of the business if the requiring body did not intend to use the acquiring land for their own purpose. Then your losses, paragraph 23. Writ petition is disposed of directing the DM collector to revisit the issue in terms of the observations made herein Baba by granting reasonable opportunity to hearing all the parties. After this, 106. Before 106, I think, 106. Before 106, your losses kindly come to page 108, so that to maintain the sequence, so that your losses can appreciate it. Malad, this is the written representation of the department, executive engineer. Kindly your losses take note of the date and signature of the person. Very vital. The same D. Sarkar, executive engineer. Kindly see, Malad, the submission of him before the DM, 3 and 4. On 6th of December 2024. At present, no any departmental or government project intends to initiate on the said piece of land, but may come any government project in future. 2. 4. Irrigation and Waterways Department has not raised any objection ever against functioning of the foreign liquor on-shop on the said piece of land due to lack of proper demarcation of the plot. This was the submission. Kindly have a look at the Malad order at page 106. But he has completely with the highest officer of the district. He has totally misconstrued deliberately the submission of the department and recorded something else. Malad, from the top, you will see 6th paragraph with the expression starts the concerned executive engineer. The concerned executive engineer has informed by his letter dated 6 December 2024 that the said piece of land is owned by the Irrigation and Waterways Department, though they could not mention the date of its acquisition. He has also informed that the concerned department has not issued any NOC in favor of the concerned Kolaghat foreign liquor on-shop as per the office record. Further, it is also stated in the aforesaid letter that the licensee cannot produce any departmental NOC in her favor. No, naturally, objection will stand by for future. Well, this is not his submission. Kindly tally with this paragraph, with paragraph page 108, completely in the deviation to that. Then he ultimately asked me that you should vacate immediately. Then I come up before this honorable court. Your lordship was pleased to pass an order only in respect of 3 points. That order touches.
Give me the date. I have the order here.
I just give you the order dated 30th June 2025.
Yes.
Now your lordship, the paragraph 10. But I request your lordship, this order has to be read with your lordship's earlier order. Paragraph, your lordship has quoted the entire thing, then paragraph 10. The Irrigation and Waterways Department is directed to prepare and circulate a report by way of an affidavit dated 11 June disclosing as to whether the plot number 360 will be immediately required by the Irrigation and Waterways Department for any project. The quantum of land in plot number 363 acquired by the irrigation order shall be mentioned. Whether any steps taken for eviction against any other occupants in plot number 363 shall also be disclosed. Now, your losses, before that, your losses kindly also take up page 110 of my writ petition, because this is vital. Same executive engineer. Kindly have a look at this. Lord, because I'm pressing for long-term settlement. Lord, everybody has built up a very nice building, not my owner alone, the other landlords. I will show the pictures. The entire 26 acre of land.
And it is pending consideration, your prayer for long-term.
I am on the last occasion, Mr. Chakraborty submitted, but because of this letter issuance, they have initiated departmental proceedings against the executive engineer. But I tell you, lordships, even the district magistrate, when the submission was made by the executive engineer, that we do not require right now. This is sometimes excess land after acquisition. He threatened the the executive engineer, I will initiate disciplinary proceedings against you. Now, even after that, kindly have a look at page 110. He initiated the process for long-term settlement on my favor. Last line, kindly see. Because I am pressing for that.
There is no upcoming departmental project on the site.
Now, kindly have it take up. Next line, your lordships. Prayer for Chandraful long settlement may be granted by the authority concerned. Now, this is the stand of the state. Your lordships, kindly look at the affidavit.
Lordship, sorry to interject, but this was from the day one. We have said that this was never the stand of the state.
I'm showing that. I showed the stand only. The last occasion.
We have taken objection regarding this.
Wait. Yes, and that is the reason you have initiated departmental proceeding.
That is why we have initiated, because he could not have done so. And Lordship has directed us to file affidavit that.
All right, I'm seeing. Please.
Now, your lordships, kindly look at page 12. But I tell you, lordships, this annexure of this document, something misleading. Page 12, your lordships, of their affidavit.
Yes.
Subject, request to fix a joint survey program for demarcation of plot number 363 to 87, such and such. Kindly see reference, WP number such and such. Well, this reference of the writ petition and this joint survey in relation to my learned friend's writ petition, block development officer's report, that was. Then such and such. and is to fix a joint survey program for demarcation of plot numbers in the following. And that was done, and the BLRO has said it. Then your losses kindly. Next page is almost the same for illegal encroachment. Then your losses. Paragraph page 14. Kindly see everything mentioned, the earlier repetition, all that. In continuation of the above memos under reference, the undersigned is hereby requesting you to make an arrangement for joint demarcation of land to assess the quantum of encroached land as well as the quantum of encroachment free land of the entire plot number such and such, but under belonging to IW department and such and such. Moreover, it is to be taken under your consideration that the report mentioning some areas of the said plot has been initiated from your end to the department superintendent exercise, which is now to be elaborated further with respect to total quantum of land belonging to the I and W for the said plot. In this connection, you are also requested to arrange the same as it is required for making departmental stockyard of flood fighting materials for upcoming monsoon at the same location. It will be treated as urgent on the basis of requirement of irrigation and waterways department. Concern will contact you. Malad, this was signed by DK Sarkar, but kindly see the next page. Signature. I request your lordships kindly tally this signature.
Yes, I've tallied it.
Same person when he submitted before the DM. No urgent pressing requirement.
Very well,
This has been created.
Please
Purpose.
Lordship.
And no proceedings have been initiated against any of them.
Lordship, one humble request is that I have just now received the exception.
Yes, go through it. Please go through it.
Kindly.
Acha, the report in the form of affidavit filed by the respondent numbers 3, 14 and 15. And the exception thereto filed by the petitioner is taken on record. Stop. The aforesaid respondents, they are the state respondents, isn't it? All
of them
are directed to file further affidavit disclosing the follow-up steps with regard to the memo dated 7th July 2025 annexed at pages 14 and 15 of the writ petition. Stop. Hearing of the writ petition stands adjourned till the month of November 2025. Stop. List in the combined list of November. The interim order that is subsisting in the matter is extended till 19th of December 2025 or until further order, whichever is earlier.
May I request one thing, your losses, to add in your losses order? Kindly direct them to produce or annex the documents when this decision was taken for stockyard.
This is 7th July after the court's order. I can see it from here.
Well,
Copy of the position.
Yes, he'll serve.
Opposition, I have used an exception to the report.
Kindly records, my lord, that in pursuance of a notice, my lord, sale notice, I participated in the tender process. I became the highest bidder. I purchased, I deposited, my lord, the entire amount. Sale certificate was issued by reason of your lordship's intervention, my lord. Possession has been, yes, order complied with. My lord, the remaining part is this, my lord. Since I have purchased, my lord, in pursuance of a notification issued by the Bank of India, there was a prior mortgage, my lord, that was, my lord, by the Mr. Shaha, my learned friends.
Bank of Baroda.
Bank of Baroda. So Bank of Baroda, that is Mr. Datta's client.
You took possession from whom?
From Bank of India.
SBI.
Now, my lord, there was a prior mortgage.
With
Now, my
Bank
lord,
of
yes, and
Baroda.
registered mortgage. That was in compliance of. Now, my lord, they received the entire amount as that was fallen due and payable from Mr. Shaha's client,
Alright.
Mr. Dibanjan Datta. That if I have correctly understood.
Yes.
Now, my lord, kindly direct the bank, Mr. Datta's client, to release the mortgage and give her that the loan-free certificate as per law, so that in future there cannot be any dispute if I want to dispose it of, that every mortgage is subject to sale. So, my lord, every sale is subject to mortgage. So, my lord, I want to be, my lord, I want to enjoy the property, my lord, without
No
there being
encumbrance certificate or something of that sort has to come from you.
No dues cannot be given at this stage, my lord.
Why?
There is a history of this.
It's a registered instrument.
Wait, my lord, there was a loan in I had granted, that is Bank of Baroda, in favor of a company. They sought release of a particular property upon payment of some sum.
All right.
I got the sum, released that particular
And this is the house.
This is the land which is Mr. Basu's client had.
Land, all right.
Yes. Also flat.
And
There are other mortgages.
yes,
The loan is also continuing.
right.
The loan has now been declared NPA. There
Yes.
is a original application pending before the DRT in the
Right.
said account. I cannot issue no dues, but I had already given whatever necessary with regard to the release. If
Yes.
Mr. Basu approaches through that company, because I do not recognize Mr. Basu's
How
client.
can I?
That company.
That how will he get contact with that
I-
company? You have to issue it to the SBI so that SBI can give it to the
I had done
petitioner.
everything. If Bank of India now again writes to us, we can again confirm that
Where
we had
is the
released.
document from Bank of India that the property has been released from the loan?
Well, we are not having that document. That is the difficulty, man.
That is why I'm making a
If they-
request to your lordship.
If they write to us, we can again confirm that we had released.
Yes.
But the mortgage deed.
No, that doesn't matter. But the deed in
Yes.
respect of this land has
Yes,
to be
we
given.
will again confirm that it has been released. Your lordship can
Where
take
is
it.
the deed?
That the deed is required to be executed after the
No.
repossession.
No.
The
is required to be executed by
sales,
Yes.
the deed, the mortgage
But
deed
the
must be
mortgage
having.
has to be the mortgage has to be released. And in respect of my property, it's a registered mortgage.
Yes, it will be
But in
released.
part,
It has
in part.
been released.
My lord,
In part.
title deed was returned to the intermediary bank.
That means the bank must be
Yes.
having the deed of this
Title
property.
deed.
Title
But
deed.
what Mr. Basu is claiming,
Subsequent.
yes,
Mortgage deed.
mortgage deed. But
No,
I
that
cannot,
cannot be given.
yes,
No,
because
that
that is
cannot be given, but kindly. But if the sale is subject to mortgage, and according to Mr. Dotto, that the part of the property has been released since he has received payment. But that part, my lord, there must be a release deed, my lord, indicating that this part of the property,
That-
otherwise section 14
I
will be
cannot
Yes,
release in
yes.
favor of Mr. Basu's
No,
client.
to
Favor
the
of the-
bank.
No,
the
not favor of bank, but my borrower, who is now an NP.
borrower will not come.
Yes, because I had released in favor of the borrower. Borrower had again mortgaged with it with.
It was incumbent upon Mr. Dotto's client, my lord, to get it done in a
It-
proper manner.
No, it
Today,
was
my
not
lord,
my
if you put
obligation.
the
It
clock-
was the obligation of the borrower.
But why should I be made to suffer?
It was the obligation of the borrower.
I put
Wait.
Yes.
What is the solution?
The
We have to find out a solution.
I can confirm that I had released.
And then the title deed.
Title deed we had returned. There can be no dispute that they have not received the title.
Return to whom? The
Return to the
borrower.
borrower must have submitted to Bank of India. Unless how
Title
Title
should
deed.
also be there.
title
Check
deed
up.
must be there. Unless without that, how could they have created the mortgage?
Exactly.
Title, it must be there.
Yes.
Take it up and use there.
And this
have
and
to
the
put pressure at each and every stage to get things done. Otherwise, how could the property be given to him?
জজসাহেব তো বলছে কথা কি
আচ্ছা আসুন তো দেখি।
এত উত্তেজনা কেন অল্প বয়সে?
Another thing. This property is also related to a greater conspiracy of Rose Valley, which is under the CBI investigation.
That is a different thing.
There may-
Surface will not come
No,
over
there
here.
may be some attachment. I do not know. There may be some attachment order. Maybe. I do not know.
The court is not entering
Yes.
into that. It is only with regard to the surface proceeding that the court is interfering.
We will again, my lord can record my submission and we will give in writing that we had released. In
Learned advocate
2023.
presenting the petitioner's
My lord,
substance
I tell you, lordship,
that
there are only one
physical
thing.
possession of the auctioned property has been taken over by the petitioners. Stop. The title deed and the release deed, however, is yet to be handed over. Stop.
There is no release deed. My lord,
To be prepared.
Yes.
Title deed will be returned and the release deed is required to be prepared. ঠিক আছে? The court has been informed that the present flat which has been put up in auction is a part of the mortgage. Stop. There are other mortgaged properties with the bank.
With Bank of Baroda, my lord.
With the Bank of Baroda. Stop. As regards the flat in dispute, the Bank of Baroda has already released the same in favor of the borrower. along with the title deed, which possibly has been deposited with the State Bank of India.
Bank of India. Bank
for
of
the Bank of India for obtaining further loan. Stop. The Bank of India is directed to hand over the title deed of
Original title deed, not the certificate.
original title
Bounty?
deed of the
Bounty?
flat
No, no, দেয়নি, কিচ্ছু দেয়নি, নীরব আছে।
to the petitioner. Stop. The deed of release, if not already prepared by the Bank of Baroda, shall be prepared and handed over to the
Well, that has to be a registered document. We cannot register it. It has to be registered by the borrower who had sought release. That is to be paid in stamp.
Because
Stamp
register
duty.
will not help us, my lord. The register
Stamp duty has to be paid. Bank of Baroda has no obligation to it.
Bank of Baroda certainly has obligation.
No, no, no. Bank of Baroda has released it. Who will pay the stamp duty? Who will
pursuing your money like a Shylock, and now you are maintaining silence.
no, no, difficulty is the borrower has fled away.
Borrower has today, my lord, I stepped into the shoes of the borrower. There is no existence in the eye of
not with
Where
me.
should the borrower
I have no nexus with
No,
Mr.
it is not a
Basu's
question of
client.
Nexus. Question is ultimately, my lord, your lordship.
When you release the property,
Yes.
there is some document
We issue release document.
not registered.
Not registered. The mortgage deed is prepared by the borrower and deposited in our favor so that we have an additional security over and above the original title deed. We have the original document of the registered mortgage as well as the title document, so that in case of enforcing the mortgage, we have these securities. Now, when the property is released, it is the duty cast upon the borrower to seek release of the registered mortgage as well as take back of the original deed. He has to pay the stamp duty, he has to get it registered.
Then is the release deed also required to be registered?
Yes, because it will show in the office of
registered.
Yes, because it will show as encumbrance in the office of the registering office.
And they will not, and I cannot, my lord, get it registered because of this encumbrance.
No, if your lordship, I do not know whether your lordship.
What is the way out?
No,
Yes, my lord, I am suggesting one thing, subject to Mr. Dotto and Mr. Shah's consent. My lord, kindly permit me, my lord, to my lord, add the register assurance, my lord, and kindly ask him to file a report, my lord, indicating, my lord, this is the problem. Let him, my lord,
What
my lord,
will
because
the
otherwise,
registrar-
even if, because he says the other properties are also encumbered. My part that has been released, only a release letter, to which, my lord, Mr. Shah is not aware of whether it was released or not. My lord, without getting into this kind of cloud of confusion, let the register say that in such a circumstances, if Mr. Dotto's client, my lord, makes a declaration that the property has already been released, and the borrower today, I have stepped into the shoes of the owner. Now, my lord, today the existence of the borrower is no more. Under these circumstances, it is the register. No, even if today, my lord, after the sale is executed, unless the sale is set aside by the DRT, my lord, today I am the owner, I have paid the amount. Now, my lord, today the register will say, because otherwise register will come and say that the registered
Then
mortgage
that
is
will not be a registered document. The register can always check up the records and see whether it has
will register, because after the disposal of this matter, if I go after, my lord, putting the exact stamp duty as per the Stamp Act and Registration Act, the register will not get it registered. He will say that every sale is subject to mortgage and is already mortgaged.
Yes.
That is why I am requesting, my lord, because by this order, none of the parties in the proceeding will be affected or prejudiced if your lordships, my lord, ask the register to file a report in the conspectus of this fact, whether he has any objection, because I cannot make any prayer, my lord, which is contrary to
No,
law.
whether he has any objection with regard to the release.
No, release means in such a situation, what has been suggested by Mr. Dotto, that only a release letter as against a mortgage deed, whether, my lord, the register, my lord, after the disposal, my lord, what is, because the register will not allow me to execute the deed. Otherwise, my lord, the court cannot pass any order, or the party should not invite the court to pass any order which is incurable execution.
Yes. So, what exactly can the registrar?
deed registration করতে
হবে না, এটা তোর কল্পনা, এটা তোর কল্পনা, এটা তোর কল্পনা।
There can be no hindrance in registering a
That
new
is
deed.
his perception, which is frightfully narrow.
There can be no hindrance in registering a deed. Registering authority is only
is his
concerned
conception.
about the stamp duty.
Yes.
He will look into nothing else.
No,
It
but
is
who is
his.
going to sign?
No. Sign will be done by Bank of India because Bank of India has auctioned the property. His authorized officer will sign the document and he will get it registered through the authorized
So
officer of Bank of India.
let him act as
The
a
only-
confirming party. Let him act as a confirming party in the deed.
If my lord directs, we will.
Let him act, but I do not want
Listen,
to.
whatever is the solution required to be done, because you have released it and the Bank of Baroda has, Bank of India has got the money and the property has been delivered. Now, whatever the documentation part, please take care of it so that he has
Yes, I'm deeply obliged.
that with the documents. Otherwise, it will be of no use.
Let him be armed with a written instruction indicating the client's mind.
ওরা জানে না।
Okay,
So,
ওরা জানে না।
if my lord directs, we can act as a confirming party in the document or in the sale certificate, which is proposed to be registered. We can act as a confirming party if my lord indicates it.
And the registrar will act on the
That
basis.
will be the sale certificate, but the release deed.
Yes.
That will solve the purpose.
No, that there must be an
Sale
averment.
certificate.
Yes, there will be an averment.
In the sale,
In
sale
the
deed
sale
itself.
in the sale certificate
Sale
itself.
certificate.
Yes, if your lordship indicates one line,
You have
we
to
will.
prepare the
I will
sale
convince.
certificate.
An execution has been made in terms of his lordship's order.
Yes.
It has
The
to be.
register should also agree to that because.
The register will have register.
Mr. Shah is right. Mr. Shah is right.
Register.
The system is showing registered mortgage deed, so it will not be possible.
আরে ওইটার মধ্যে কনফার্ম করে দেবে তো
Whatever is to be done, please do it. I do not want to enter into this.
But kindly not discuss it.
না দরকার নেই
থাক, এটা বেঁচে থাক।
বেঁচে থাক।
না বেঁচে থাক। তুমি আর মেরে দিচ্ছ না, নষ্ট।
এটা তো বলতে করতে পারবে না, ডিড অফ রিলিজও করতে পারবে না, ওই লাইনটা কাটা হয়ে যাচ্ছে।
ঠিক আছে, Bank of India is directed to handle.
Well, indicates that we will act as confirming party. I'll.
Bank of Baroda and the Bank of India are directed to take necessary steps to ensure that proper documents, including the title deed of the property, is handed over to the petitioner so that the petitioners can enjoy the property as per their own wish and desire. Stop. Released when? When?
My lord had indicated Bank of Baroda and them for release of title deed. Today, as on this day,
They have it.
My lord has indicated us in
For preparation of documents.
not
that
for
he
release
can-
of the title deed.
Acha, theek hai.
Kindly clarify that.
Care of it.
Kindly clarify that.
I will take care of it. When? Bank of India, when will you come back?
এক মাস। এই এক মাসে এই এক সপ্তাহে কি করে পারবে?
হবে না।
এক মাস।
বলে দেয়ালে।
এক মাসে এক মাস।
28 তারিখ তো, keep it on 25th of August.
That part hard without.
পাঠা।
কেন? আমার শোনাতে কি আসে যায়? একটা আরে প্রার্থনা সবসময় দেবতার কাছে হয়।
Kindly clarify that.
Kindly make it.
হ্যাঁ বাজে বল। আরে তোমার মক্কেলের ডিল রেজিস্ট্রি করতে কি?
না ব্যাংকের ব্যাপার বা পাবলিক মানি, আই ডোন্ট ওয়ান্ট টু টেক এনি কাইন্ড অফ রিস্ক।
তোমার পাবলিক মানি তো না।
আমার না হোক।
Kindly takes care of that.
না
না আমার সমস্যা হয়ে যাবে।
সেটা হবে না।
Kindly takes care of that part.
I also renew my prayer.
Your prayer is rejected outright. I never keep parted matters, not even one parted matter before this bench. No.
Exception proves the rule.
No. The moment I move out, no baggages behind.
You get it assigned.
Next. You want
Time, my lord,
for the
respondents, my lord. There is the interim order, my lord, that is existing till, my lord, end of August. Right?
29th of August.
Kindly fix it next week. Because my clients, my lord, are all octogenarians, my lord, they are, my lord, since, my lord, due to heavy rainfall, my lord, they are unable to come to Calcutta.
Please come. On the prayer made by the learned advocate representing the private respondents. Hearing of the writ petition stands adjourned. Till when do I keep it?
Any other day other than 6th of August, Your Lordship.
Yes, well, after 6 months, I also have accepted.
12th, 13th. When 12th?
12th.
12 तारीख है.
Deeply obliged.
29th. Yes.
Lordship, item number 25, I beg to appear virtually, Lordship, as S1 number 9 in person, Lordship. Honorable Division Bench.
The band. You are appearing in person and you are wearing the band?
No, no band.
What
No
is
band.
this? This is your shirt. All right.
Only shirt.
I may be permitted to
The matter is pending before Honorable Division Bench, Lordship. I am not going into the interim order, Lordship.
Order
I
of the
just
Division
want to
Bench.
ascertain before your Lordship that
Your
she has
Lordship,
paid for quashing of a FIR before your Lordship within the writ petition, and she has paid similar prayer before the revisional court with the self-same FIR.
Your Lordship, I may be permitted to file.
She wants to take parallel proceeding going on with respect to same FIR. She has paid quashing, that is CRR 3135 of 2025. And now in this writ petition, she is paying quashing of the same FIR. This writ petition is not maintainable, Lordship. Date fixed before the Honorable Division Bench is on 6th, upcoming week.
You just give me the appeal copy. You have not served me the copy.
Only one copy.
One copy has been served.
He will pray for adjournment again.
Another copy. I am yet to serve.
He had been delaying all the procedures, Your Lordship. Your Lordship, I may be allowed to read out two documents, Your Lordship, in the exception.
No, now it is extension of interim order. I will extend and then let the division bench take a decision. The interim order that is subsisting in the matter is extended till 26th September 2025 or until further order, whichever is earlier. Stop. The appeal preferred by the private respondent. Which
8
private?
and 9.
8 and 9. The private respondent numbers 8 and 9. Is due to be taken up for consideration shortly. Stop. The parties will make all submission before the Honorable Division Bench so that the issue can be resolved once and for all.
And they may be restrained, Your Lordship. They may be restrained from filing more complaints because my son and everybody is just
obtain order from the division bench. Exception.
Every day she is doing this kind of submission. Honorable Division Bench has advised to settle the dispute. When my learned colleague called her, he told her I have to withdraw all the cases. Thereafter, she will settle. She is in no mood of settlement, Lordship. She is doing everything before the court falsely.
I have been representing my client from where they have started filing cases against me, my family, my junior.
No, Lordship. Her husband is charge sheet accused. I am not against her. She is having the rape accused, Lordship.
And the Howrah PS may be directed to
list on 18th of August. 18 August. Yes.
Your Lordship, the Howrah PS may be directed to take care of the exceptions, Your Lordships, because a number of contradictions are there and I have proved it by documentary evidences, Your Lordship.
All right, next.
26 not I appear for the respondents.
Appeal was preferred by the state with the application where the order of transfer applied for certain information. That information, after filing of the writ petition, the appellate authority had passed an order. The Honorable Division Bench Milord, in an appeal filed by the state, Milord, I said, Milord, that I will file an appeal against the last order dated, Milord, 10 July 2025. So far as on the basis of my submission, because, Milord, I tell your lordship, I made a request to the division bench, honorable division bench, that kindly direct the authority. This is not recorded, but I must tell your lordship, because otherwise, Milord, that would be the misrepresentation. I requested the honorable division bench that kindly direct the commission to dispose it of. The honorable division bench was pleased to observe, not recorded, that since you have not yet preferred any appeal, the question of giving direction cannot and does not arise. But this is not in the order. Now, Milord, today there is another order. Now, today, Milord, the main issue is
another order.
18/6/2025, the first order. Thereafter, Milord, 10 July,
Right.
appeal. Now, Milord, whether I can make a prayer before your lordship, considering all the facts and circumstances, the issue is whether this kind of information as sought for by me in the writ petition, because the honorable division bench did not touch the other many parts of the writ petition, it is still alive. Writ petition has not been disposed of. No, writ petition is disposed of. Order impugned is set aside. May assail the order dated.
No, the writ petition is pending in view of the.
Did I say anything, Milord, which Milord demolishes the image of my learned senior friend?
No.
I never said. I said that I will prefer appeal against Milord 10 July. I make a request, Milord, at the cost of clarity.
And his prayer.
Yeah, let me hear. Yes.
Milord, I made a specific submission before the honorable division bench that a particular political leader of a ruling dispensation, he influences this transfer. The honorable division bench, good, bad, indifferent, said, do you want to prefer any appeal against the order? I said yes. I cannot, Milord, travel beyond the records. This is not recorded, but I say I must be clear to your lordship. Now, Milord, in this event, Milord, whether this kind of information as sought for by me, Milord, has any, Milord, is affected under section 8(1)(j. Whether the
no, then that is the larger issue to be decided.
No,
that it will be academic in this case.
No,
this will be academic.
But irrespective of the status, irrespective of my appeal, I have considered before the division bench. That is why the order impugned was set aside. Because, Milord,
you kindly say that after making your submissions at length, thereafter.
Milord, what is in a length, what is in a,
yes,
I do not
recorded.
know. I said, Milord, the division bench did not, Milord. Milord, the honorable division bench was of the opinion that it is acceptable and reasonable. But division bench was conscious, otherwise there was no occasion for the division bench not to, Milord, dismiss the writ petition or to dispose of the writ petition.
No,
division bench was conscious about the fact, because the court was under contemplation, possibly, that there are other issues to be decided. Now, today, in the conspectus of this fact, whether I can make a prayer that the issues involved in this writ petition can be decided. Whether I can get the response from the commission or not, I can take avenue before your lordship's court. That is a different thing. Whether the nature of information I have sought for can be decided by your lordship. Because in
that case, let them file their affidavit. Did they file any affidavit?
Kindly record that the division bench did not allow my prayer. I considered before the division bench. Kindly record all these things. As per division bench. Or whether, Milord, your lordship, despite there being a oral rejection, observation, that we cannot pass any order upon the commission to dispose of it because you have not preferred appeal. Whether I can make any prayer, because it is contrary to the prayer, because they are not recorded, but my duty is to tell the truth. Now, today, Milord, if such application, whether a request can be made to the commission that if such appeal is filed within 48 hours or to 72 hours, the commission will expedite the issue.
That prayer was,
law is there as to within which period.
Law is the provides the law 48 hours in case of an emergency, the commission's emergency. Now, Milord, the commission, suppose, Milord, is facing an insurmountable difficulties in disposing of the appeals, whether in such a situation where the division bench twice, Milord, passed an order, Milord.
No, that is not there in the division
bench's
order, and I will not add anything to it.
But the other issues may be decided.
Please.
But Lord Lordship, kindly record his submission. I have said nothing remains in the writ petition. My Lord has the division bench said.
25th July 2025, passed by the Honorable
case, we cannot.
In MAT 1084/2025, party নামগুলো লিখে দেবেন.
Then, Milord,
filed in court is taken on record. Yes.
No, Milord, sorry, Milord.
Nothing. The petitioner intends to
file an
where is
appeal.
your prayer?
My prayer to the. Just a minute.
And the last order is the continuation of your lordship's order. So earlier order, thereafter this order was
If your
passed.
lordship feels prayer Miller at page Miller, page
There
44,
is no
40
such. There is no such prayer.
sorry, sorry, sorry. Sorry, Miller 31, 31.
No, no.
Sorry, sorry,
15, page 15.
ওটা appeal হয়ে গেছে, sorry, sorry.
Page 15 is
Yes.
your prayer.
Yes, order directing the respondents, recommending the respondent authorities and authenticated to transfer of the petitioner, particularly the represent establishment, recommend the petitioner note sheets relating to the transfer of the petition, all other transfer related documents after giving an opportunity to inspect.
So
So,
you do not have that prayer also.
That was turned down by the division.
That prayer is
So
not
nothing
there.
survives.
Nothing survives. Yes, কি বললাম? না, petitioner intends to হবে না.
Petitioner sharing prayer I cannot make before the commission.
I cannot help here also. Acha, on a perusal of the same, it appears that there is no further issue to be decided in the instant writ petition. Stop the writ petition, stands disposed of.
Give the bless your lordship.
Yes, next.
Page 8 and 11.
Pursuant to lordship's direction, they have now opened the website so that every candidate can apply for EWS certificate.
All right.
That they have acted upon, Milord.
So far the writ petitioner is concerned, we have issued the requisite certificate as per his demand.
All right.
And so far the
There may be others also.
Yes, Milord.
Requiring.
we have opened the portal.
But a direction may be issued, Milord, to dispose of all application within its time period, Milord.
Here I just joined the issue. Lordship sees my lord's last order once.
Yes. Which portion, which paragraph?
If I take your lordship, my lord, my lord, first paragraph. The learned counsel for the state submits that the department will take necessary steps to upgrade the portal for issuance of economically weaker section EWS certificate, irrespective of the fact whether the candidate belongs to the other reserved caste or to the general caste. I just beseech your lordship, my lord, that may not be constitutionally permissible for the state respondent to do.
Challenge it in a writ petition.
To our scheme.
Come.
For whom you are appearing?
It has been brought to the notice of the court.
Or for whom you are appearing?
The state has already upgraded the portal
They
for
have no
issuance of
authority.
EWS certificates.
But they are saying that pursuant to your lordship direction.
Next.
That would be
In view of the above, nothing remains to be decided in the writ petition. The same stands disposed of.
in that event, my lord, at least maybe my lord, permitted to be, my lord, added to the part.
No, no, no. All connected applications stands disposed of.
Grateful. My lord,
Grateful. Then in that case, I'll dismiss your application. What is the use?
They have not added. They have not.
They are not added. Acha, an application for addition. Only one.
Yes, my lord, the 4 EWS candidate, my lord, who are, my lord,
1, 2, 3, 3 দেখতে পাচ্ছি তো একটু দেখবেন তো
one, yes, only one application is there. Can number, I tell you. 4.
This application
Acha.
for opposite the prayer.
The application seeking addition of party is considered and dismissed as the relief sought for by the petitioner has already been allowed by the authority. Yes, next. Other applications, please check. If not disposed, then dispose it off. Grateful, do not.
Your lordship have passed order. My lord, may I submit one thing, my lord? Yes. My lord, today there is some development in the issue.
All right.
My lord, they tried to obtain the EWS certificate on the ground that they are OBC status.
They are not claiming. They claim to be
We are not
general
claiming.
category candidate.
Not now.
Not today.
Today, the Supreme Court have stayed the decision of the High Court. Now the
Not that decision.
they survived and they are now OBC.
They are now OBC. Now this is why, you know, they are just trying to do something.
Listen,
indirectly which they cannot
if
do directly.
the candidate voluntarily says that I am general category and I do not want the benefit of the OBC, you will force him to be an OBC.
It's the policy of the government.
You cannot have a faulty policy.
Because
If your policy is faulty, take steps.
Obtain the double benefit.
By force, you will say that somebody is a scheduled caste candidate and an OBC candidate. What is your
Your lordship is
solution?
right.
Isn't it?
Absolutely, lordship.
But
Cannot be.
Our scheme is a completely full of.
Sir, your scheme is faulty. You need to change it.
Challenge the power scheme. They have not challenged our scheme.
Doesn't matter. He doesn't want to take the benefit of the scheme.
No. His submission will not say.
Call the next matter.
Our scheme.
Next one, I appear for the petitioner, my lord. There is a direction to file a report.
For the respondent, bank, your lordship.
Let's.
My affidavit in opposition, your lordship.
What is the Supreme Court stay it was submitted?
So far OBC is concerned,
I do not know, Mr.
there was a notification issued by the state government following previous direction of the division bench.
Yes.
Now, some category was included, subcaste was included in that list. Now, that was
2011 one.
No.
The recent one.
Recent.
25.
Yes.
Yes.
Now, that notification was challenged
Yes.
in a writ petition.
Right.
And this court, this division bench stayed that notification.
All right.
That was subject matter of challenge before the Supreme Court.
And the Supreme Court
Has stayed
the order of division.
Division.
So that means your
notification survives.
Revives.
Yes, revive.
As of now.
My lord.
Yes. What is this?
To me, there was no secured credit. Therefore, bank has no authority to issue notification under SURFACE Act. That's my challenge.
All right.
Now, last occasion, they have submitted before the court that they have filed a original application before the tribunal and we have appeared, inter-appearance before the tribunal. All these are incorrect.
Incorrect?
Yes. Now, we have not been served with a copy of the application so far as this writ petition is concerned. And I have checked, I have made my affidavit in reply also to their affidavit. Now, I have checked from the SURSAI. These are mandatory provisions. SURSAI also doesn't record my name. Now, apart from that, two dates are very relevant. That's why I have brought in direction of division bench of our High Court, where division bench directed the ombudsman to inquire into the matter, because these fraudulent practices are being done by the banks. And ultimately, ombudsman conducted that inquiry and held the bank responsible.
In this matter?
Not in this matter, in other.
In a separate matter. All right.
Now, similar, why I am saying similar, if you kindly takes up the dates. The date on which the previous loan was. This page 26 is the settlement certificate of the Union Bank.
Of your writ petition?
Of my writ petition.
26. Yes.
This is on 4th September 2019. My mortgage loan was settled with the Union Bank. Therefore, as of 4th September 2019, the deed was lying with the Union Bank. At that time, Andhra Bank did not merge. Kindly see the schedule.
No, details of the charges and security released, page 4th of September.
It was released only on September 4.
Yes.
Therefore, before that 2019, before that date, there was no occasion, there was no scope for pledging this with other bank.
All right.
Now, take the affidavit, page 4. That's why in my reply, I have sought for investigation.
Yes.
Paragraph 3, their assertion, loan was sanctioned on
page 4.
17.
Page
3 of their affidavit. Paragraph 3.
Achha, page 3, paragraph 3, huh?
In the middle,
yes.
12th April 2017, the loan was sanctioned. And it is my specific case that deed is lying with me.
1 minute. Page 3, you say details of the debts and assets.
Yes.
Your lordship, that's my affidavit. They are referring my affidavit in opposition. Your lordship is
Their
the
affidavit.
paper book, your lordship. There's the paper book which has been.
Where is your opposition?
Today I have filed. it.
Yes.
Oh, I see.
I'm sorry.
Yes, page 3.
Page 3, paragraph 3, by way of the present writ petition,
The
The petitioner has
paid.
prayed for the action of the respondent in initiating proceedings under Securitization Act regarding mortgage property as a collateral against a loan sanction on 12th April. Now, next page, same assertion, paragraph 5, clause B.
On 31st March 2017.
The credit
No,
facility.
this release, page 26, the settlement certificate. When was the loan taken?
Loan taken before.
Before means prior to.
Yes. And on this date, my deed was released.
Prior to 17, this date that they are saying?
Yes. This loan is prior. I have no relation. Relation.
12th April 2017. Prior to that, the loan was taken, which was settled on 24th of.
Yes, Millet. Yes.
2014.
That was taken in 2014.
Achha.
I have pleaded in paragraph 2, 3.
Then?
Therefore, Millet, there is no occasion to mortgage this deed with this present bank. Now, Millet, unless it is done by a deposit of title deed, there is no secured credit. Even if, according to me.
What was the collateral security which you took?
Same date. Same date. This gift deed, which was released by this 2019
Union Bank.
The same was the subject matter of guarantee in 2017.
And you took the loan?
No, even the SARSAI I have annexed. Kindly see, that's very important. SARSAI was this notification was issued only to secure that to know to make people know about the mortgage. Page 30, I have annexed the data I have collected from the website.
Yes.
Kindly see page 30. It was a security interest in the middle. Borrower type is individual.
Asset category is immovable.
Yes. Next page, house flat number D137, Bagajuddin Colony. Description of the assets of the immovable property from the previous page. In fact, assets details. Assets ID, assets category, type of assets, description of assets, survey number, plot number, area unit, house flat number, building number, the same date. And in the middle, current view, equitable mortgage, not then satisfaction status.
What is the bank stand in the opposition as to who obtained the loan from the?
No, they say that I am one of the guarantor.
And my name is not even listed.
But if I am a guarantor, my name would be appearing in the SARSAI. Now, kindly see the very page 32, rather page 31 from the bottom. Borrower's sole proprietorship. Before that, my satisfaction status, kindly see, not satisfied. Now, then sole proprietor, loan taken.
What does this mean? Satisfaction status not satisfied?
That is the loan is due to be satisfied. Now, then borrower, sole proprietorship, and then
are the names of the guarantors
is not there. That's my point.
Does it show the name of the guarantors?
Yes, usually.
It shows.
All parties involved in the transaction is shown.
All right.
Charge holder is Andhra Bank. It was
Page 32.
Holder initially it was mortgage.
Yes, Millet.
According to them, it was mortgage with Andhra Bank.
Kindly see, charge holder, Millet. Page 32. Charge holder name, Union Bank, within bracket Andhra Bank.
This was mortgage to a different merger.
Because prior to merger, these were two separate banks, Andhra and Union.
Yeah, that's all right. So right now, the Union Bank.
Therefore, that's why my last question, my submission was, let them produce the original deed. Let them say that
what is the stand in the opposition?
They say that my name is appearing in the agreement and as a guarantor, and I have signed each and every page. And Malad, I have the original.
Do you have the original deed?
This is with me, Malad.
Does the bank have the original deed?
Yes,
original?
Yes, I have.
2 originals.
Then it's a public money there. If 2 originals are there, then they should be brought to criminal case, Your Lordship. This is the original I am having today. I'm submitting. Let both things be submitted.
Let the
Yes,
court
yes.
see 2 originals.
They're both the 2 originals should go. Din. Original din.
We have to ascertain which one is certified or which one is original.
That both needs to be compared.
Is this a gift deed?
Gift deed.
Yours is also a gift
Yes,
deed?
by the state.
By the state?
Yes.
Your Lordship, both
What
needs
is the date at the top?
19 November 88.
Your Lordship, both has to be compared side by side. I think that would be.
Backside will because this is the registered one.
Yeah, everything.
Same thing.
Same. Everything is there. Your Lordship, a criminal case should be lodged against all of them.
Including bank.
No, why bank?
Certainly.
It's a public money
Including
is at
bank.
stake.
Including bank.
Let me see your document once.
Yes.
How the bank is liable for this when the original husband is already lying with the bank?
আলাদা করে রাখুন কোনটা কার ভুলে যাবো তারপর
Why one should be in the right hand side.
Yes, yours is in the right hand side.
The number must be different. Cannot be same.
At the top also EP number same. And what is strange is 17th has been struck off 19th. Here it is also the same thing. The handwriting appears to be the same.
Well, I can understand possibly but there may be. I have to ascertain it's a colony property.
Yes.
An instruction it
There may be some error somewhere, I do not know.
Maybe can I see the deed numbers must be different.
Wait,
Can't be the same because the same register cannot register the same number to different deed.
Absolute same. In fact, the thumb impression, I do not know if somebody checks whether it will be the same or not. The witness is also same.
Only when the concerned registry office can. না অরিজিনাল থাকবে না কিন্তু ওরা তো ইনফর্ম করতে পারে যে কি করে এটা ইস্যু করছে
More or less
I don't know
same.
Your Lordship,
I have not even seen prior to submitting before your Lordship.
My submission is we have the loan documents. We have got the original deed. We have given the loan. Now when now the loan has been made a non-performing asset. Now when we are trying to get hold of our money back, now they are coming before your Lordship.
And NPA was done in 2019.
And your Lordship, another submissions which my learned senior friend has done.
And you know what is strange? See at the back portion, the middle name struck out, same over here also. So it's very difficult for a non-expert to say which one is correct or whether there is any error in issuance of this deed or not. Since you say it's a colony property,
this requires
there may be something.
This requires investigation.
This
cannot
is yours and this is the bank's.
My submission would be kindly keep it with them with a separate envelope with this code and let there be investigation. This should be done, because my name is not appearing in the search. I don't know whether my brothers have procured another deed or not. That I have to take instruction from my client.
Both of you can check.
No, yeah, Your Lordship. I have
Just-
seen almost, but we are not the expert. I don't think. Like,
Yes, same. You will not be able to differentiate.
No, I have seen little bit.
Impossible, absolutely impossible.
The registry office can let.
It's absolutely impossible to differentiate
May I come
between
back with
the
the
two.
instruction, lad?
What instruction will you take?
I have to let talk with my client how this can be done.
He may not have an answer. Because the person in whose favor the deed was there has possibly expired or something. The death certificate is annexed.
Yes, yes.
So the legal heir will not be in a position to ascertain. So no relief can be granted to you over here. Whether police inspection or not, your surface proceeding cannot be stalled.
Surface proceedings.
Now you have got the knowledge of this proceeding before the tribunal that is pending. You take steps over there.
And only difficulties I am facing, like I have brought judgment. That's why I'm glad that if I say the tribunal does not have jurisdiction, how can I submit to that jurisdiction? That's why I have brought a judgment of this honorable court,
yes,
which was passed relying on Supreme Court judgment as well as the Supreme Court judgment, that I cannot submit to that jurisdiction. The other High Court has to decide that.
You have to submit to that jurisdiction to say that the tribunal does not have jurisdiction, and these are the issues that have cropped up.
Yes.
Because prima facie from the document, you cannot say that the tribunal doesn't have jurisdiction.
Yes.
Please come. It is better both of you give a photocopy and write the deeds. Write who's one, who is giving, so that I can keep it on records and I can dispose it off. Right.
We'll supply it, right? In the course of the day, we'll supply.
Yes, yes, within the course of the day.
We'll supply.
Yes, yes. Keep it, I'll dispose it off. I am not entering into it because I am not in a position to enter. And why I am not entered, that I have to record that on a perusal of the deeds. Achha.
Can I keep it open for the tribunal?
All issues open. The learned advocate for the petitioner and the learned advocate representing the Union Bank has produced before this court copy of the title deed in respect of the property which is allegedly mortgaged to the bank. Stuff.
Same handwriting.
On a perusal of the same with the bare eyes, comma, it is absolutely impossible to differentiate in between the two deeds produced in court today. Stop. Copy of the deeds are retained with the records. Stop. As the bank has taken steps in terms of the Surface Act and claims to have granted the loan by keeping the title deed of the property in mortgage, comma, the bank will proceed with the application before the Debts Recovery Tribunal. Stop. Paragraph. Learned advocate for the petitioner has been made aware of the original proceeding, made aware of the details of the original proceeding, where the petitioner has been impleaded as party. Stop. It will be open for the petitioner to enter appearance and make all necessary submission in his defense. Stop. The writ petition stands disposed of.
There is some difference.
I am not entering into anything. You make everything clear over there. To give. Yes, yes, I'll give. Petitioner একটা reply না exception কি দিয়েছে একটু দেখে রেখে দেবেন। Plus, হ্যাঁ নিশ্চয়ই লিখে থাকবে। Do not forget to give that deed.
In the course of the day.
In the course of the day.
Yes.
Let me also have a copy of his deed so that I can.
That's.
You can look at your deed and think it's his.
Yes, yes, absolutely.
It's absolutely impossible to differentiate. Next. Yes.
99, in the last occasion, there was a direction upon us to add my husband as a party respondent and cause a service. The address available to us, we had incorporated. But it is found that address is not found. So that is the police who can identify, because the left me in 2019. We have with their he divorced me.
Respondent number 4 has entered appearance. The husband.
I'm the home, where the
Oh, you are the home. You must be knowing where the husband of the petitioner resides. Some address must be there with you.
This is that matter when
trial court, the husband is appearing. He has filed a proceeding.
for custody.
Yes. Then you get the address from there.
From the e-court detail we have got. Copy has yet been served. He has
From e-court, you've got the address?
No, e-court, from e-court I can get the detail number.
Order sheets. Where is the child now with you? And
in terms of
all right.
order, that has been done.
All right.
I have only thing, I have instructions, I have the phone number of the father only.
All right.
Because once he has come to visit the child.
Yes, yes.
So we can give the phone number because I do not know the
No, but then it will not be proper for the petitioner to call. You can obtain, you have the phone number, you can obtain the address and pass it on to the petitioner so that copy can be sent. Right. But what is to be done now? The proceeding is pending over there. Why will the read court enter?
Not only that, my lord, I have the CWC has sent me one letter, my lord. It has been addressed. That child has written that letter.
Yes, last occasion you have handed it over.
He doesn't want to
stay over there with the mother.
No, this is the letter, my lord.
If the letter is here, you've handed it over. Oh, latest.
Not for the custody. We have the right.
I am no one, because I am interested in the welfare as fallen from his lordship.
Doing in absolutely contrary to the law. They are not even allowing me to sit with them.
No, you should not. It is good that you are not there.
An application, they are not even entertaining it.
It is better that they do not entertain.
Yes.
You approach the court and get an order. The child is in a protective care.
Without the order, without anything.
Yes, yes. CWC can do it if the child is in need of protection.
Your lordship kindly appreciate. They cannot do it on his own. There is a procedure that they will have to.
On 3 occasions,
there is a procedure that they will have to comply with.
Listen,
this is not
the mother has gone and visited the child. The mother has gone and visited the child.
I have written,
3 occasions.
On once, they allowed me. Thereafter, they are not entertaining my application. They are not giving any copy.
Everything has been stated on the last occasion. Thereafter, I filed the report and lordship has passed this order.
Let them supply the document. They are under obligation to.
Which document?
What is the complaint? My application, they are not entertaining. They are not allowing me. They are not talking to me. They are not sitting with me. My husband, who has left me 10 years back, he has submitted a document. On the basis of that document, my child has been taken away, and I'm the worst.
No, child is not taken away.
Assume I'm the worst mother. Police had taken my child in the evening.
No.
And I am not allowed to even sit with them. This is their conduct.
Your child doesn't want to stay with you.
Very well.
There is a communication.
Let us assume for the time being that child do not want to sit with me. But that is not the procedure. Anyone comes and files an application and they will take away my child. And if that is the rule, your lordship kindly set up the rule. Let the act not be there. It is their obligation to bring a SIR, social investigation report, within 15 days. It is their obligation to pass an order within 1 month. It is their obligation to upload all documents in the website. They are not doing anything. They are not allowing me. Assume me to be a worst mother in the world.
Civil court is there. He can approach to the civil court. All the remedies are there.
Even I don't know the case number. CWC is absolutely working in collusion with my husband. That is my allegation. Allow me to confront them.
a report by the chairperson.
And that this contact is that is
Child
for
Welfare
this
Committee,
contact I have
Hooghly.
come before Lordship.
Child Welfare Committee, Hooghly, dated 25th of July 2025, has been filed by the learned advocate representing the committee.
And my lord, we are not here. Your Lordship kindly sees the prayer. We are not here for the custody. We have, my lord, prayed. Allow me to confront with you. Give.
Acha, the CWC may be contemplating of handing over custody of the child to his father. Stop paragraph. It has been brought to the paragraph the communication by the child to the CWC Hooghly dated 17th July 2025 has been placed before this court by the learned advocate representing the state. Stop. It appears that the child is attending school. Stop. The father of the child has filed a proceeding before the learned civil court seeking custody of the child. And the next date for hearing is fixed on 29th August 2025. What is the case number? Custody case number? The committee is directed not to hand over custody of the child to either of the parties at this stage. The custody of the child shall be decided by the competent forum where the proceeding is currently pending. Stop. The committee shall ensure that the child is taken care of properly and he attends school on regular basis.
Grateful.
Stop. The do you have the number?
Contact number of the father.
Not the case number. Acha. The father of the child, that is the husband of the petitioner, could not be served as the petitioner claims that she does not have the current address. Stop. Learned advocate representing the committee is directed to forward the address of the father of the child to the learned advocate representing the petitioner for ensuring service of the writ petition upon him. Stop. Release the matter for further consideration on 18th August.
May I get the copy of the observation of CDL so that I can even approach before the district forum for
All right.
I am not
Give a copy so that she can
report
take.
of the state.
Yes, this is what I have given to his lordship.
This is only one page.
No,
Yes, my lord.
CWC.
CWC one page.
One page document I have given to.
This is the document. Chairperson CWC. এই দুটো রেকর্ডে থাকবে।
Lordship দেখে নিয়েছি।
Yes.
I have handed over the document.
Yes, yes.
The SI and social investigation report that we are under they are under compulsion to hand it over to.
Yes, they will hand over as and when the investigation is done. Yes, next.
Item number 30.
In procedural lordship, last direction, Mala. I've taken the instruction, I've been instructed to appear on behalf of the respondent number 2 as well.
Yes. What is your instruction?
Well, not the material instruction I have received so far. So, if your lordship kindly allow me to come up with a short affidavit with
Again affidavit, what is
because
the use?
well, only day before yesterday, this is the mail that I am handing up for the lordship.
The mail will not
It's
do
a
instruction from the end of the
so
respondent
why
number
it was
2.
got stuck, that is what I want to represent by of an affidavit for lordship kindly.
Affidavit, bring a report from them.
In the form of an affidavit only. That is the report. Kindly pass a direction. This is the 4 weeks time has been sought for lordship kindly. Nothing is
I will not,
client.
I will not
The
give you
banking
more than
operation
2
is not
days.
kindly what is in Delhi.
No.
It
Are
took a lot of
you able
effort
to
for me
operate
to
the bank account? No.
The
he's
banking
not.
operation is not it is functional.
Not frozen. Not frozen.
Lost. I understand. The petitioner is losing interest.
We all are sympathetic on that aspect.
But either you pay the money for the interest. It
Kindly,
cannot be done.
at
Please
least
come.
2-3 weeks time be given.
Certainly no. The respondent number 2 is directed to file a very short report disclosing the formalities required to be complied by the petitioner for effecting necessary changes in the Aadhaar card. You want change in the Aadhaar card?
Yes. Correction in the Aadhaar card not based on birth certificate.
Based on the birth certificate of the petitioner. Released next Tuesday, 5th of August.
Next kindly not next Tuesday.
No. The petitioner is losing interest.
2 weeks be given. It took a lot of effort for me to contact. Kindly 2 weeks be given.
You have taken effort. Now they have contacted. They will.
I'll not be there in this week. Kindly 2 weeks be given.
Let them
at
go.
least.
Court's order, they will.
I will. I have already.
11th of August.
11th of August. Very well.
Next.
Wait for you.
My lord, item number 31. My lord, Kumar Jyoti Tiwari is appearing for the Union of India. I'm praying for not today, my lord.
Why?
When he is unable to come to the court today, my lord, due to personal difficulty, my lord.
He could have joined online. What is the issue?
Issue is that correction of the date of birth on the passport. All the academic qualification has a one date of birth.
Only not today? Yes, my lord.
Only not today. Yes, next.
If you retain the same position also.
My lord, this is my
T2, I beg to appear on behalf of the private respondent.
This matter, my lord, I am led by Mr. Vikash Ranjan Bhattacharya, my lord. He's in Delhi, my lord. He has requested to pay for time, my lord. Can it be?
What is the issue?
My lord, petitioner, my lord, alleged husband is the petitioner before your lordship, my lord, basically challenge the marriage certificate, my lord.
In a writ petition, they are seeking nullity of marriage.
No, my lord. Nullity of marriage.
Is their prayer, lordship?
Nullity of marriage, my lord. Before the trial court, my lord, I have made a representation. I have made a suit, my lord, filed a suit in the trial court.
1 minute. A is issuance of writ of mandamus quashing the marriage certificate.
And kindly sees the next prayer.
Issuance to cancel and remove the illegal marriage registration from official records.
But what I am praying, my lord,
Restraining from misusing the invalid marriage certificate. Invalid. You take a decision that this is invalid.
They have already.
1 minute. You are the husband.
my lord.
Yes. What?
But I made a representation, my lord, before the marriage registrar, my lord. The marriage registrar, my lord, said, my lord, that
for private respondents.
if your lordships kindly takes up my representation, which is at page, my lord, 63, my lord.
Yes.
My lord, I have said, my lord, the marriage registrar don't have that jurisdiction, my lord. That is the point, my lord. The marriage registrar said, my lord, page 65, that since the matter is pending before the trial court, my lord, it is sub judice, my lord. So it cannot be taken up, my lord. Your lordship
What
knows, my
matter is pending? TS?
Suit, my lord.
Suit regarding?
Suit regarding declaration, my lord, for nullity of the marriage, my lord. Apni bolun tahle?
Suit declaring nullity of marriage, and here you've come for quashing.
Your
Parallel
lordship knows,
proceeding.
my lord, there are two parts, my lord. In Hindu Marriage Act, my lord, after solemnization of marriage, my lord, the registrations take place, my lord. So, my lord, in the trial court, my lord, the solemnization of marriage part is under challenge, my lord. And it's a consequential that if the marriage goes, my lord, the certificate also goes, my lord. Here, my lord, in the writ petition, we have specifically challenging the jurisdiction of the marriage register
In
for
registering the
registrations of
marriage.
marriage, my lord.
Yes.
What we have short for, my lord, that the police stations, Thakurpukur, my lord, it has been written, my lord, Thakurpukur is the jurisdiction of the marriage registrar, and the bridegroom, my lord, is staying in Horidevpur, my lord. So they don't have the jurisdiction, my lord. That is the point, my lord. So, my lord,
Where does the bride stay?
My lord, Horidevpur, my lord.
And the groom stays both Horidevpur?
No, my lord. The Jagodal, my lord. Bridegroom stays in Jagodal area, my lord, in North 24 Parganas, and the bride stays in Horidevpur, my lord.
All right. Yes.
And marriage register have, and the marriage register don't have that jurisdiction, my lord. Page 38. 171, my lord. Here, my lord, Thakurpukur, Behala, Taratola, Alipur. This is the jurisdiction of Malabhanjo Chaudhuri, the marriage registrar. Page 38, 171, point number.
Show me the provision of law which permits the marriage registrar to cancel a certificate.
Marriage registrar? Huh? No. My lord, kindly permit me to, my lord, file a supplementary affidavit, my lord, where I have annexed the.
We have not
Worship, we have not received.
No, what you annexed in the supplementary?
The marriage registrations rules, everything, my lord.
Rules by way of a supplementary. Why? The rules are already there.
But this is there, my lord. Have
But we haven't received any copy.
The copy may be handed over to her.
1 minute.
Copy has been given, my lord.
Supplementary
No
affidavit.
supplementary, only read.
Only the writ petition has been served.
No supplementary copy.
Lordship, a proceeding under section 125 CRPC was initiated against the husband. Lordship, in my respectful submission, these are all measures to circumvent those proceedings. And Lordship kindly sees this is a representation. This petitioner had preferred another writ application that was taken up, but that was rather disposed of by my Lord Justice Tirthankar Ghosh, where they had prayed for, rather they had alleged police inaction. A police case was registered. Their grievance was that certain penal sections were not inserted to the liking of. Now, Lordship kindly sees in that representation, it to Devan kindly.
What is
kindly sees the second paragraph that was part of that earlier writ application. I can give the number also, WPA 12752. In the second paragraph, they had specifically pleaded that we have already sought for declaration of that marriage as null and void. They've even mentioned that title suit number. And this is the status of that proceeding. The next date is in the month of November.
And one thing, in the plaint that has been filed, has any ground or anything mentioned with regard to the registration that the registrar
the copy of the plaint, I have only been instructed with this writ application. I don't have a copy of the plaint as of now.
Is anything mentioned with regard to the registration?
Then I have to come back with the copy of the plaint.
Anyway, where is the provision?
In my respectful submission, this prayer is not tenable.
All right.
The writ court.
Where is the prayer for? Where is the provision for setting aside the marriage?
No, not setting aside of marriage, but certificate.
Yes, setting aside of certificate, the cancellation of certificate. Where is the provision? Under which provision? You don't know it.
ডিসপোজ অফ করে দিয়েছে এখানে এই নাম্বারটা নিয়ে নিন, এটার অর্ডারটা পেয়ে যাবেন।
Please come. The petitioner prays for setting aside / cancelling
What
the marriage registration certificate issued by the marriage registrar on the ground that the said registrar did not have the jurisdiction to register the marriage. Stop. Paragraph. Supplementary affidavit filed by the petitioner annexing copy of the West Bengal Hindu Marriage Registration Rules, 2010 is taken on record. Stop. The learned advocate for the petitioner is unable to show any provision which permits the registrar to cancel the certificate once the same has been issued. Stop. Paragraph. It appears that a civil suit seeking annulment of the marriage is pending consideration before the learned civil court. Stop. The
Lord, may I indicate Rule 14, my lord?
Which page is it?
17, my lord.
Yes. What does it say?
Of disposal of objection and appeal. If
you have not filed any objection, and this is neither an appeal. You are completely mistaken. Stop. As the marriage itself is under challenge before the competent court, accordingly, no useful purpose will be served by keeping the writ petition pending. Stop. Cancellation of the marriage certificate will be a consequential step in the event the marriage is set aside / annulled by the court. Stop. In view of the above, the writ petition fails and is hereby dismissed. Stop. It will be open for the petitioner to raise all issues before the learned court where the title suit is pending.
Grateful, ma'am.
Grateful. A report filed by Yes, yes.
Hello, may I
take this report? Yes. Report
the affidavit of service filed with
Yes, yes. Affidavit of service taken on record. Next.
Along with supplementary affidavit.
Yes, yes. Give me one supplementary copy now.
স্ট্যাটাসের একটা দিয়েছিল
Supplementary copy.
My lord, may I take back this case? Deeply obliged.
Record, my lord. Grateful, man.
But I'm led by Mr. Bhattacharya, but he's not here. Very innocuous prayer, my lord. Page 84 is my representation. To the authorities, my lord, we are small shop owners, my lord. My lord, there is a rail overbridge will be constructed at Shaithia, my lord. We may be affected, my lord. We have made a representation, let them consider it.
Before whom?
To the my lord, railway authorities, my lord.
Who is
And as well as
appearing?
municipal.
My lord, I appear for the for the state respondent.
The nodal officer through which the railway authorities will act?
Yes, my lord, but the plan has been done by the railway authorities. My lord, the entire plan has been approved by the authorities according to the parameters. Now, my lord, the prayer of the writ petitioner kindly consider. They want that this plan should be modified.
No, I am
Yes,
not praying that.
prayer.
That is my prayer in the representation. Let them consider. I do not know, my lord, because there was a notice issued by the authority to purchase the land.
Yes.
Ultimately, they did not proceed.
No.
My specific allegation in the representation that there was a plan that has been modified.
No.
Previously, we are not being affected. Now, my lord, there is a chance of we are apprehending reasonably.
Where is your representation?
My lord, at page 83.
And
84.
who is the authority?
My lord, I have sent to the railway authorities as well as my lord, the local bodies, my lord, because they are acting.
But then the project is not of the local bodies.
No.
So the local body will not be able to consider, right? It has to be the railway.
By the railway authority.
The railway, the affidavit of service. Who is appearing?
Complete হয়েছে তো?
My lord, he has made
Yes, my lord.
respondent number 2A, senior divisional engineer, coordination Eastern Railway.
The service is complete, my lord.
Please come. The petitioner prays for consideration of the representation that is pending consideration at the end of the senior divisional engineer within bracket coordination, Eastern Railway, Howrah Division. Stop. Next. The petitioner, now the matter relates to
proposed construction of rail overbridge at Shaithia.
A proposed construction of a railway bridge.
Rail overbridge.
Railway overbridge at Shaithia. Stop. Next. Learned advocate representing the state respondents submits that the project has been verified. What do you say?
The plan has been approved by the railway authorities according to the parameters.
That the plan has been approved by the railway authorities as per the prescribed parameters.
My lord.
Stop. Next. The railway authority is not represented. Stop. Affidavit of service filed in court is taken on record. Stop. In the absence of any representation from the railways, it is not possible for the court to decide the issue conclusively. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the senior divisional engineer within bracket coordination, Eastern Railway, Howrah Division, the respondent number 2A, to consider and dispose of the representation filed by the petitioners in accordance with law at the earliest, but positively within a period of 6 weeks from the date of communication of this order. Stop. An opportunity of hearing shall be granted to one of the representative of the petitioners. Stop. A prior notice of hearing shall be provided to the petitioners. Stop. Reasoned order shall be passed and communicated to the petitioners immediately thereafter. Learned advocate for the petitioners is directed to forward a copy of the representation along with all other supporting documents to the aforesaid respondent at the time of communicating the order of the court. Stop. It is made clear that this court has not entered into the merits of the claim of the petitioners, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the representation.
Only one line should be added, that in presence of other concerned authorities, because BLRO is the concerned authority.
All right. যেখানে বললাম না যে hearing to be given to the petitioner and all other necessary parties.
Necessary authorities.
Authorities.
Great.
Very well. Yes, next.
34, my lord, I beg to appear for the treatment.
I appeal for a state respondent, lordship.
My lord, only state respondent is there. This is my affidavit of service.
What is it?
My lord, my issue is that a marriage register certificate was prepared by my lord suppressing material facts as well as playing fraud. Now, my lord, subsequently, I approached the civil court. Title suit filed with a prayer for declaring that the marriage certificate issued on basis of a fraud is null and void. I obtained a decree. I communicated the order to the registrar that you please remove the marriage certificate from the portal. Now, my lord, what marriage certificate deems it fit, kindly take, my lord, page 40. He wrote a letter to the learned judge saying that...
Judge?
Yes, my lord, subject to correction.
Through bench clerk.
Yes.
Page 40. My lord, kindly see the from and to. Then he indicated that there are certain mistakes in the order, which subsequently corrected. But my lord, last but one paragraph. Hence, it is not clear to the office whether marriage certificate number so-and-so dated so-and-so of so-and-so need to be cancelled from the office record or not. My lord, kindly, if your lordship's pleasure, kindly come to page 30.
Well, let me understand. It is a certified copy of the order number 1 and the order number. There is a mismatch in the name of the petitioner.
My lord, subsequently, I corrected and wrote a letter including the orders. My lord, kindly take page 30.
30?
Page 30 of my writ petition. The order passed by the learned civil judge. And kindly take note of the date. The operative part is there.
Date. Where is the date?
Well, it's mentioned in the order that the suit be same is hereby decreed in favor of the plaintiff
as against the defendant in ex parte manner without any amount of cost. It is hereby declared that the plaintiff is not the legally married wife of the defendant, and the marriage registration certificate as got described in the plain dated so and so. My lord, I have annexed the registration certificate as well, that your lordship will find out from page 13.
Page 13.
Page 13 of my writ petition.
Yes.
Kindly see, my lord, date.
No, show me that there is a mismatch.
No, then my lord, it's not there, because subsequently, my lord, kindly see, if that be so, I again communicated page 42 in my representation. Because whatever they are saying that mismatch, there is no mismatch. I have also annexed the first page of the plaint, my lord. Kindly take, my lord.
Mopriti Ghosh and Showman Ghosh.
Yes. Page 15 is the first page of the plaint.
Mismatch in the name of the petitioner. Who is the petitioner?
My lord, Mopriti Ghosh.
Mopriti Ghosh.
Lordship, I received your instruction, Lordship, in this
Yes,
respect. There is two grounds they have mentioned. One is that marriage certificate number is not mentioned in the order, Lordship. Number
Not
one.
mentioned in the order.
The order, Lordship. And secondly, Lordship, that there is no provision in the Special Marriage Act 1954 and the West Bengal Special Marriage Rules 2210 regarding cancellation of a marriage, Lordship.
The court has cancelled it. But he will remove it only from the portal.
Portal, but the number
No,
of
no,
the certificate,
but
the
plaint,
Lordship,
copy of the plaint is there.
Lordship, but the number is not mentioned in the, that's why there is a confusion, nothing else, Lordship. If Lordship,
Advise your client properly.
Lordship.
Otherwise, serious consequences
Lordship.
going to follow. There is a court's order and he is saying that he doesn't have the provision to cancel the marriage. Who is he to cancel? The court has cancelled it already.
I
Please
did
come.
not even ask for cancellation. I just said you remove that registration from the portal.
The marriage of the petitioner stood nullified by the
judgment and decree dated.
There is only confusion to understanding the order, Lordship, nothing else.
April 2024. Page 23 is the, my lord, judgment, and decree, your lordship will find out from page 32.
By judgment dated 16th April 2024 in other suit number, page 23, 115 by 2021, party num, legal 11. And decree is?
My lord, page 32. And in page 33 specifically stated the marriage certificate date. I don't know, my lord, where from he is.
But there is only lots of confusion to understand the correct.
And the decree, date of the decree.
Page 33, first line. The suit coming on.
The date of the decree should be there also.
It is on the
16th April 2024, same day.
Yes, ma'am.
Judgment and decree করে দেবেন একই দিন আছে 16th April 2024 ঠিক আছে the marriage certificate of the petitioner is annexed at page 13 of the writ petition. Stop. The learned trial court
We can even ask for cancellation.
Not trial court now. The petitioner has prayed before the marriage registrar to remove the certificate from the portal maintained by the registrar. Stop. The Registrar General of Marriage has by a communication dated 6th November 2024 has intimated the learned civil judge within bracket junior division that the marriage certificate number has not been mentioned in the order date and there is a mismatch in the name of the petitioner. Stop. Paragraph.
May I please that report, your lordship?
Please do. The copy of the
page 42
marriage certificate and the final order both are annexed in the writ petition. Stop. It does not appear that there is any mismatch. Stop. The certificate which is required to be brought down from the portal is dated 1st June 2021. Stop. The authority is directed to, not the authority, the marriage registrar is directed to immediately take off the marriage certificate from the portal. Stop. Release the matter for recording compliance on 1st August, this Friday.
Give me some more time, Lordship.
Friday, my lord, I have some difficulty.
You have difficulty? 5th of August.
Lordship, 10 days, at least 10 days, Lordship. I do not know what is the process.
No process, just remove it.
Lordship.
5th of August.
Grateful. My lord, I have submitted affidavit of service.
Affidavit of service.
Mine was item number 100. It will be taken up clearly once again tomorrow, my lord.
I do not know. You have to follow the list. You have to follow the list.
Because of my illness, I disturbed you, lord.
No. Item 100, you say?
My lord, I need item number 100.
No, it will not be taken up, I can tell you.
My lord.
It will not be taken up. These matters will be taken up after the combined list matters are taken up.
In the month of August?
Yes.
My lord, item number 8, my lord. My lord, directed that the officers of the respondent.
Yes, Mr. Dey. Are they present?
Yes, she's on that.
In that event, my lord, I can come up for next year of combined list, my lord.
You are not required to come. You can join online also. The court permits online appearances. So please follow the list from home and then join. Dhanya, DHANYA.
Yes, ma'am.
Madam, the court wants to know, firstly, what is your designation?
I'm Associate Vice President.
All right. So you must be knowing what the fact of the matter is?
Yes, ma'am.
All right. The petitioner deposited certain money with the insurance company and thereafter could not pay the premium possibly. And now you all have clubbed this into a separate insurance account where with a 5-year lock-in period, and it is ending on the 29th of December 2026. The query of the petitioner is, on 29th December 2026, will he be entitled to withdraw the principal and the interest in one go?
So, ma'am, I would like to brief this case. So this is a retire smart, this is a pension policy, ma'am. So he paid only 2 lakhs premium. He was supposed to pay 5 years, but he paid only one initial premium. Mrs. Ruma Gupta, she paid only one initial premium. So due to which this is a terms and conditions of the policy itself. It says that in case of discontinuance of this premium, this policy will move into a discontinuance fund. This is as per the terms and conditions of the policy only. So this is inbuilt in the policy itself. So at the end, so when you say this discontinuance policy, so the policy, it goes to the discontinuance policy fund. So as per the terms and conditions of this policy, there is a lock-in period of 5 years starting from the date of inception of the policy. So during the lock-in period of this policy, you cannot take any payout under the policy. This is as per the IIDA regulation, this policy is built in. So after that, at the end of the lock-in period, customer has got basically 2 options. Either he can take out of that fund value at the end of the lock-in period, he can either take annuity policy, which is a pension
policy. The petitioner is not inclined to continue with any policy. She wants her money back. Will it be possible?
So,
the principal and the interest.
So what happened? It won't be per se principal plus interest. It will be the discontinuance fund value, ma'am. So this 2 lakh rupee minus some charges has already got credited into the discontinuance policy fund in the year 2022. So as on today, the value is around 2.20 lakh rupees as on today. So as the policy again progresses at the end of 2026, this amount will again go up. It will never come down because this amount is Again, this amount is invested in the fixed deposit or in the debt fund only. So as per the terms and conditions, she is not eligible for full refund, ma'am. Actually, as per the terms and conditions, there is no eligibility of a full refund, but there is an IIDA regulation which stipulates there that with the given fund value, if that annuity is not becoming 1,000 rupees per month, insurer is supposed to refund this money. So only at the end,
whatever the petitioner is entitled to, please refund, and she is not interested to purchase any further annuity or anything, and she wants her money back. All right.
Okay.
Please come.
So it is at the end of the lock-in period, ma'am, that
Yes,
pay
yes.
amount.
Yes, at the end of the lock-in period.
Yes. What vacancy? Oh, annuity there. Interest also part also is there.
Whatever is
Entitled.
due to you
Yes.
will be given back.
Yes.
Acha. Please record her designation. Such and such person is present online. Stuff. It has been submitted that the petitioner would be entitled to take refund of the amount that is credited in her account along with interest on 29th December 2026. Stuff paragraph. The
Ma'am, again, discontinuance fund value, it would be
discontinuance fund value. Amount in the discontinuance fund value. Acha. The 29th of December 2026. The petitioner is agreeable to the same stuff. In view of the above, the writ petition stands disposed of. On expiry of the lock-in period, the petitioner shall be intimated the formalities to be complied with for obtaining withdrawal of the amount disposed.
Including interest also. That part you have mentioned.
Yes, I have mentioned. Whatever interest, your interest will accrue.
Yes.
Is it the interest they will give you back?
Yes.
All right.